ಹಲೋ.
ಹಾ ಕೊಟ್ಬಿಡಪ್ಪ. ಅಲ್ಲ ಕುತ್ಕೊಳ್ಳಿ, ಇಲ್ಲೇ ಕುತ್ಕೊಳ್ಳೋರಂತೆ ಸೀಟ್.
ಓಕೆ, ಮಾಡಿ ಮಾಡಿ.
ಕೊಟ್ಟಿದ್ಯಪ್ಪ ಲೈವ್? List number 1 for dismissal, serial number 1, N. Suresha for petitioner, MP Geeta Devi.
I appear for the respondent number 2, my lord. Lord, in this matter, the petitioner is claiming that he had purchased the property in 1982.
No, that they are not interested in prosecuting, madam.
Very well, my lord. The last couple of occasions also they were not present, my lord.
Yes,
Serial number 1, N. Suresha for petitioner,
then the matter was called on 23/5/2023.
Respond number 2.
For the petitioner. Government advocate for servant
Dismissal.
directed to post this matter on 30th/5/2023. On 30th/5/2023, when the matter is called, none appears. Again directed to, again matter was posted on 9/1/2024. There was no representation on behalf of the petitioner. The matter was posted on 4/6/2024. The matter was called in the morning session, in the afternoon session, none appeared for the petitioner. Except learned government advocate. Directed to release this on 5/6/2024 at the top of the list for orders. Even on 5/6/2024, none appear for the petitioner. Directed to release this matter today or dismiss under the caption dismissal at the top of the list. Even today, when the matter is called, none appear for the petitioner. It appears that petitioner is not interested in prosecuting the case. Dismissed from the court.
for admission, serial number 2, Shekhar LS for petitioner, BN Anantanarayana.
CP pertains to permission seeking to prosecute RFA as an indigent person. Mr. Chindap Gowda, who is appearing for respondent number 2, is contesting. He called up in the morning and sought for time for a week's accommodation. Personal inconvenience.
For respondent number 2, release this matter to 2 weeks. Yes.
Serial number 3, Rupa KR for petitioner, N. JR Jagdish. Serial number 3,
Appear, release this matter next week.
serial number 4, Chetan AC for petitioner. Serial number 4, serial number 5, G. Balakrishna Shastri for petitioner, Rakshit R.
Lords, in this case, I am appearing for respondent, my lords. My lords, kindly, the matter may be referred to mediation. My lords. There are chances of settlement.
We have no instructions regarding that, my lord.
Now that his wife petition,
Yes,
Yes, my lord.
what is the case filed by that husband?
restitution.
Capital right.
Yes, my lords.
Then we can.
My lord, the problem is, currently the wife is residing at a village near Chalkere. And it's at a distance of 300 kilometers from Kolar, my lord. And
But will arrange in the Chitraduರ್ಗ district.
My lord, he's a doctor. Bengaluralli arrange ಮಾಡಿದ್ರೆ.
ಮತ್ತೆ ಅವ್ರ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
That's one day may be fixed any Saturday.
Yes, Saturday.
my lord,
Go
the
to
problem is
Chitraduರ್ಗ
if she has to travel from her village to any place, Bangalore or Kolar, she has to leave the previous
No,
day.
that will refer to the Chitraduರ್ಗ Mediation Center district.
Yes, my lord.
There he can go there one day, we'll fix on
Oh.
Saturday. If we try, if it is possible, settle it. What is that why petitioner doing?
She's not
She's
unemployed.
an housewife,
Yes.
he's a doctor.
He's a doctor, my lords.
At the request of the parties, refer this matter to Chitradurga District Court Mediation Center. Parties are directed to be appear on 22nd. 22nd this. On 22nd June. Yes.
Serial number 6, Mahesh Kiran Shetty for petitioner, Onkara KB.
The wife's petition seeking transfer of the application for divorce that is filed before, my lord, the court in Jamakandi. So it is filed, husband has filed it in Bangalore. The wife is resident of Jamakandi. And she has also filed an application under 125 of CRPC, which is pending adjudication there.
Where?
In Jamakandi, in MC.
He is appearing in that case.
He is appearing in that case and that is going on. So
Which is that 1546 for divorce. Husband has filed for divorce.
divorce.
No, who is your opponent?
So Omkar appears.
Where is he? Last occasion he was there.
He was there. In fact, it was referred to mediation as well. In
What
the
has
mediation, it's settled agli. In fact, my lord, they have been prolonging. This is 2022 matter. Settlement ಆಗುತ್ತೆ ಅಂತೇಳಿ ಹೇಳಿ.
What has happened to that mediation? What is that suggestion made by that
My
party?
lord, what they suggest is that they will settle the matter. One time they say that, my lord, they will take her back. But we later on come to know that, my lord, he is already married during pendency. Before dissolution of the marriage, he is already married. And one time he said that, my lord, he will hand over one site in the name of the child. And that site also, my lord, it is a litigated site which cannot be accepted. For that reason, my lord, since that 125 CRPC petition is pending there, my lord, and
Once we will pass off.
please, ma'am.
Serial number 7, Mallegowda HP for petitioner, BS Basavaraju.
The respondent in this case, 2016 matter, my lords. Say already divorce has been granted by the family court. Later they filed an appeal before the honorable court and matter has been remanded. Now they have filed this transfer petition from Bangalore to Tumkur.
Bangalore to Tumkur.
Tiptur, sir.
Now that you have filed a petition.
I have filed the divorce petition.
That time he was in Tumkur or she was in Tumkur?
He is in Tiptur only.
Tumkur only. She
Tiptur,
came and prosecuted the case.
No, my lord, expert order has been passed. Earlier she appeared and after that she not appeared before the
On
court.
that basis, it has been set aside and
Yes,
sent
yes,
it back.
yes, ma'am.
Again, same thing will happen. Why can't
Thank
you
you.
transfer it to that Tumkur? Mister? You can go and prosecute there.
It may refer to mediation, my lords. Already,
Mediation ಆಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ sir, ಆಗಿಲ್ಲ.
Mediation ಆಗುತ್ತಾ?
We'll try, we'll try.
Yes, at the request of Tumkur.
Bangalore only, we'll pay.
Bangalore ಬರ್ತಾರ ಎಲ್ಲಿ ನಿಮ್ colleague?
Last occasion also absent.
Last occasion also he has not come. None appear for the petitioner, respondent, Marvin, and everything from the Constitution. I will just urgent, I will not extend the interim.
Yes, yes.
None appear for the petitioner. Leave this matter of 2 weeks.
Serial number 8, Rajendra S for petitioner,
Petitioner, my lord. This petition, my lord, the petitioner sought for transfer of MC petition filed by the husband in Mysore to Bangalore.
Where he has filed Mysore. What is that
Mysore.
husband doing?
My lord, he is graduate and working in ABC consultant in Bangalore.
Oh,
Husband
he is working here.
here only and residing here only. My lord, the
has
notice
present
is
here.
served, though notice is served unrepresented
He is not doing-
for several dates. My lord, the wife, my lord, filed MC petition for divorce on the ground of cruelty before the family court Bangalore. Here, my lord, the husband appeared and the matter is now,
Which is your MC petition, Mister?
my lord, MC number 5470 of 2022.
54.
70 of 2022.
That is FR number, Mister. 5459 of 2022.
Please,
That is filed by that wife.
wife before family court Bangalore.
Bangalore, there he is appearing.
Appearing, mediation ಗೆ ಹೋಯ್ತು, mediation failed.
What is the case now? Husband is filed
Husband is for restitution of conjugal rights.
in Mysore.
Mysore.
Which is the case?
My lord, MC number 846/22.
Tell the copy.
Okay,
Produce that.
please, annexure D.
Next year.
D.
So learned counsel appearing for petitioner wife has contended that.
ಬಟ್ ಡೇಟ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಅವರು ಆಗ್ಲಿ ನಾವು ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಪೇರ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ
ಯಾರು?
ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್. ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಲಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Contended that petitioner is residing in Bangalore with whom, Mr.
ಪೇರೆಂಟ್ಸ್ ವಿತ್ ಪೇರೆಂಟ್ಸ್ ಔಟ್ ನಾಗರಬಾವಿ.
And she has filed MC number 5459 of 2022, Principal Judge, Family Court, Bangalore. In that case, respondent husband is appearing through his counsel and prosecuting the case just to harass the petitioner, and he is also a resident of Bangalore. Just to harass the petitioner, he has filed MC number.
MC number 846/22.
There.
Annexure.
MC number 846 of 2022. Court Mysore for restitution of conjugal right. It is inconvenience for a petitioner to travel from Bangalore to Mysore for prosecuting the case. Hence he sought for allowing that petition. Respondent served unrepresented. Heard the learned counsel for the petitioner. Petitioner is legally wedded wife of respondent. Their marriage was solemnized
11/7/2000.
7/20/21. After that matrimonial dispute, petitioner started living with her parents in Bangalore. Is she working?
Earlier working.
Now living with parents in Bangalore, and she has filed an MC petition 5459 of 2022 for divorce before the Principal Judge, Family Court, Bangalore. In that case, respondent is appearing and prosecuting the case. Now the respondent has filed MC number 846 of 2022 for restitution of conjugal right in
Family court Mysore.
State Court, Mysore. It is inconvenience for the petitioner to travel from Bangalore to Mysore for prosecuting the case filed by the husband. The other hand, husband is residing in Bangalore.
And also working here.
ಬೇಡ ಮತ್ತೆ ಯಾಕೆ ಅವ್ರು ಅದಕ್ಕೋಸ್ಕರ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋದು. On the other hand, the wife has filed an case for divorce in Family Court, Bangalore. In that case, he is appearing, prosecuting the same. Under these circumstances, if this petition is allowed, it will not cause any inconvenience to the respondent. Accordingly, the CP is allowed. MC number 846 of 2022, pending in the file of Family Court, Mysore, is withdrawn. Same is transferred to Family Court, Bangalore.
Serial number 9, Vinay Chandra for petitioner, Ramesh Chandra N. Murnal.
Kindly re-refer the matter for mediation, my lord. There are chances of settlement.
Serial number?
Level 9,
Yes, Mr.
I am appear for respondent, my lord. Yes, my lord.
Why the party has come today? Is there
No,
any direction?
No, he is coming from Shivamogga. If there is any chance to appear before the mediation, he would.
You are saying that it is inconvenience to come to that Bangalore. Then that case is filed.
My lord, Shivamogga,
Ah.
MC case,
Why that parties has come?
No, my lord. The DV case has been filed by the respondent in petition.
Now that Bangalore Mediation Center.
Yes, my lord. Yes, my lord.
It is written that it is not settled in mediation.
It has been not settled, but again, he is interested, he is showing interested to settle the matter,
Both of them.
both of them.
And why do you want mediation? You both of them sit together and decide. What is that decision? Whether.
My lord, there already the respondent is ready to pay the 12 lakh rupees for final settlement, but she is not ready to the payment what he has given. Hence, again,
Now she is ready to negotiate, madam.
Yes, my lord.
Yes, on the request of parties. Refer this matter to Bangalore Mediation Center. ಯಾವಾಗ appear ಆಗ್ತೀರಾ?
so ಇವತ್ತಾದ್ರೂ ಸ್ವಾಮಿ ನಡೀತದೆ ಇಲ್ಲ ನಾಳೆ ಹಾಕ್ಬಿಡಿ ಸರ್, ನಾಳೆ ಹಾಕ್ಬಿಡಿ ಸರ್, ನಾಳೆ ಹಾಕ್ಬಿಡಿ ಸರ್,
Sir, directed to be. Yes, madam.
Yes,
Tomorrow.
please, my lord.
tomorrow.
That is directed to be appear before Bangalore Mediation Center on tomorrow.
Yes, my lord.
Serial number 10 adjourn. Serial number 11 MB Chandrachuda for petitioner Anand H.
Petition by the wife. Answer the petition of the Bangalore to Madhugiri.
Husband is in Bangalore, you are in.
Husband is in Bangalore. I am from Madhugiri.
Madhugiri. She filed any case?
ಹೌದು, ಅಲ್ಲೊಂದು ಮೇಂಟೆನೆನ್ಸ್ ಕೇಸ್ ಹಾಕಿದೆ, ಈಗ ಒಂದು ಡೌರಿ ಅರೇಂಜ್ಮೆಂಟ್ ಕೇಸ್ ಇದೆ, ಒಂದು 498 ಇದೆ, ಅಲ್ಲೇ ಮಧುಗಿರಿಲಿ ಇದೆ, ಅಲ್ಲಿಗೆಲ್ಲ ಬರ್ತಾ ಇದಾರೆ, ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದಾರೆ ಕೋರ್ಟ್.
What is that number? Maintenance.
ಕ್ರಿಮಿನಲ್ ಮಿಸ್ ನಂಬರ್ 2 of 21.
2 of 21.
125 ಕೆಳಗಡೆ ಹಾಕಿರೋದು ಮೇಂಟೆನೆನ್ಸ್. ಇನ್ನೊಂದು CC ಕೇಸು 2915 of 21.
2915 of 21.
498
ಎಲ್ಲಿದೆ? ಅದು ಮಧುಗಿರಿ.
ಮಧುಗಿರಿಲೇ ಇದೆ. ಇವೆರಡು ನಾನು ಹಾಕಿರೋದು. ಇದು ಹಸ್ಬೆಂಡ್ ಹಾಕಿರೋದು OS 148 of 22. ಇವೆಲ್ಲ ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಅಪಿಯರೆನ್ಸ್ ಆದ್ಮೇಲೆ ಬೆಂಗಳೂರಿಗೆ ಬಂದೊಂದು ದಾವ ಹಾಕ್ತಾರೆ. ಸೂಟ್ ಬಾರ್ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್.
ಸೂಟ್
ಮೊಹಮ್ಮದ್ ನಲ್ಲಿ MC ಬರಲ್ಲ, ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ಕೇಳ್ತಾರೆ.
Yes. So and so learned counsel appearing for petitioner wife has contended that petitioner is residing with their parents in Madhugiri. She has filed criminal miscellaneous 2 of 2021 for maintenance in additional civil judge JMFC Madhugiri, and also filed in a criminal case in CC number 2915 of 2021. In both cases, respondent husband is appearing and prosecuting the case. Just to harass the petitioner, now that respondent has filed OS number 148 of 2022 in the file of second additional principal judge family court at Bangalore for restitution of conjugal right. Since petitioner is residing in Madhugiri and she has filed 2 cases in Madhugiri, in that respondent is appearing and prosecuting. If that civil petition is allowed, it will not cause inconvenience to that respondent. Hence, he sought for allowing that petition. None appears for the respondent. Heard the learned counsel for the petitioner. Petitioner is the legally wedded wife of respondent. Their marriage was performed according to the Islam community on 29/7/2018. After that matrimonial dispute, petitioner was started living with their parents in Madhugiri, and she has filed criminal miscellaneous 2 of 2021 for maintenance against the husband. and also filed in a criminal case in CC number 2915 of 2021 in Madhugiri. In both cases, respondent is appearing and prosecuting the case. Now the respondent has filed OS number 148 of 2022 for restitution of conjugal right before Second Additional Principal Judge, Family Court at Bangalore. Since petitioner is resident of Madhugiri, it caused inconvenience to her to come to Bangalore for prosecuting the case. Under these circumstances, the civil petition required to be allowed. The OS number 148 of 20 pending on the file of Second Additional Principal Judge, Family Court at Bangalore is withdrawn, and same is transferred to Principal Civil Judge and JMFC Madhugiri.
Serial number 12, Hegde Dattatreya Ganapati for petitioner, Vamshi Krishna C.
Serial number 12. Hegde Dattatreya. None appear. Leaves this matter next week.
Serial number 13, MP Chandrachuda for petitioner,
For the
Sumati S.
Here for the petition. Section Act.
Objection ಹಾಕಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ.
Ready?
Petition by the wife.
Yes.
The marriage between the petitioner and the respondent was performed on 14/12/2021. Petitioner has filed a domestic violence case against the husband on 31/10/2022. On the file of Principal JMFC KGF Kola. After receipt of the notice, the respondent filed an MC petition 143 of 2022 under section 9 of the Hindu Marriage Act before the Family Court, Bangalore.
What?
For divorce.
Restitution
For restitution of conjugal rights.
What is that, where she is residing, KGF?
KGF,
Where he has filed that case? Husband?
Kolar.
Bangalore.
Bangalore.
Kolar, my lords.
Kolar.
Kolar.
Where is that, this thing, yes? Kolar only.
My lords.
Family Court, Kola.
Huh? Kolar.
Kolar.
What is the distance?
30 kilometers, my lords.
30 kilometers.
And one more thing, my lords, already before the trial court, page number 66, my lords, may kindly see the order sheet in MC 143 of 22. My lords, by the order dated 27/23, the trial court has ordered the respondent herein to pay 10,000 litigation expenses and 1,000 rupees conveyance charges for the travel of the petitioner herein. And he has paid the amount, my lords, as reflected in page number 68. On 14/9, he has paid 5,000, which he has received. That apart, my lords, on the facts, 14/12/21 marriage took place, my lords. Thereafter, she went to for her delivery of the child to her parents' house, has never returned. On 14/10, my lords, date is important. 14/10/22, he issued a notice for restitution of conjugal rights. Thereafter, the petitioner has filed this petition. And the petitioner, the respondent herein filed petition for restitution on 8/11, my lords. As on 8/11/2022, notice was not ordered in DV case, my lords. That is reflected in order sheet at page number 36 and 37.
Why you have received that amount, Mr.?
ಅದು ನನ್ನ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ಮೇಂಟೆನೆನ್ಸ್ ಕೇಳಿದ್ದೆ ನಾನು.
Maintenance ಈಗ ಅಥವಾ
Maintenance and conveyance charges also have been.
ಕೇಳಿದ್ದೆ. ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಲಂಪ್ ಸಮ್ ಒಂದ್ಸರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಿಟಿಗೇಷನ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
No, that was paid towards the conveyance charges, my lords.
every date of hearing 1,000 rupees.
1,000 rupees.
ನನಗೆ
And
ಬೇಕಾಗಿಲ್ಲ, ನಾನು ವಾಪಸ್ ಕೊಡ್ತೀನಿ.
Yes.
Milord's petitioner is, the respondent herein is working as a constable in excise department, Milord.
ಅದೇ ನನಗೆ
Duty timings ಇರಲ್ಲ, ಅವ್ರು ಯಾವಾಗ ಕರೆದ್ರು ಹೋಗ್ಬೇಕಾಗತ್ತೆ. Therefore, it is difficult.
Here also he has to attend the court, is it not?
He
30 kilometers,
let,
you have to attend that DV case in that KGF only.
Milords, whenever necessary, Milords, this can be done, but traveling for him to KGF is difficult.
Why?
Hence the petition, because of his duty, Milords. Whenever whenever he's called for duty, wherever it is, he has to be present, Milords, or else his
Kolar also he has to
DV
attend the
Act.
court.
Through his advocate, he is present, Milords, only on,
Also through advocate only if there is any evidence, he has to be present.
Milords, traveling would again cause difficulty to him, Milords. It's a, first of all, the DV Act also false allegations have been made. I'm not on the merits, but for him to travel from Kolar to KGF at all hearing dates is impossible. And
All hearing date you have to go. You have to go only that where there is any evidence.
ನನಗೆ
ಇಲ್ಲ.
ನನಗೆ ಲೈಫ್ ಥ್ರೆಟ್ ಇದೆ. ಇವರು ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಅಲ್ಲಿ ಥ್ರೆಟ್ ಮಾಡ್ತಾರೆ, ಅಟೆಂಡ್ ಮಾಡಕ್ಕೆ ಬಿಡಲ್ಲ
That is-
ಕೋರ್ಟ್ಗೆ.
in fact,
ನನಗೆ
Milords,
ದುಡ್ಡು
he
ಬೇಡ
has
ಆಯ್ತು.
attended
return the money.
the naming ceremony of the child. He has given a chain, he has put some 10-gram chain to the child also. He
ದುಡ್ಡು
goes and
ವಾಪಸ್
visits
ಕೊಟ್ಬಿಡ್ತೀನಿ.
the child.
ಅವ್ರಿಗೆ
He
ಬೇಡ
goes,
ಅಂದ್ರೆ
Milords, to visit the child also.
It is for transfer.
Yes, Milords.
Convenience and inconvenience of the parties.
Since she is at home only, she can come and go, Milords. We are also paying charges, conveyance charges.
They don't want the charges. You
ಅವ್ರು ಚೈನ್ ವಾಪಸ್ ಕೊಟ್ಬಿಡ್ತೀವಿ. ಈಗ ನನ್ನೇ ಬೇಡ ಅಂದ್ಮೇಲೆ ಅವ್ರು ಚೈನ್ ಹಾಕ್ಬೇಕು ನನಗೆ.
We have not said now ಬೇಡ ಅಂತ. There are chances of reunion ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನು ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ. So that the matter is not aggravated, Milords, let him not be forced to travel to KGF, Milords. Duty
is-
constraints ಇರೋದ್ರಿಂದಾನೇ he is not able to.
Only 30 kilometers. he can
Yes.
Travel. Or if you want to settle that, I can refer to that mediation.
ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
Mediation will refer.
Let the mediation take place here at Bangalore, Milords. We
Bangalore or
will
Kolar.
conveyance,
Kolar alle.
ಕೋಲಾರಲ್ಲೇ ಎಲ್ಲಿಗೆ ಹಾಕ್ಬೇಕು?
Kolar district court. Yes.
please.
At the request of parties, refer this matter to Kolar District Court Mediation Center. When will you appear?
ಎನಿ ಡೇಟ್ ಕನ್ವಿನಿಯಂಟ್ ಟು ಮೈ ಫ್ರೆಂಡ್. ಅವ್ರು ಪೊಲೀಸ್
Next week, any date, Milords,
ಭಾಳ
Saturday.
please, 26.
22nd.
Serial number 14, Kemparaju for petitioner, Hemant Kumar J.
Respondent in this case.
Petitions, please, my lord.
Yes, Mr.
Seeking transfer from Madavalli to Mysore, my lords.
Mallavalli to Mysore. What is the distance? Mallavalli to Mysore.
48 kilometers. 48 kilometers.
What
My
is
lord.
that wife doing, Mr.?
Both are doctors. my lord.
No,
Sir, doctor.
Both are doctors.
the respondent is working as an engineer in Pune. Tata Consultancy Service, he is working in Pune. I want to bring into the notice of this court, my lord. Here, the petitioner earlier had filed a divorce petition before the principal family court, that is third additional, in MC number 1047 of 22. That has been suppressed by the petitioner
Filed where?
in Mysore itself.
Mysore.
I appeared there and I filed my objections also. Then later on, she withdraw her case as not pressed. Then again, another one case was filed by her for seeking maintenance to the child in CMS number 550 of 22. I appeared and the court ordered me to pay 7,500 rupees per month. Regularly, I am paying that maintenance amount. Now,
Mr. Counsel, anyhow, you are in that Pune.
yes, my lord.
To attend the case, you have to come to that Mandya. Instead of coming to Mandya, you go to
No,
the
both born and brought up in Malwali town.
Who?
Both petitioner and respondent.
No, petitioner has filed a case in Mysore, Mr. They are residing in Mysore.
Now they have shifted to Mysore, my lord. And
That's after the
You are
marriage.
not resident of Mandya. You are in Pune.
working in
Go to
Pune.
that
My
Mandya.
my hometown is Malwali, my lord.
No, it is not that hometown. Now you are not residing there. Anyhow, you have to come to Pune. Instead of coming to that Mandya, you come to Mysore.
My lord, another CC 29539 of 2017 is pending before the 8th ACMM court for, it is filed by the petitioner for 498A.
Ellie,
Here in 8th ACMM in Bangalore.
why that you have filed in a?
That they have already taken the stay, my lords, that the proceedings has been taken.
It has not been stayed from it.
You have to come to Bangalore for.
No,
prosecuting
the evidence has been over. The evidence has been over, my lords. The evidence are not in pending.
Petitioner
also
has
the
already
accused
adduced
number-
their evidence.
Accused number 2 and 3, the honorable court has been stayed. Even for all the above the matters, my lords, we have approached him in Pune also. Even the father of the petitioner and petitioner, they both traveled to Pune last month and we approached him, kindly come to reunion and everything, but he is not ready to take up anything.
Not ready.
He is not ready.
I'm not
Initially,
ready
my
for
lord, the
mediation
first
Earlier, the matter was referred for mediation. And there the matter got settled. They both reunion. Then only the child got her birth.
After
That's
that,
what-
again,
After
That's what,
reunion,
my
then
lord.
again they quarreled with
Initially, my
each
lord,
other.
initially, my lords, there was 2 petitions that I have brought to the notice of this honorable court, 1047 and CMIS number
now
618.
there should be a chances more because you have a kid.
Yes.
No, my lord.
3.5
My
years kid, my lords.
Respondent is not ready to reunion.
You are not.
Not ready.
Then we will transfer to that Mysore. Yes. What is
My
that?
lord, I have to come from Pune for attending in Bangalore also, again in Mysore. It will be a hardship for me to travel.
No, but you want to travel to Mandi also.
That is my hometown. Even the petitioner hometown is also Malwali.
No, my lords. We are staying in Mysore, my lord.
Now they have been shifted
no.
to Mysore and she is working as a dentist in Yalandur district, Chamarajanagar
That-
district.
that
She can
also now we-
travel to her work from to Yalandur from Mysore. Hardly it is 48 kilometers from.
See, you are not in that Mandia. It is not convenient for you in that Mandia because you are in Pune. That is what I am saying. Or whenever case is there, you have to come to that Mandia. Instead of coming Mandia, go to Mysore.
Already they have harassed me by filing an MC petition in Mysore, my lord.
That is all there. Filing in a case is not an harassment.
And they only withdraw that case as not pressed.
Not withdraw.
Now I have filed this
Even in
divorce
their
petition
petition, they
before
have
Malwali
clearly
court,
said.
which is
not-
my hometown.
My
Now
lords,
they are not ready to come to
That,
Malwali.
daughter or son?
Daughter, my
Daughter.
lords.
Daughter, what is her age?
3.5 years.
She is with you.
Yes.
Yes. Which is that MC number 69 of 23, na?
IMC number 16.
Which is the case you have filed? In Mysore?
Mysore 1047 of 22, my lords.
ಎಲ್ಲಿದೆ? Produce ಮಾಡಿಲ್ವಾ?
They have not produced the document.
Zero?
47 of 22.
It came to be withdrawn.
My lords,
Criminal miscellaneous.
MC, my lords.
For what?
It is for the divorce.
ಅದ withdraw ಮಾಡ್ಕೊಂಡ್ರಲ್ಲ.
Withdrawal amendments. Joint memo ಹಾಕಿ compromise ಆಯ್ತು.
Pending ಇರೋದು ಯಾವ್ದು?
Pending ಇರೋದು MC 69 of 23.
For what?
It is for the divorce filed by the respondent.
ಹೌದಾಯ್ತ್ರಿ, ನೀವ್ ಯಾವ್ದಾರ
ನಮ್ದು ಯಾವ್ದು pending ಇಲ್ಲ.
My lords, one submission. The MC 1047 of 22 was filed by the petitioner before the family court. That has been withdrawn by filing a memo. It is not joint memo. It is filing by memo.
That has been settled. Now that present tell. So and so learned counsel appearing for. The petitioner has contended that. Petitioner is living with her parents and 3.5-year-old daughter in Mysore. Respondent is working in Pune. He has filed MC number 16 of 2023 in the court of senior civil judge JMFC Malwali just to harass the petitioner. Petitioner has to travel ಎಷ್ಟು kilometer?
48-50 kilometers.
Has to travel nearly 50 kilometers to come to Malwali for prosecuting the case. Since 3.5 years old daughter is with her, it is difficult for her to come to Malwali. Hence he sought for allowing that CP. So and so learned counsel appearing for, the respondent has contended that respondent is working in Pune. He is resident of Malwali town. It is convenient for him to prosecute that MC number 69 of 2023 in the Malwali. Otherwise, he has to travel from Pune to Mysore.
Mysore. Malwali. Pune to Malwali, Mandya district.
Mysore, it will cause inconvenience. Therefore, he sought for dismissal of the
Much.
CP. Heard the learned counsel for the parties. Feroz. Civil petition paper. It is not in dispute. Petitioner is a legally wedded wife of respondent. Their marriage was solemnized on 2013. After the matrimonial dispute, petitioner is started living with her parents in Mysore. Even though respondent is the native of Malwali,
Yes, my lord.
he is working in Pune. And he has filed MC number 69 of 2023. Senior Civil Judge JMFC Malwali. To attend that case, he has to come to Pune to Malwali. Instead of that, he can travel to Mysore. It will not cause any inconvenience for him. Otherwise, the petitioner has to travel more than 40 kilometers to come to Malwali. Since her 3.5 years old daughter is also with her, it is difficult for her. It is an inconvenience to the petitioner to come to Malwali. In view of the above, the civil petition required to be allowed. Accordingly, CP is allowed. MC number 69 of 2023 pending in the file of Senior Civil Judge JMFC. Malwali is withdrawn and the same is transferred to Senior Civil Judge and JMFC. Ilri, Mysore.
Family court, my lord. Principal family court.
Family Court, Mysore. Yes.
Serial number 15,
Much of.
Vasant AK for petitioner, Vikyat B.
Appear for the petitioner, my lord. Last date of hearing, this honorable court directed me to seek the instructions of the petitioner,
Sir, 15.
Yes, Mr. Vasant.
seek the instruction of petitioner with respect to for mediation there at Shivamogga. Petitioner is before this honorable court, my lord. In the meantime, petitioner states that memo may be
Vijayanagara district.
the respondent got married second time, the child begotten. The respondent, and also she having the threat of implicating her in atrocities act. That being the fact, she is very much scared and fearsome. Even in Sagar also there is a mediation center. If this case has,
What will be the problem if it is Shimoga?
my lord, because she is not earning anything. And also she had faced the threat after coming out of the court or a mediation center. He being a respondent, being a police, he brings the people and he threatens, and also,
But he is in Vijayanagara.
please, my lord, he is working there at Tumkur. Now he is working there at Tumkur. And after the marriage and when they separated, without knowing to the,
Now, is
But
there
she-
any problem for Bangalore Mediation Center?
my lord, because she is before this honorable court.
You will refer it to the today itself.
My
There today.
No, my lord.
Tomorrow,
Tomorrow, please.
tomorrow.
my lord,
Has she asked anybody, their family members in the Bangalore?
but she came there at a railway station. They freshed up and they came, but
She
she.
ask any other family members is there to stay back? Nobody. ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಯಾವ ತರ ಒಂದಿನ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಬೆಂಗಳೂರಿಗೆ ಬರಕಾಗುತ್ತೆ mediation.
Because
Whether she is residing with whom?
she is residing with her mother
Mother,
and brother.
brother is there.
Brother is there.
Then brother accompanying her, he is there now.
He is there. He is there.
One day we'll fix that in Bangalore. He can come to Bangalore. You are ready. Bangalore mediation. No, you choose either Bangalore or Shimoga. Which one is convenient?
Now what she is representing, she says, I am finding it difficult because financially also because.
Now, what is the problem, madam, in the Shimoga? It is your hometown.
ಆಗಿದೆ ಸರ್ ಕಡೆ ಎಲ್ಲ ಜನ ಕರ್ಕೊಂಡ್ ಬಂದಿರ್ತಾರೆ ಫ್ಯಾಮಿಲಿ
ಅಲ್ಲಿ ಶಿವಮೊಗ್ಗಕ್ಕೆ ಅವ್ರಿಗೇನ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಇದೆ? He is in Vijayanagara. Where is that his native place?
Vijayanagara.
Hagari his native.
Then ಶಿವಮೊಗ್ಗದಲ್ಲಿ ಏನ್
ಅಲ್ಲ,
contact ಇದೆ?
ಶಿವಮೊಗ್ಗ ಅಂತ ಹೇಳಿದ್ರೆ he being a police constable, he has got the wide contacts. Sagar, because her advocate also in Sagar.
Hmm.
Along with her advocate,
Yes, you go to
she can
Sagar.
like that.
Agrabommanhalli is the Shimoga district only.
No,
No,
it is in Ballari district.
Ballari.
Hagari is in
Go
Ballari.
to Sagar.
Lodge for me.
You have no threat because you yourself is in a police. Yeah. We'll fix the date, you try it.
We are ready, my lords. We are ready to settle the matter because previously when MC
But-
was filed for section 9.
She already married second time, and also there is
No,
a case registered against him.
No, there is a
in,
PCR,
under
which is there is no
section
FIR
490.
registered presently, my lords. The PCR they have filed for bigamy, but there is no FIR registered yet. So there is no direction.
ಆಯ್ತು ಈಗ
ಅಲ್ಲ,
ನೀವ್
not
ಎರಡನೇ
cons-
ಮದುವೆ ಆಗಿ ಆಗೋದಿಲ್ಲ ಅಂದ್ರೆ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇನ್ನೇನ್ ಮಾಡ್ತೀರಾ?
No, we are ready to settle, my lords, because when the MC was ordered in the section 9 for restoration of
But
conjugal
is
rights.
that, she is ready to get any divorce, Mr. Vasan?
My lord,
No, that husband filed in a case for what?
now for divorce.
Presently for divorce.
Initially restitution for conjugal rights of, and it came to be allowed because she did not attend properly before the Hagari court, and it came to be allowed. Now at present, he filed the divorce petition before Hagari.
No, now that whether she wants to go with the husband or she wants divorce.
Because he,
You asked her. Husband, you want to take her back?
No, when the court order was there, my lord, she is not come before the court, my lord.
I agree, if you are ready to take back, I will send to the mediation.
No, my
They
lord,
will mediate.
they are not ready. As per the instructions, there, he is not ready.
Then we'll transfer this to that, this thing,
Sagar.
Nagar, you prosecute that. Yes. ನೀವ್ ಯಾವ್ದಾರ ಕೇಸ್ ಹಾಕಿದ್ದೀರಾ?
ನಾವು ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ, ಒಂದು 498A 3 and 4 of the DP Act, as well as now even Begum's this also got registered. It is before Sagar court only.
ಎಲ್ಲಿದೆ ಅದು? MC ನಂಬರ್. So and so learned counsel appearing for the petitioner wife has contended that she is residing with her mother in Gandhi Sagar. ಮಕ್ಕಳಿಲ್ಲ.
ಇಲ್ಲ ಸರ್.
Yes. The husband has filed MC petition
22 of 23.
22 of 2023. The file of senior civil judge and JMFC. Agrabommanhalli. What is the distance, Mr. Vasan?
Nearly,
Now it comes to Vijayanagara district. Presently, Agribond.
nearly 300 kilometers
300.
from Sagar to Hagari.
It's about 300 kilometers from Sagar.
212 birthdays, exactly, to be precise, 212 kilometers.
It is about 220 kilometers from Sagar. It is difficult for her to travel from Sagar to Agrabommanhalli to prosecute her case. And she has also filed an
MC,
MC.
she has filed the criminal petition in crime number 231 of 2023.
Criminal miscellaneous.
Crime number, my lord.
Criminal case book ಮಾಡಿದ್ದೀರಾ?
ಹೌದು, crime number 231 of 2023.
231 of 2023
Before the JMFC Sagar.
She has also filed a criminal case against the respondent
Please, my lord.
in CC number 231 of 2023
Crime number.
before JMFC Sagar.
Sagar. Prior, she had filed the,
For
Pri-
not for
prior to that, she had filed criminal miscellaneous number 49 of 2021 for maintenance.
ಏನಾಯ್ತು?
Adu came to be allowed,
ಅದ್ ಮುಗೀತಲ್ಲ, ಈಗೇನ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ.
but the maintenance had not been given.
ಅದು ನೀವು prosecute it.
Please, my lord, please, my lord.
Hence, he sought for allowing that petition. So and so learned counsel appearing for the respondent has contended that respondent is a government servant. He is working in Tumkur. It is difficult for him to travel every time from Tumkur to Sagar for prosecuting the case. Petitioner is a housewife. She can travel from Sagar to Agrabommanhalli to prosecute the case. It will not cause any inconvenience to her. Hence, he sought for dismissal of the CP. Heard the learned counsel for the parties. It is not in dispute. Petitioner is a legally wedded wife of respondent. Their marriage was solemnized on 27/5/2020,
27/5, my lord.
27/5/2020. Due to that wedlock. ಇಲ್ಲ ಮಕ್ಕಳಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ
Yes. 2020. After that matrimonial dispute, he started living with her mother in Sagar. She has also filed a criminal case against the husband in CC number 231 of 2023, pending in the file of JMFC Sagar. Husband has filed MC 22 of 2023 on the file of senior civil judge and JMFC Agrabammanhalli is about 220 kilometers from Sagar. It is inconvenience for her to travel from Sagar to Agrabammanhalli. Under these circumstances, the CP requires to be allowed. Accordingly, civil petition is allowed. MC number 22 of 2023, pending in the file of senior civil judge JMFC Agrabammanhalli is withdrawn, is transferred to family court Sagar.
Grateful to this honorable court.
Serial number 16, Harish Kumar MS for petitioner.
For petition, madam. The wife has filed a master petition, madam. The wife is residing in Sagar, my lord. Wife is residing in Sagar. Earlier, both of them are residing in Sagar. No, husband has filed the under for divorce petition, my lord, in Bangalore, my lord.
ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ husband?
Husband is software engineer, my lord.
Yes, heard. Issue notice. They have further proceedings. In MC 432 of 2024, pending in the file of 6th additional principal, their family court Bangalore in next table.
For order, serial number 17, GJ Sunkapur for petitioner. Serial number 17.
Yes, non-furnishing fee of weeks time is granted to do the needful.
17.
I am filing the retirement memo, my lord,
You are appearing for whom?
for petitioner.
Why?
Wife.
Serve a notice.
Yes, my lord. Acknowledgement is there.
That counsel for petitioner has filed a memo for retirement. Memo is taken on record. Petitioner, counsel for the petitioner is permitted to retire from the case. Office is directed to show the name of petitioner or any other counsel filed in Wakala next week.
Serial number 18, B Vishweshwaraya for petitioner. Serial number 18.
Each time is granted to do the needful.
Serial number 19, Ravindranath M for petitioner.
Petitioner, madam. Kindly press for 1 minute.
ಏನು 3 ಸರಿ ಆಗಿದೆಯಲ್ಲ? No such
ಇಲ್ಲ madam.
address.
ಅದು ಅಡ್ರೆಸ್ ಅವ್ರು ಸೇಮ್ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದಾರೆ ಅಂತಾನೆ ಹೇಳ್ತಾ ಇದಾರೆ. ನಾವು ಅವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ವಿ.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಳ್ಳಿ. Take hand summons.
ಅದು ನೋಡಿ
ತಗೊಂಡ ಪರ್ಸನಲ್ ಸರ್ವ್ ಮಾಡಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಕ್ ಎದುರ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಕೋರ್ಟಿಗೆ ಹೋದಾಗ ಎದುರಿಸ್ಬಿಟ್ಟೆಲ್ಲ ಇದ್ ಮಾಡ್ಯಾರಂತೆ. ಚನ್ನಗಿರಿ ಮೇಲೆ
ಗಿರಿ.
ಅಡ್ವೊಕೇಟಿಗೂ ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. ಅಕ್ಲಾನ್ಮೆಂಟ್ ಇವಾಗ ಕಳ್ಸಿಕೊಟ್ಟಿದ್ದಾರೆ.
That is not the.
ಅದಕ್ಕೆ ಸ್ವಾಮಿ ಸರ್ವ್ ಆಗಿಲ್ಲ, ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದಾರಂತೆ. ಇನ್ನೊಂದ್ಸತಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಂತೀನಿ ಸ್ವಾಮಿ, ಇಲ್ಲದೆ
ವಾಪಸ್ ಏನ್ ಬಂದಿದೆ?
ಅಡ್ರೆಸ್ ನೋ ಸಚ್ ಅಡ್ರೆಸ್ ಅಂತ ಹೇಳಿ ಬಂದಿದೆ ಸ್ವಾಮಿ. ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ತಾರೆ ಅಲ್ಲೇ ಇದಾರೆ ಅವರು, ಅಡ್ರೆಸ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes. At the request of counsel for the petitioner, week's time is granted to do the need.
ಪ್ಲೀಸ್ ಒಬ್ಲೈಟ್.
Serial number 20, Manju Bairal R for petitioner.
For petitioner in this case. This is As a wife has filed a transfer of this petition for transfer of MC case from Bengaluru to Hubballi, my lord.
Yes. Procedural.
As per the direction of this honorable court, we have already served the copy of petition to the trial court advocate, my lord.
Advocate serve ಮಾಡಿದ್ರಾ?
Yes, my lord.
ಯಾವತ್ತು?
Trial court advocate, my lord, in MC case. We have filed a acknowledgement on 15/4, my lord.
15/4.
Yes, my lord.
They have not appeared.
No, my lord, they have not appeared.
You are in the Hubli.
Yes, my lord.
They have filed in Davangere. Where is that petition is filed?
Bengaluru, my lord.
Why they have filed in Bangalore? He is in
Earlier, he was working in Bengaluru, my lord. Now he is residing at Chennagiri, Davangere district, my lord. The wife is residing along with her parents at Hubballi. There she has filed a maintenance petition, my lord, and that has been allowed.
Notice issued to that respondent. Written with postal sera. Refused. Hence service of notice to held respondent held sufficient.
Yes, my lord.
Is this matter next week?
They are not
No, their
interested
name
to.
has to be shown. Now that we have ordered that service held sufficient. Next week, if they are not come, we will pass on.
Much obliged.
Serial number 21, Udaya Kumar G for petitioner.
My lord, in this case, the address mentioned in the MC petition filed by the respondent is correct, and it's correct, and I have taken to the same address, but it is mentioned as it is, they have been left. In spite of that, I have taken notice on the advocate also, as per the direction of the honorable court, and a copy of memo has been filed, presentation memo has been filed before this honorable court.
That is not the service. You want to take hand summons.
Hand summons to the, on the advocate who is appearing in the.
Hand summons only party. You can
No,
serve
my lord,
advocate.
my difficulty is that I am from Gangavati and he is residing at Bangalore. He has filed here. In spite of that, he has filed an MC petition for conjugal rights. I had filed for DV Act there. After serving the, means after filing, I have filed the Wakalat here, and after filing this, so
ಏನಂತ ಬಂದಿದೆ ಪೋಸ್ಟಲ್ ಸರ್?
left ಅಂತ ಕೊಡ್ತಾರೆ ಸುಮ್ಮನೆ ಇದರಲ್ಲಿ, ಲೆಫ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ ಅವ್ರು ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಅವ್ರ ವಕೀಲರು ಅವರೇ ಕೇಸ್ ಹಾಕೊಂಡಿರೋದು ಇಲ್ಲಿ. ನಾಳೆ 19ಕ್ಕೆ ಇದೆ ಕೇಸ್ ಇದೆ ಸ್ವಾಮಿ. Once again, I may be permitted to serve by to the advocate.
Advocate ಕೊಟ್ಟಿರೋದು ನೀವೇನ್ ಮಾಡಿದಾರ ಅವರು?
File ಮಾಡಿಲ್ಲ.
They will not come because it is not in a service ಅಲ್ಲ.
Both ಆಗ್ಬೋದು.
No, why can't you serve any hand summons when that matter is posted in that this thing?
That is the things, my lord. Both the things have been served. Maybe I may be permitted on advocate as well as on the party. Both once again. On 19th.
ಹೀಗೆ hand summons ತಗೋಬೇಕು.
ಆಗ್ಬೋದು.
Copy serve ಮಾಡೋದಲ್ಲ. You take hand summons to the party, let us see.
Yes, my lord. And even on advocate also, my lord. Once again. Memo ಹಾಕಿ ನಾನು ಮೆಮೋ ಹಾಕಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ. ಆ ಕೋರ್ಟಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಮೆಮೋ ಹಾಕಿ.
ಅಡ್ವೊಕೇಟಿಗೆ ಬೇಕಾದ್ರೆ ನೀವು ನಮ್ ಪರ್ಮಿಷನ್ ಇಲ್ದನೋ ನೀವು ತಗೊಡ್ಬೋದು. ಅವ್ರು ಕೋರ್ಟಿಗೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಸಫಿಶಿಯಂಟ್
ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಎ ಸರ್ವಿಸ್.
ಅವರೇ ಕೇಸ್ ಹಾಕೊಂಡಿರೋದು MC ಕೇಸಲ್ಲಿ ಅವರೇ ಕೇಸ್ ಹಾಕೊಂಡು ಅವರೇ ಬರ್ತಾರೆ.
ಅವ್ರು ಅದಕ್ಕೆ ಬರಲ್ಲ ಅವರು.
ಬಟ್ ನಾಲೆಜ್ ಬರುತ್ತಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ, ದಟ್ ಕ್ಯಾನ್ ಬಿ ಕನ್ಸಿಡರ್ ನಾಲೆಜ್ ಬರುತ್ತಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಅವ್ರ ನಾಲೆಜ್ ಬಂದೇ ಬರುತ್ತಲ್ಲ ಸ್ವಾಮಿ.
Yes, learned counsel for the petitioner. Learned counsel for the petitioner is permitted to serve petition copy on the counsel appearing for the respondent before the trial court.
And even on the party also, both by hand.
Petitioner is permitted to take out hand summons to that respondent and also permitted to serve copy on counsel appearing for the respondent in trial court.
Interim order.
Interim order granted earlier is extended till next day.
Much of it.
Serial number 22, NR Rangegowda for petitioner.
Serial number 20, interim order may be kindly extended, my lord.
20 interim order extended.
Serial number 22, Rangegowda NR for petitioner.
Petitioner. Notice returned with Shara, my lord, not in station. But I will take one more step, my lord.
Yes, week's time is granted to pay the process, issue notice to respondent.
Interim order.
Interim order granted earlier is extended till next date of year.
Serial number 23, M. Shivaprakash for petitioner, A. Nagarajappa.
For respond number 1 and 2.
Serial number 23. M. Shivaprakash.
Yes. Serial number?
23 M Shiva Prakash.
Yes, Mr. Suprakash. Non-furnishing of writ petition copies covered to issue notice to respondent. Shara, insufficient address, no such person. You are appearing for whom, Mr.?
I'm appearing for respondent 1 and 2 mails.
What is this matter, Mr.? Yes, let him take process. Yes, none appear for the petitioner. Week's time is granted to do the needful.
Serial number 24 Manivannan G for petitioner MS Prakash.
Petitioner, my lord.
In this case, Lord.
Filing amend posted.
Declaration suit pending ಇದೆ 2016 in the case ಅಲ್ಲಿ repetition file ಮಾಡಿದ್ದಾರೆ.
What is this, Mr.?
Amended cost title, I'm filing.
What is that non-amendment of the cost title?
R4 ತೀರಾಗಿದ್ದಾರೆ ಅವ್ರನ್ನ ಎಲ್ಲ ಬ್ರಾಟ್ ಮಾಡಿದೀವಿ.
What is that reliquy of soft?
Let us cite the order passed by
So
the.
respondent number 1, my lord, to cancel the revenue records.
Right.
In respect of the punishment number,
What is that order? Annexure D.
yes.
Order passed by the ಇದು ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ನ್ಯಾಯಾಲಯ ತಾಲೂಕು ಪಂಚಾಯತ್ 69 ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲ 64.
ಈ ತಾಲೂಕು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಕ್ಯಾನ್ಸಲ್ ದಿ ಖಾತಾ ಇವ್ರು
ಖಾತಾ,
ಫ್ರಾಡ್
ನಮ್ಮ
ಆಗಿ ಖಾತಾ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು ಆಫ್ಟರ್ ಡಿ ಕನ್ಕ್ಲೂಷನ್ ಈ ಅಥಾರಿಟಿ ಏನ್ ಮಾಡಿದ್ರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಮತ್ತೆ ರೆಸ್ಟೋರ್ ಮಾಡ್ತಾರೆ ದೇವಸ್ಥಾನದ ಜಾಗ ಅಂತ. ಈ ಕೇಸ್ ಏನ್ ಮಾಡಿದ್ರು ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ನಾವು ಫೈಲ್ ಮಾಡಿದ್ವಿ ಡಿಕ್ಲೇರ್ ದಿ ಓನರ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ. ಟಿಲ್ ಟುಡೇ
No, what has happened to the suit?
ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ ಇನ್ನು 3 ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅವರು 2 ಫೈಲ್ ಮಾಡಿದ್ರು ಅದನ್ನು ಇಲ್ಲಿ ಹೇಳಿಲ್ಲ. ನಾವು ಫೈಲ್ ಮಾಡಿರೋದು ಇದುವರೆಗೂ ಹೇಳಿಲ್ಲ ಕೋರ್ಟ್
ಅವ್ರು ಏನಕ್ಕೆ ಫೈಲ್ ಮಾಡಿದ್ರು?
ಅವರು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು 2. ಅದರಲ್ಲಿ ಫಾದರ್ ನೇಮ್ಸ್ ತಪ್ಪೆಲ್ಲ ಹಾಕ್ಬಿಡೋದು ಎಕ್ಸ್ಪರ್ಟ್ ಡಿಗ್ರಿ ಮಾಡ್ಕೊಂಡ್ರು 2 ನಾವು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ 6 ಫೈಲ್ ಮಾಡ್ಕೊಂಡು ರೆಸ್ಟೋರ್ ಮಾಡಿಸಿದ್ದೀನಿ ಮತ್ತೆ.
You are appearing for whom?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಅವರು ದೇವಸ್ಥಾನ ಪರವಾಗಿ ವಾದ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ.
ಯಾರು?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 is the owner of the property. ದೇವಸ್ಥಾನಕ್ಕೆ ಜಾಗ ಬಿಟ್ಟಿರೋದು ಮಾರಮ್ಮ ದೇವಿ ಟೆಂಪಲ್ ಪ್ರಾಪರ್ಟಿ.
So this entry will be subject to the result of the suit.
Yes my lord.
ಸೂಟ್ ಬಗ್ಗೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ನಮ್ಮ ಪಾರ್ಟಿ ನೀದ್ ಕೇಳ್ಕೊಂಡು ನಾನು ಅದನ್ನ
Certificate copy ಇದೆ ಸೂಟ್
ಇದೆ, ಬಟ್ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ. I will look at
Same party.
See, if the suit, if they declare that they are the owner,
yes my lord.
entry in their name is correct. If it is suit is dismissed, you file an application for change of entries.
ಅದೇ my lord ನಾನು ಕೊಟ್ಟಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನಾನು ಒಂದು ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ಡ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
At the request of counsel for the petitioner, please this matter next week. You verify, Mr.
ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ.
Yes, next Thursday.
Yes ma'am.
20th.
Serial number 25 Hanumantappa B for petitioner H Devendrappa.
Last time petitioner council took time to produce the photographs
Hmm.
that their construction is not completed.
Photographs of what?
Photographs of the scheduled property, my lordship. The contention of the respondent BBMP is that they have constructed, the plan is for ground floor only. They have constructed ground plus 2 floors extra.
Hmm.
So they have said, no, our building is under construction only. We have
That
not.
is very, yes, last occasion before this court only they have said.
Yes, my lordship. He was not having the petition copy also, he said.
Password.
Serial number 26 Mithun GA Siddhappa for petitioner BJ Somayaji.
Responded.
Yes.
In the current matter, Manoj, the order which is challenged is an order passed by the Tahsildar with respect to road encroachment. Manoj, one point is, Manoj, it might at best be an order under section 67 of the Land Revenue Act, if it is so. Even then, Manoj, the problem is, they might have had, if it is an original order, then they have an appeal there.
Yes.
On the ground of this, we don't know how much this writ petition is running. Tahsildar has passed an order saying that some have encroached the road, some have not encroached the road.
Oh, what is this writ petition in local bird LB?
LB Barala idu. We don't know how much it was classified as LB, but now it has been minutes because it was.
KLR matter is also there.
ಹೌದು ಸ್ವಾಮಿ, 4-5 ಮ್ಯಾಟರ್ಗಳು ಇದೆ ಸ್ವಾಮಿ. 4 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. LB ಇದೆ, ಅವು ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ.
ಇದ್ರಲ್ಲಿ
ನೀವ್ ಯಾರಿಗೆ?
ಪಿಟಿಷನರ್ ಮೇಡಮ್, ಫಸ್ಟ್
Not
ಮ್ಯಾಟರ್
the-
ಮಾಡಿ.
ಏನದು?
petitioner is the complainant. He has claimed not that several people have encroached not portions of road.
ಮದ್ದೂರ್ ಮೇನ್ ರೋಡ್ ಸ್ವಾಮಿ 3.5 ಅಡಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
3 ಅಡಿ encroach ಆಗಿದೆ ಅಂತ. Not
3 ಅಡಿ,
now
4
that
ಅಡಿ
road not is a highway.
ಮೆಂಬರ್ಗಳು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. 40 ಮೆಂಬರ್ಸ್ ಎನ್ಕ್ರೋಚ್
It's
ಮಾಡಿದ್ದಾರೆ
a-
ಸ್ವಾಮಿ.
Some of them has filed in a KLR. He has filed in a local.
He is the complainant, he has filed it. Now, my lord, this is the main matter.
Fix the date, hear the matter, madam, please, madam.
Today, if it is an order passed by the Tashildar, my lords, in all ways, my lords, I think there should be a first appeal, my lords, which is available under the Land Revenue Act.
Nine, you can file an appeal.
He has to go and file an appeal. This is not maintainable, my lords.
Appeal before the DC, the Assistant Commissioner.
ಅಲ್ಲೂ ಆಗಿದೆ ಸ್ವಾಮಿ, AC ಫೈಲ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ? AC order ಎಲ್ಲಿದೆ?
ಕ್ಲಾರಿಫೈ ಮಾಡಕ್ಕೆ ಫಿಕ್ಸ್ ದ ಡೇಟ್ ಮಾಡಿ. ಟುಡೇ ಇದು ಆರ್ಡರ್ ಸಿಗ್ ಬಂದಿತ್ತು, ಇದು ಮಾಡಲಿ.
All these bold matters, Mr.
ಎಸ್ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನೇ ಡೇಟ್ ಮೇಡಮ್?
The request of counsel for the petitioner. Is this matter next Thursday? You verify.
ಎಸ್ ಮೇಡಮ್.
Please,
This thing, you go and file an appeal, will.
my lords, Tashildar cannot pass an order under the Municipalities Act. He will not be able to pass an order under the Gram Panchayat Act. My lords, if he passes an order, it's under the Land Revenue Act. And it is appealable as a first, under the first.
ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
Yes, next Thursday.
ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ, ಅದೊಂದು ಓವರ್ ಆರ್ಡರ್ ಆಗೋಯ್ತು ಸ್ವಾಮಿ.
ಏನ್ objection?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 20 ಇಸ್ ಡೇಡ್ ಮೇಡಮ್. ಆಲ್ರೆಡಿ 22 ಹೇಗೆ ವಕಾಲತ್
My
ಆಗಿದೆ.
lords, if the petition is not maintainable, all those things may
5
not
ಮೆಂಬರ್ಸ್
arise.
ಡೆತ್ ಆಗಿದ್ರೆ ಸ್ವಾಮಿ.
It may not arise also.
Let us see next.
ನೆಕ್ಸ್ಟ್ Thursday.
If matter has to go back, we'll pass an order.
Please.
You don't worry about this office objection and all.
ಎಸ್ ಮೇಡಮ್.
Serial number 27, Sangamesh RB for petitioner, Keshava Reddy L.
Here for the petition. Notes the hand summons was issued. May I request this, my lords,
Request of the counsel for the petitioner.
instead of that, my lords, may I request my lords to kindly permit me to issue summons through the court. It's a municipality, my lords. I'll pay the process today itself.
Municipality is not served.
ಅವ್ರಿಗೆ ಒಂದ್ಸತಿ ಹೋಗಿಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ, ಹ್ಯಾಂಡ್ಸ್
But order dated 6/6/23 ಏನದು?
ಅದೇ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ಆಗಿದೆ.
ಹಾ.
I request my lords through court if it can be issued, my lords, process. I will pay the process today itself.
Yes. Learned counsel for the petitioner pays weeks time to file a, pay the process fee to issue notice to respondent. Yes,
After payment, a notice may be issued.
yes, issue notice to respondent, yes.
Very good.
Serial number 28, RB Sadashivappa for petitioner, Ravi HK. VK Manjunath.
Notice issued to the proposed respondent number 9B and C, returned with postal share, my lord, unclaimed, absent and refused, my lord. Thrice the notice has been issued.
Steps to be taken in respect of refused.
Unclaimed anta ಒಂದ್ಸಲಿ ಬಂದಿದೆ, absent ಅಂತ ಒಂದ್ಸಲಿ, refused ಅಂತ ಒಂದ್ಸಲಿ. Kindly held the service of notice on the respondent 9B and C.
ಯಾರು respondent number?
9B and C. Proposed respondent number 9B and C.
ಏನ್ ನೀವು ಅಯ್ಯೇ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು. They are the LRs of the 9th respondent.
Objection.
Sir, sir.
9th respondent.
Ninth respondent ಇಲ್ಲಲ್ಲ ಇದ್ರಲ್ಲಿ, ಎಲ್ಲಿದೆ? Only 7 respondents are there.
ಅಲ್ಲ, impleading application ಹಾಕೊಂಡ್ವಿ. At the first instance, application has been filed. In which, my lord, 9th respondent is no more, my lord. One more application. It was first of August 2022, my lord, it is filed. One eight of 2022. First of August 2022.
This is a hotly contested matter. We'll have to quickly get the documents.
This Nagaveni and Pooja, my lord, they are trying to avoid the service of notice.
Want to implead. What is this application?
My lord, kindly recollect, my lord, last week one connected writ petition has been listed, though it is disposed of. On the instance of the town municipal council, my lord, one more application has been filed for inspection. My lord, the subject matter of the land, my lord, acquired long back in the year 1960 for the formation of the AK colony. The petitioners are the beneficiaries.
Yes.
The impleading applicants, my lord, they are encroached the, my lord, the land, for which, my lord, the 4 times inspection has been conducted. And the town municipal council, my lord, they failed to take action for eviction of the encroachers.
Yes, we'll first see that your application, you take out that application. Where is that, whom you want to implead?
The proposed respondent number, my lord, the, though it was listed, para 4, my lord, I submit that the above case was listed before the honorable court for the taking steps with respect to deceased proposed respondent number 9 on 7/7/2022. And this honorable court be pleased to grant 2 weeks time for, is granted to the petitioner to do the needful. And on verification, I came to know that,
You come to your application.
yes. Opponents.
Last list ಅಲ್ಲಿ 14 is the petitioner,
ಹೌದು.
7 is the respondent. ಏನಿದ್ ಹಾಕಿದಿರಲ್ಲ ಹಿಂಗೆ 14 and Chandrappa.
My lord, if I may submit, my lord, they're all proposed respondents. They
They are the
want to
proposed
implead, my lord. That application is not allowed where none of us have come on record.
That
Yes, my lord.
application itself is not proper.
Absolutely, my lord. Even our numbers, initially it was said that we are respondent, proposed respondent 12, and then it was made 6. So there is some mistake which is crept in the application filed by the petitioner.
Application correct ಇಲ್ಲ ಬರೀ ಅದಕ್ಕೆ 1 to 7 ಅಂತ ಒಂದು ಹಾಕಿದೀರಾ ಮತ್ತೆ ಐ ಅಂತ ಮಾಡ್ತೀರಾ. How this, Mr.
And a proper application may be directed for
Fresh
them.
application has been filed, my lord, on 6/3/2023. For bringing the LRs of the deceased 9th respondent on record. Six three 2023. ಹಾ, 3 application ಹಾಕಿದ್ದೀನಿ.
ಅದು LRs ಗೆ.
ಹೌದು, LRs.
But let me know who are the persons who want to implead. That is not forthcoming properly in your application.
They want to implead those 13 people where they claim that we are encroachers, my lord. There are separate petitions. Yeah, they
7
want
to
to implead
19.
those 13 persons who are the actual landowners, my lord. I am one such person. And Tarikere municipality, my lord, without conducting a survey, they published this list of encroachment.
Come to that.
Yes.
13 persons ಎಲ್ಲಿದ್ದಾರೆ?
1 to 19, my lord, separate application, impleading application.
ಅದೇನು ಫಸ್ಟ್?
My lord, 18/3/2020.
2000?
18/3/2020, my lord, the proposed respondent number 8220 has been, application has been filed. These are the proposed impleading applicants, my lord, 8 to 20.
8 to
20.
8 to 1920.
ಹೌದು.
ಇವರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
ಹೋಗಿದೆ.
ಏನಾಗಿದೆ ನೋಟಿಸ್? You are anybody?
I appear only for, my lord, we received a cover, my lord, only with the summons, and it said proposed respondent 12. But again, that was
Notice is-
also again changed to 6 antide.
ದಿವ್ಯಾ ಚೇತನ್.
No, my lord, Hanumantappa, my lord, Shri Hanumantappa is.
ಹನುಮಂತಪ್ಪ 12.
12 6 ಆ confusion ನಮಗೆ ಇದೆ.
Hanumantappa is
That
13.
IA
my
copy is also not served.
ಎಲ್ಲಿದ್ದಾರೆ?
Hanumantappa, my lord, the 18/3/2020 application, serial number 6 is the Hanumantappa.
But illi we received it as 12, my lord. But we've only received the summons from the court without the copy of the IA, my lord.
ಅಲ್ಲಿ ಅಪೋನೆಂಟ್ಸ್ ಅಂತ ಇದೆ ನೋಡಿ, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 6 is the ಹನುಮಂತಪ್ಪ.
ಹನುಮಂತಪ್ಪ.
ಹೌದು.
Serial number 6 ಹನುಮಂತಪ್ಪ.
ಹೌದು, he is the proposed respondent number 13.
ಇನ್ ಬಾಕಿದರಿಗೆಲ್ಲ ಏನಾಗಿದೆ ನೋಡಿ.
ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. My lord, the ninth respondent, Gangadharappa, he is no more, my lord. My lord, the application, iವರು Chandrappa is no more. Hence, the application has been failed to bring the LRs of the deceased respondent number 9 on record.
ಏನಾಯ್ತು?
At the first instance, ಅದು application notice is served, my lord. Now, twice the notice has been ordered and it is returned unclaimed and refused.
Refuse.
ಹೌದು.
ಯಾರು ಯಾರು ಎಲ್ಲಿದೆ LR application?
LR application, my lord, 6/3/2023.
Repetition ಕೊಟ್ಟಿದ್ದಾರೆ. TMC.
6/3/2023.
Who are the LRs?
The page number 5 ಅಲ್ಲಿ Chandrappa, since deceased by LRs, wife and children.
Papa is
He's
proposed respondent
nine.
number
9.
9. Yes.
Wife and children, my lord, Sakama is
refuse ಮಾಡಿದಾರಾ?
ಇಲ್ಲ.
9A served ಇದೆ.
9A served ಇದೆ. Sakama is served. Now B and C are, my lord, they are the children of this Chandrappa.
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ? ರೆಫ್ಯೂಸ್ ಆಗಿದೆಯಾ?
Refused ಅಂತ ಬಂದಿದೆ ಈಗ.
Notice issued to that LRs of proposed respondent number 9, Chandrappa. Nagaveni
And Pooja,
daughter of Chandrappa and Pooja.
daughter of Chandrappa.
Miss Nagaveni and Miss Pooja, daughter of Chandrappa, is served refused, unclaimed in service of notice to LRs of deceased respondent, proposed respondent number 9 is held sufficient. Will allow this application. Impleading.
My lord, I will place my objections on record, my lord. What is happening, my lord? Tarikere municipality, without conducting a survey, without issuing notices, they've made us as a list of encroacher, and this honorable court has granted a stay. So I'll place my objections on it. And
Is permitted to amend that impleading proposed application amend ಮಾಡಬೇಕು.
Please, Mel.
Application is not yet allowed. We'll see what is
a
the.
direction, my lord, they've served a writ petition copy, but IA copy is not given.
I will serve, my.
Yes.
I'll place my objections on 2 weeks' time, I'll request.
Serial number 29,
Match.
Prasad BS for petitioner, MS Devaraju.
1 week time to filing the, 1 week time to filing the first notice ಮಾಡಿದ್ರೆ
Time is granted to pay the process.
please.
Serial number 30, Vijay Kumar Madhukar Deshpande for petitioner, Siddharth M.
Milord, in this
HM,
case,
Geeta
I have
Devi
filed no
MP.
objection, Wakalat, Milord. Earlier advocate has filed a memo for retirement, Milord. Week's accommodation may be granted for me.
Now that you are appearing.
Yes, Milord, I am appearing now, Milord.
Now you
The
want.
earlier advocate, Vijay Kumar, has filed a memo of retirement.
Sri Vijay Kumar, learned counsel appearing for the petitioner, has filed a memo for retirement. Memo is taken on record. Learned counsel, Sri Vijay Kumar, appearing for the petitioner, is permitted to retire from the case. Yes, you want time, Mr.
Yes.
Yes.
Yes, Milord, a week's accommodation, Milord.
Yes, next week.
Serial number 31, Suresh K for petitioner, Venkat Reddy.
I prefer the appellant, my lord. I
To
filed
respond.
application for sub-service by paper publication to respondent number 3.
No such firm,
The
no
case may be posted on Monday, my lord.
Yes, you have to take steps, Mr.
Yes, I will file an application for the paper publication, my lord.
My lord, sir, one more submission.
Time is granted.
My lord, sir, one more submission. I've been only served with the petition copy. Annexures are not with the,
Which
I
one?
will submit, I will give.
for respondent number 4, my lords.
Yes, respondent
I'll
number
furnish.
4, you have to serve it. Yes.
Yes, I will furnish, my lord. Along with the process we have paid, but once again, I will
Yes,
furnish.
granted to do the needful.
Serial number 32, Annapanavar Ramesh for petitioner, TP
Yes, I
Vivekananda.
pay for the respondent.
Yes, Mr.
I propose,
The impleading application filed by.
in this case, I pray for a week's time to comply with the officer's.
What is that office objection?
And in regarding the annexure A2, my lord, actually the paper was only like that, so I could not.
Notification of the office objection raised on IA 1 of 2024 filed by the impleading Who has filed this?
I have filed the impleading.
In objection.
Aదే paper annexure A2,
A3, page number 11 to 21 for which
A3 I will do it, my lord, but annexure A2, as far as A2 is concerned, the newspaper was only printed like that only, my lord. I could not make it this way.
Want to implead, come on record as a party.
Yes, ma'am.
I will file my objection.
Sir, annexure A2.
A2, that is the newspaper, my lord, dated
I think you want to file an objection. I will file the request of parties.
the lordship may kindly overrule the regarding annexure A2, my lord. It's a newspaper.
Yes. Office objection raised on IA 1 of 2024 is heard the learned counsel for the proposed respondent. Office objection raised on IA 1 of 2024 is overruled. Yes.
Serial number 33, KB Lokanath for petitioner, government advocate.
Move for withdrawing that.
ಹಾ ಸರ್, ಅದ್ರ ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
Learned counsel for the petitioner has filed a memo dated 4/1/2024. Seeking leave of this court to withdraw this petition. The memo is taken on record. The above writ petition is dismissed as not present.
Serial number 34, Gurudat VR for petitioner, B Pramod.
Responding. What is this, Mr. Furnishing of PF?
You have not yet served a copy also with petition copy.
Is there a Gurudat?
Gurudat VR.
That you have been directed to take notice or
So only R3 we have taken the, we are take to Wakala. You have not yet served the petition copy and along with the annexures.
of subsidiary voice annexure A. What is that they want the question? Let the copies have not been served upon the. Where is he? Learned counsel appearing for respondent number 2, my lord.
For
2 and 3.
3, I am for 3.
Respondent number 2 and 3 are submit that. Petition copy is not served. None appear for the petitioner. Petitioner, counsel for the petitioner is directed to serve one set of copies on counsel appearing for respondent number 2 and 3.
Hearing interlocutory application matter, serial number 35, C Prakash, J.R. Shivakumar for petitioner, H.L. Pradeep Kumar.
Appearing for
And this
respondent number
sought
2 and
for
3,
an
my lord.
amendment of the prayer where rule
Can you
9
grant
of
2 weeks time to file an objection on IA, my lord?
Allah 2017 matters. Now
Oh.
you have filed an IA for what, mister?
Hello, challenging the rule 9 of Karnataka Housing Board allotment regulations. In what, at one stage, they say we would allot you on the basis of seniority. And by the endorsement, now it is impugned. They say we'll draw the lots and then only allot. So that particular regulation is put to challenge. So last time there were some objections on this IA that has been rectified.
Yes, madam, what you want?
2 weeks time ಕೊಡಿ ಸ್ವಾಮಿ objection file ಮಾಡ್ತೀನಿ.
Yes, counsel for the respondent is
ಆಯ್ತು
to file an objection.
Preliminary hearing B group matter, serial number 36, P N Rajeshwara for petitioner, V Vagish, Veena Kumari.
Petitioner, kindly pass away, my seat. Kindly pass.
Pass over ಬೇಡ.
Senior held up the another court, my lord. Tuesday or Wednesday it.
Yes?
Wednesday it.
What is this matter, Mr.?
ಅವರಿಗೆ ಲೋಕಲ್ ಸ್ಟ್ಯಾಂಡ್ ಇಲ್ಲ, ನಮಗೆ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದನ್ನ ಪ್ರಾಪರ್ಟಿಗೆ ಲೈಸೆನ್ಸ್ ಇವರು ನಗರಸಭೆಯವರು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
Who is he?
He is nobody, that is my case. And if he is agitating it on behalf of the public at large, this writ petition is not maintainable. That is the sharp point.
Yes.
He is not claiming an interest in the property. ನಾನು ಲೇಔಟ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ ತಪ್ಪುಗಳಾಗಿವೆ ಅಂತ ಅವ್ರ ಕೇಸು.
Yes, Mr.
He cannot have any locus standi. Senior ಬರ್ತಾರೆ.
Yes, sir. Release this matter next week. Yes.
Serial number 37, NJ Kumar, Doreraj BH for petitioner. Ken Puttegowda.
Yes. Yes. So that who is representing Puttegowda?
ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ ಪಾಪ ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕೋದಾದ್ರೆ ಹಾಕೊಳ್ಳಿ.
You are appearing.
Check. Yes, my lord. We will take instructions from the senior and we will try to give NOC.
You have not yet decided.
Yes, ma'am. ಇಲ್ಲ ಪಾಪ.
This matter, Mr. Uday.
My lord, it relates to, my lord, the levy of charges in respect of a land, my lord, BBMP in respect of a land, my lord, pertaining to, which was situated in KADB area. Under, in fact, earlier, my lord, 4 orders, my lord, I mean, 3 writ petitions were allowed in our favor. Again, my lord, they have passed, my lord, without any statute. By virtue of a circular, they are claiming demand notices have been issued.
Yes, Mr. All this.
Improvement charges.
At least you ask them to give some other counsel.
Yes, my lord.
Senior counsels who are there on the panel. Yes, at the request of counsel for respondent, is this matter next week.
Yes.
Serial number 38, YK Narayana Sharma for petitioner, HC Shivaramu.
Respondent. Yes, Narayan Sharma. Yes.
See, Madam Law. This property was the ancestral property of the petitioners. Originally, it was belonged to Srimati Chandrakantamma, the mother-in-law of the petitioner. And after her death, her adopted son, Shri B. Somashekar succeeded that property and Khata was made in his name. After that, he died and Khata was transferred in the name of Srimati, this petitioner. And subsequently, it was in long back, Lord. In 2012 and 13, the respond number 121 claimed that the property belongs to him and filed an appeal challenging that to cancellation of that khata. After hearing both the sides, that was cancelled. Again, that I prefer this petition, my lord. There is a serious dispute and subsequently they filed a suit for injunction. And subsequently they got amended the plaint and sought declaration. Now that suit has been decreed. Again, that I preferred an appeal before the Honorable Court and the appeal is pending.
We will dispose of this entry
Yes.
subject to the result of that.
Yes.
Please, my lord.
In view of the decree part in our favor, Lord, sir. Disputed question cannot gone into.
Now entry.
Maybe,
Yes.
but
If he succeed, he will go before the authority for
Yes.
enter his name.
Allah,
Yes.
this
has
is
to
the,
enter because
the lordship may kindly see the reason assigned by the officer, my lord, of page 56, lords.
Yes.
Page 56. B. My lord got it, page 56. B. ಸೋಮಶೇಖರ್ ಅವರು 428 ನಿವೇಶನವನ್ನು ದಿನಾಂಕ 14/3/96 ಪದ್ಮಾವತಿ GN ಶೇಖರ, ವಿನೋದ್ ಕುಮಾರ್, ರಾಮಚಂದ್ರರವರುಗಳಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಬಾಕಿ ಯಾವುದೇ ಖಾಲಿ ನಿವೇಶನ ಇರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ 14/12/2005 ಮತ್ತು 28/5/2005 ಸದರಿ ಸ್ವತ್ತುಗಳನ್ನು ಪದ್ಮಾವತಿ ಮಕ್ಕಳು ಬಾಬುಲಾಲ್ ಕೊಠಾರಿ ಮತ್ತು ಪರಸ್ಬಾಯಿ ಕೊಠಾರಿ ಅವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. 1ನೇ ಮೇಲ್ಮನವಿದಾರರು ಕ್ರಯಕ್ಕೆ ಪಡೆದು ಖಾತೆ ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಂಡು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಿಂದ ಕಟ್ಟಡ ಲೈಸೆನ್ಸ್ ಪಡೆದಿದ್ದು, ದಟ್ ಈಸ್ ಮೈಸೆಲ್ಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಸ್ವಾಧೀನಾನುಭವ ಹೊಂದಿರುತ್ತಾರೆ. ಅದೇ ರೀತಿ 2ನೇ ಮೇಲ್ಮನವಿದಾರರು ಉಳಿದ ಪೂರ್ವ ಭಾಗದ ನಿವೇಶನವನ್ನು ದಿನಾಂಕ 29/11/2007 MD ರಾಜೇಶ್ ಅವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಅವರು ಸದರಿ ನಿವೇಶನವನ್ನು 2ನೇ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ದಿನಾಂಕ 25/4/2008 ಕ್ರಯಪತ್ರದ ಮೂಲಕ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. 3ನೇ ಮತ್ತು 4ನೇ ಮೇಲ್ಮನವಿದಾರರು
ಬಾಲಚಂದ್ರಪ್ಪ ಬಿನ್ ಟಿ ಬಸವರಾಜುರವರಿಂದ ದಿನಾಂಕ 7/3/81 ಕ್ರಯಪತ್ರ ಮತ್ತು ದಿನಾಂಕ 21/1/88 ಕ್ರಯಪತ್ರದ ರೀತಿಯ ಖರೀದಿಸಿರುತ್ತಾರೆ. There are several sale deeds in this regard, your lordship. ಇವರು ಕ್ರಯಪತ್ರದ ರೀತಿಯ ಪ್ರತ್ಯೇಕ ಖಾತೆಯನ್ನು ಹೊಂದಿರುತ್ತಾರೆ. 2011-12 ಡಿಮ್ಯಾಂಡ್ ವಿತರಣೆಯಂತೆ 1982-83
You have obtained that suit for declaration.
ಡಿಕ್ಲರೇಷನ್
Yes.
ಅಲ್ಲ, notwithstanding the declaration obtained by me, my lord, the order is in accordance with the sale deed. If at all he has agreed.
Because when it was in my name, you ought to have referred parties to approach.
And annexure R1, my lord, may kindly see.
Ought not to have passed an order.
The annexure R1 ಕ್ರಯಪತ್ರ ಒಂದ್ಸಾರಿ ಒಂದೆರಡು
And he gave the finding.
Page 26, my lord, in the objection statement filed by him. They have stated that there is no land available ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅವ್ರು ನಮಗೆ ಬರ್ಕೊಡುವಾಗ. Page 26, my lord, may kindly see. Page 26 ಅಲ್ಲ ಅವ್ರು ಬರ್ಕೊಡುವಾಗ ಹೇಳಿದ್ರು.
ನಾವು ಬರ್ಕೊಟ್ಟಿಲ್ಲ, ಬೇರೆ ಯಾರು.
ನೀವ್ ಯಾರಿಗೆ ಬರ್ಕೊಟ್ಟಿದ್ದೀರೋ ಅವ್ರು ಹೇಳಿದ್ರು. Page 26, my lord, may kindly see. ಈ ಸ್ವತ್ತಿನಲ್ಲಿ ನನಗೆ ಇನ್ನೂ ಉಳಿದಿರುವುದಿಲ್ಲ, ಪೂರ್ಣ ಸ್ವತ್ತಿಗೆ ನೀವೇ ಮಾಲೀಕರಾಗಿರುತ್ತೀರಿ ಅಂತ ಹೇಳಿ ಈ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. There is no property available.
RFA OS number ಯಾವ್ದ್ರಿ?
OS number
OS number
5 of 2014.
that was renumbered 13/2019.
That has been decreed now, declaring that I am the absolute owner of the property.
19.
ಯಾವಾಗ ಡಿಗ್ರಿ ಆಯ್ತು?
ಅದು decree on 8/4/2024.
Declaring that I am the absolute owner of the property in question, which is the
What is that
subject
RFA?
matter.
RFA 11/52/2024.
11?
52. 11/52.
5/2 of
24.
yes. In this writ petition, petitioner questioning order dated 23/12/2014 passed by
Executive officer.
which respondent? Sixth respondent. Whereby Karnataka in respect of the property in dispute has been directed to be continued in the name of respondent number
1.
Respondent number 1 herein. In the meantime, respondent number 1 has filed a suit for declaration in respect of the property in dispute in OS number 13 of 2019.
5/14, subsequently renumbered as 13/19.
Yes, the suit is decreed on 8/4/2024.
Declaring
So that petitioner has filed a regular first appeal before this court in 1152 of 2014. In view of the above, the only relief can be passed this. Any entry is subject to the result of decision in RFA 1152 of 2024. With that observation, the petition is disposed.
Serial number 39 adjourned. Serial number 40, Pawan GN for petitioner.
any,
Vivekananda Paniyala, Kumar MN.
instead of any entry, my lord, any order that may be passed in the RFA is subject to the result of this.
No, any entry is subject to the result of the RFA.
No, entry is made in our favor, your lordship, based on the records, your lordship, based on the sale deed.
Now
If
the
he lost
entry
the
is
case,
in
then it
made
will
in
go.
paper. If that suppose he has succeeded in that RFA,
It has,
for declaring your owner is gone, then he can seek
Yes.
for a change of entry.
please, my lord.
Because there are several sale deeds,
Oh,
question of.
maybe, but
succeeding-
my name was there earlier.
Yes,
If you are an owner, the suit decreed in your favor has to be upheld by this court. In any case, if it is reversed. he can-
yes.
Yes, yes. It has to be restored in my name.
Yes.
Serial number 40,
For respondent number 5.
Petitioner, my lord.
Yes.
This is a case where a plan was sanctioned in my favor, respondent number 5, by the Mangalore Development Authority. They have challenged that plan, not looking at the amended bylaws of that MUDA. That is the question which has been
Yes, Mr.
sought to be urged, my lords.
Have to seek instructions, my lord, from the client.
What is that instruction, Mr. Now?
My lord, they're willing to withdraw the petition, my lord. I'm not pressing it.
Want to get that? Yes, if they want to withdraw,
Some date may be given, my lords.
It may be given, my lord, after 2 weeks.
Learned counsel for the petitioner press 2 weeks time to get instruction from his client. Release this matter on 19th.
Please, ma'am. Wait.
serial number 41, PD Surana for petitioner, Vijay Narayan.
In this case, I
Devi
appear for
Mohan
the respondent.
2 of 2023 amendment filed by the advocate for the petitioner. What is
Yes,
that?
in this case, he is trying to convert this writ petition into a suit, your lordships. Whatever contention has been taken by him is not necessary to adjudicate the subject matter of this.
Have you filed
writ.
objection to that IA?
Yes, we have filed, your lordships.
Where is that?
We filed it on, don't know if it has been put up, your lordships, but it has been filed. It has been served to the other side also.
Yes, none appear for the petitioner. Is this matter of 2 weeks? Let us see.
Much obliged.
Serial number 42, BJ Somayaji for petitioner, R Pramod.
And for the respondent, Lords, my lord, Lords, on behalf of the Lords, I filed a wakalat. I need 1 week time, my lord, because I do take
The
instructions.
Panchayat has filed a petition.
The Panchayat has filed an appeal.
Of this
This-
side now.
On the resolutions, my lord, they have passed a resolution that the land which has been granted to us has been granted to the Ambedkar Samudaya Bhavana. My order is the Deputy Commissioner's order, my lord. Wherein Deputy Commissioner has granted the land in favor of me, my lord, it is Mollaya, my lord. And after that, my lord, I have been in the possession of the property. The Panchayat claim made a resolution afterwards, my lord, that land has been encroached by us. Therefore, that has to be vacated and it has been granted to the Ambedkar Samudaya Bhavana, my lord. Here in this, my lord, their resolution has been challenged before the Jilla Panchayat, my lord. Jilla Panchayat says, my lord, the order of the Deputy Commissioner shall be followed and the
Is that annexure D, Mr.
Yes. Now, Gram Panchayat passed a resolution. Against that, he approached the Adyaksha of the Taluk Panchayat. He rejected it. Then he approached the Zilla Panchayat Adyaksha. Adyaksha ordered Zilla Panchayat. He passed this order. That's against that you have passed. This is without jurisdiction.
How can he has a power to pass such an order?
Yes, sir.
No.
That is without
You have to
jurisdiction.
kindly see
Annexure
the
D.
order. They are not satisfied the Gata made out in the name of the Ambedkar.
Annexure D.
Annexure
Section
D.
D,
is
my
without
lord,
jurisdiction.
operative portion 24, ink page. The operative portion
Then
of the
where
order,
will-
my lord, it is nothing but the suspension. You have to kindly see.
Hello.
Mandya Taluku, Dudda Hobli, Hullenalli Gramada Krama Sankhya.
You're you argue ಮಾಡಿದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ
ಈಗ ಟೈಮ್
ಅಲ್ಲ ಒಂದ್ ಟೈಮ್ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತೀವಿ ಸ್ವಾಮಿ
ಸರಿ.
ಅದಕ್ಕೆ. ಯಾಕಂದ್ರೆ ನಾನು ಎಲ್ಲಾರ್ಸು ಬಂದಿರೋದು
ಹೌದು.
ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತೀನಿ. ಆಯ್ತು
ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಮಾಡ್ತೀನಿ. ಪರವಾಗಿಲ್ಲ. ನೀವು ಟೈಮ್ ತಗೊಳ್ಳಿ ಏನಿಲ್ಲ.
No, where is the power of Adyaksha to pass such an order?
It is not setting aside, my lord. The entire jurisdiction is that, my lord, not with regard to the original order, my lord. The order which has been passed, the resolution, my lord, to remove the encroachment. That is the crux of the matter, my lord.
Now, under which provision he has power to pass such an order?
That is under what provision they have passed a resolution, that is the point to be
Panchayat has power to pass in a
resolution, my lord.
Against that, you have filed an appeal.
Yes, my lord.
That is 269, it is provided.
No.
237.
He approached the Adyaksha Taluk Panchayat. He rejected it. Then against that, he filed a appeal before the.
I'll file the detailed objections with regard to this with the documents, my lord, and the order of the deputy commissioner is there, my lord. I will make it on action and I will.
See, the 237, he cannot pass an order that either modification or cancellation.
That is modification, cancellation is not at all taken place. It has been as it is, my lord. The question is, the order of the deputy commissioner dated 13/7/2017, my lord.
237, they can kept in abeyance, that's all. They can't see.
That's why.
Or if it is any resolution passed by the Panchayat, if it will affect to the public in large, they can keep pending and they can forward it to the government
Yes.
for taking a decision. Here, he can't pass an order.
Here, what happened, it is a.
ಅಂತಂದ್ರೆ in ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಅವ್ರ ಅಧ್ಯಕ್ಷರು ಕುತ್ಕೊಂಡ್ಬಿಟ್ಟು ಅವರೇ ಅಪೀಲೇಟ್ ಅಥಾರಿಟಿ ತರ they are
ಇಲ್ಲ, it is kept in abeyance ಇರೋದು. ಯಾಕಂದ್ರೆ ನಾನು I will convince you lordship with regard to the operative portion, ನನ್ನ ಸ್ವಾಧೀನಕ್ಕೆ ಇದ್ ಮಾಡಬಾರ್ದು ಅಂತ. One 10 days time ಕೊಟ್ಟರೆ ಮಾಡಿ.
Yes, at the request of counsel for the respondent, please this matter next week.
Serial number 43, SV Prakash for petitioner, Subramanya R.
My lord, the petitioner is the absolute owner of the property, my lord, measuring 4 acre 24 guntas and 6 guntas Karab in Tumkur city, my lord. My lord, the petitioner, my lord, obtained the conversion order, divert the property for the purpose of industrial purpose, my lord. The petitioner, my lord, constructed the way bridge abutting to the National Highway 4. My lord, he constructed the compound walls surrounding the property, my lord. No, my lord, the respondent, my lord, there is a storm water drain, my lord.
Your property.
ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ ಪಕ್ಕದಲ್ಲಿದೆ ಅದನ್ನ ಈಗ ಡೈವರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಇದಕ್ಕೆ ಐ ಹ್ಯಾವ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಆಲ್ಸೋ ಮಚ್ prior to the
Yes, madam.
without acquisition.
So I appear for the respondent corporation. On the last occasion when the matter was heard, your this honorable court directed the corporation to file an affidavit. I have filed it, my lords, affidavit dated 21/2/2023.
What is that affidavit?
Saying that the corporation has neither shifted nor diverted the natural course of the Halla, my lords, from its original position. And in fact,
My lord, I have
it is
produced
at page number
the
3, my lords, at
map
my
also.
affidavit.
Your lordship kindly see the map at page number 52, annexure N. ಅದರಲ್ಲಿ ಒರಿಜಿನಲ್ ಡ್ರೈನ್ ಫ್ರಮ್ ರೆವಿನ್ಯೂ ಸರ್ವೆ ಮ್ಯಾಪ್. ದಿಸ್ ಇಸ್ ದ ಒರಿಜಿನಲ್.
ಯಾವುದು? ಅಂಡರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್.
ಇದು ಈಗ ಮಾಡ್ತಾ ಇರೋದು, ಈಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿರೋದು.
ಒರಿಜಿನಲ್ ಯಾವ್ದು?
ಒರಿಜಿನಲ್ ಇದು ಮೇನ್ ಇರೋದು
ಬ್ಲೂ ಕಲರ್.
ಬ್ಲೂ ಕಲರ್.
ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಈಗ?
ಯಾವ್ದ್ರಲ್ಲಿ? ಹೌದು,
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರ? ಬ್ಲೂ ಕಲರ್ ಒರಿಜಿನಲ್.
ಅದನ್ನೇನು ಮಾಡಿ ಅದನ್ನೇ ಡೈವರ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಈ ಕಡೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಅದನ್ನ ಇದ್ ಮಾಡ್ಬಿಟ್ಟು ಹೊಸ ಸರ್ವೆ ಸ್ಕೆಚ್ ಮಾಡ್ಬಿಟ್ಟು. ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಐ ಹ್ಯಾವ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಸರೌಂಡಿಂಗ್ ಮೈ ಪ್ರಾಪರ್ಟಿ. ಈಗ ನಮ್ಮ ಹತ್ರ ಹೇಳ್ತಾ ಇದಾರೆ ನೀವು ಅದಿಷ್ಟನ್ನ ತೆಗೀರಿ, ಬೋರ್ವೆಲ್ ಇದೆ ಅದನ್ನು ತೆಗೀರಿ, ನಾವು ಇದ್ ಮಾಡ್ತೀವಿ ಅಂತ.
Is it you have put up in a contract the compound in is your property?
ಹೌದು, ಮೈ ಪ್ರಾಪರ್ಟಿ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಎನ್ಕ್ರೋಚ್ಡ್ property of government or anybody.
My lords, my submission is that in fact the petitioner himself has diverted or shifted the natural rainwater towards the northern side of the scheduled property, my lords, so that he can avoid the division of the property into two halves. And upon the request of the corporation, a taluk surveyor has surveyed the land, and he has located and identified the stormwater drain, my lords.
Now they shifted the very location of the storm water.
I produced the maser also, my lords, the presence of the.
ನಾವು ಮಾಡಿಲ್ಲ, ನಾವು 6 ಗುಂಟೆ ಖರಾಬ್ ಇದೆ ಅದನ್ನು ಬಿಟ್ಕೊಡ್ತೀವಿ ಅಂದ್ವಿ, ನೀವು ಮಾಡಿ ಅಂತ.
To go and file in a civil suit to establish, we can't decide whether this property belongs to you or the corporation.
ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ಅವ್ರದ್ದು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ನೀವು ನಮ್ದು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೀರಿ ಹೇಳೋದೇನಿಲ್ಲ, ನಾವು ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ, ಸರ್ವೆ ಸ್ಕೆಚ್ ಎಲ್ಲ ಮಾಡಿದೀವಿ ಅಂತ. ಇಲ್ಲ, ಅಫಿಡವಿಟ್ ಫೈಲ್ ಹಾಕಿದ್ದಾರೆ, ಬಟ್ ಆಕ್ಚುಲಿ ಇದೇ ಇಲ್ಲ.
Sir, they are saying that actually that stormwater line was that where you have marking on a red. You have shifted that to that.
2000 ಅಲ್ಲೇ
ನೀವ್ ಹೇಳಿದ್ರೆ ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ. That where they want to line that stormwater channel, whether it is in your property or that corporation.
ನನ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಆಕ್ಚುಲಿ. ಎಷ್ಟೂರಿಗೆ ಅದು ಬೇರೆ ಕಡೆ ಈಗ ಮಾಡ್ತಾ ಇದಾರೆ. ಈಗ ಸುಮಾರು ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಹೋಗ್ತಾ ಇದೆ. ಈಗ ಮಾಡ್ತಾ ಇರೋದು ಡೈವರ್ಟ್ ಮಾಡ್ತಾ ಇರೋದು. ನಂದು 6 ಗುಂಟೆ ಖರಾಬ್ ಇದೆ, ಅದನ್ನು ಬಿಟ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು. ತಗೊಳ್ಳಿ 6 ಗುಂಟೆ ಖರಾಬ್ ಅಂತ.
My lords, the maser also, the petitioner's son, his presence also is recorded, my lords, during when the maser was conducted, and it is stated that identification of the location of this affidavit I filed on 21/2/2023, my lords.
ಮತ್ತ ಅವ್ರ ಮನೆ ಮಾಜರಲ್ಲೂ ಇಲ್ಲ, ನಾವು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೀವಿ ಹೇಳೋದಿಲ್ಲ. Nowhere stated.
Which is the paragraph, madam?
Paragraph 7, my lords, where I have stated that the corporation has neither shifted nor diverted the location.
Not neither shifted nor diverted from national business.
ಅಷ್ಟೇ ಹೇಳಿರೋದು ಇನ್ನೇನು ಇಲ್ಲ.
You see that map which is produced. Page number 52.
Please.
Yes, whether that line you are drawing now, it's in that line they have shown in that red part or a blue.
I don't have a copy of that at the moment, my lords.
Copy ಕೊಟ್ಟಿಲ್ಲ ಏನ್ರಿ ಅವ್ರಿಗೆ? Writ
ಕೊಟ್ಟಿದ್ದೀವಿ
petition
ಕೊಟ್ಟಿದ್ದೀವಿ, ಅವ್ರೇನೋ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದೆ.
copy.
At present, I don't have the copy of the writ.
But how can you argue whether now you are drawing that stormwater drain in that blue part or red part? First you find out.
Please.
If it is a red part, then you are saying that its property belongs to you, you have filed an affidavit, then go to the civil court.
ಅಲ್ಲ ಸ್ಯಾಟಲೈಟ್ ಇಮೇಜ್ ಇದು, ಸ್ಯಾಟಲೈಟ್ ಇಮೇಜ್.
ಆಯ್ತ್ರಿ, they are saying that you have
ಅಲ್ಲ
shifted.
ಇರ್ಲಿ, ಅದು ಹೇಳಿ ಅವರು.
When they are disputed, we can't decide here. You have to go to the civil court. You verify according to that your affidavit, what you are saying, it is in that red line or a blue line, where you are drawing that stormwater. That
Please,
you have to
Please.
give that copy, Mr. That.
I will,
photo. Yes. Next week.
Please. In fact, I have also attached a sketch to this affidavit, my lords, at page number 7.
ಆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಏನು ಇದಿಲ್ಲ, ಗೊತ್ತಾಗದೇ ಇಲ್ಲ.
ಹಳ್ಳ ಅಂತ ತೋರಿಸಿದಾರಲ್ಲ ಅದೇ ಬ್ಲೂ ಇದ.
ಅದು
Yes, my lords.
ಅದು ಒರಿಜಿನಲ್.
ನಾವು
ಈಗ SW ಡ್ರೈನ್ ಅಂತ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ ಅದು.
ಯಾವ್ದೋ ಎಲ್ಲಿದೆ ನಾವು?
ಇಲ್ಲಿ ಒಂದು ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲಿ ಈ ಕಡೆ ಇಲ್ಲಿ ಲೈನ್ ಹಾಕಿದ್ದಾರೆ. ಅದು ಇವಾಗ ಮಾಡ್ತಾ ಇರೋದು.
SW train.
ಹಾ, ಅದನ್ನು ಇವಾಗ ಮಾಡ್ತಾ ಇರೋದು. ಇದು ಒರಿಜಿನಲ್ ಇರೋದು.
ಅದು ಕೂಡ ಬ್ಲೂ ಲೈನ್ ಒಳಗಡೆನೆ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ, ಬ್ಲೂ ಏನ್ ಒಳಗಿಲ್ಲ. ಈ ಸ್ಯಾಟಲೈಟ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಗೊತ್ತಾಗುತ್ತೆ.
You verify this in the satellite map.
Please, my lords.
He has marked a red line,
Please,
whether you are drawing in that red line or a blue line.
please, my lords.
Let's find out.
Oblige.
If I request, the net council for the respondent, please this matter next week.
Serial number 44, SN but for petitioner,
The respondent.
Ms. Devaraju, N. Devendra.
Respondent. I prefer weeks time, some inconvenience for me.
What is this?
ಕಂಪ್ಲೇಂಟ್ ಬರ್ತಾ ಇಲ್ಲ. I will retired, I will file a retired memo.
You do whatever you want, Mr. We are
Please.
not order of entering the name of the court, respondent, the name of the father of the petitioner.
Actually questioning the annexure CND.
So we voice that the entry made in favor of the respondent, you are challenged.
Please, me.
Yes, who has passed the order? D and D.
Malaship, it is not maintained. Kindly have this matter next week.
What is that D? ನೀವು ಅದ್ರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ಗೆ ಅಪೀಲ್ ಇತ್ತಲ್ಲ 269 ಅಲ್ಲಿ. You can go to that appeal.
Proceeding. Any,
Yes, Mr.
I'll
It's an order of that panchayat. You can file an appeal under 269.
verify next, may kindly have it next.
Verify that. Because all this dispute, we cannot decide it here in that list.
I will verify.
Yes, at the request of the petitioner, leave this matter next week.
Serial number 45, V. Srinivas for petitioner, N.R. Jagadishwara.
Time for the respondent minutes.
Yes. What is this, Mr. Jagdish?
It's a case of deviation. Kate has upheld the confirmation order.
Yes.
And this one court had directed the spot inspection report has been filed. The plan is obtained for the residential building.
Last occasion.
Yes, yes, Mr. Srinivas argued the matter. He wanted to file an application before the corporation at reprint forum. That is not permissible under law. That was the submission last occasion made by both the parties. Today has not
Now
come.
he is not appearing at all.
He has not appeared.
Aswar. Yes.
Serial number 46, 47, 48 adjourned. Serial number 49, HR Ananta Krishnamurthy for petitioner, NR Jagadishwara.
Change of kata.
Yes, Mr.
I represent the petitioner, my lord.
Yes.
There are two wills. One dated 23/7/1980 and the other dated 28/5/1980. Instead of preferring the later will, the Joint Commissioner has relied upon the earlier will. Page 45 is the order passed.
Yes.
That's it, may turn to page 46.
Yes.
Reasons.
Yes, Mr.
Not audible, Lord. Two wills are there. The later will is in my favor. The earlier
No.
will is in their favor.
Who was executed in a will?
Krishnamma.
Lakshmama, what is your the
Krishnamma.
relationship? She has
Krishnamma, my lord.
Hmm?
Both are related to both the parties.
No, that Lakshmama is executed in a will.
Krishnamma, sir. Krishnamma.
Krishnamma.
Yes.
Will in my favor on 23/7/1980. Will in favor of Munsami and Savitrama with a request that it should go to the respondents 1 and 2, Surendra and Anantraman. In the face of this, Kata stood in my name. Kata could not have been transferred in the names of these two persons without proving the will. Earlier will is in their favor, later will in my favor.
Yes,
The authorities
Mr.
had no jurisdiction. The Kata stood in my name.
Para 3 may kindly look into.
Yes.
The impound order, page 47, para
Yes.
3.
Yes, read.
ದಿವಂಗತ ಬಿ ಮುನ್ಸಾಮಿ ಮೂರನೇ ಮಗ ಎಂ ಪ್ರಕಾಶ್ ಮೂರನೇ ದರ ಪಾಲಿಕೆಗೆ ದಿನಾಂಕ 10/6/2013 ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿ ಖಾತೆದಾರ ಸಹಿಗಳನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಶ್ರೀಮತಿ ಕೃಷ್ಣಮರಾವ್ ದಿನಾಂಕ 23/7/80 ತನ್ನ ಹೆಸರಿಗೆ ಪ್ರಮಾಣ ಶಾಸನ ಬರೆದಿಟ್ಟಾಗಿ ಸುಳ್ಳು ಮಾಹಿತಿ ನೀಡಿ ದಿನಾಂಕ 23/7/2013 ಉತ್ತರದ ಪತ್ರ ಖಾತೆ ಬದಲಾವಣೆ ಪಡೆದಿದ್ದರ ಬಗ್ಗೆ ಸ್ವತ್ತಿನ ಕಂದಾಯ ಪಾವತಿಸುವಾಗ ತಿಳಿದಿದ್ದರಿಂದ ತಕರಾರನ್ನು ಸಲ್ಲಿಸಿದಾಗ ತಿಳಿಸಿರುತ್ತಾರೆ. ಶ್ರೀ ಪ್ರಕಾಶ್ ಹೆಸರು ಖಾತೆ ವರ್ಗಾಯಿಸುವ ಕಾಲಕ್ಕೆ ಖಾತೆದಾರ ನೋಟಿಸ್ ನೀಡದೆ ಪರಸ್ಥಳ ಪ್ರಜ್ಞೆ ಮಾಡದೆ ವಿಚಾರಣೆ ನಡೆಸದೆ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ಆಧರಿಸಿ ಷರತ್ತಿನ ಖಾತೆ ಮಾಡುವುದು ರದ್ದುಗೊಳಿಸದೆ ಈಗ ವಿಚಾರಣೆ ನಡೆಸಿರುವುದನ್ನು ಪರಿಶೀಲಿಸುತ್ತಾರೆ. ಅಲ್ಲದೆ ಖಾತೆದಾರ ಫೋರ್ಜರಿ ಸಹಿಗಳನ್ನು ಗುರುತಿಸದೆ 30 ವರ್ಷಗಳಷ್ಟು ಹಳೆಯ ಸೃಷ್ಟಿತ ನೋಂದಾಯಿಸಲು ಅಲ್ಲದ ಮರಣಶಾಸನ ಪತ್ರವನ್ನು ಒಪ್ಪಿಕೊಂಡಿರುವುದರ ಮಾನ್ಯತೆಯನ್ನು ಪ್ರಶ್ನಿಸಿದ್ದಾರೆ. ದೆನ್ ಮೈ ಲಾರ್ಡ್ಸ್,
ಪ್ರಕರಣಗಳನ್ನು ವಿಚಾರಣೆಗೆ ಕೈಗೆತ್ತಿಕೊಂಡು ಉಭಯ ಪಕ್ಷದವರಿಗೆ
ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ 48 ಅಲ್ಲಿ ದಿವಕ್ಷಣವರ ನೋಂದಾಯಿತ ಮರಣಶಾಸನ ಖಾತೆಯ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ ಮಾಡಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 5/7/2013 ಅರ್ಜಿಗೆ ದಿನಾಂಕ 23/2013 ಉತ್ತರ ಪತ್ರ ನೀಡುವುದು ಸರಿ ಇಲ್ಲ. ಸ್ವತ್ತಿನ ಸ್ಥಳ ಪರಿಶೀಲನೆ ನಡೆಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಸಂಬಂಧಿಸಿದವರಿಗೆ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 5/1/94 ನೋಂದಾಯಿತ ಮರಣಶಾಸನ ಪತ್ರದನ್ವಯ ಒಪ್ಪಿ ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡಿದ್ದನ್ನು ಪುನಃ ದಿನಾಂಕ 23/7/2013 ಅವರದೇ ಮತ್ತೊಂದು ನೋಂದಾಯಿತವಲ್ಲದ ಮರಣಶಾಸನ ಪತ್ರವನ್ನು ಒಪ್ಪಿ ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡಲು ಸಹ ಕಾನೂನಿನ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಹಾಲಿ ಖಾತೆದಾರ ಖಾತಾ ವರ್ಗಾವಣೆ ಅರ್ಜಿಗೆ ಒಪ್ಪಿತ ಸಹಿ ಇದ್ದರೂ ಸ್ವತ್ತಿನ ನೋಂದಾಯಿತ ವರ್ಗಾವಣೆ ಪ್ರಸ್ತುತವಿಲ್ಲದೆ ಖಾತೆ ವರ್ಗಾವಣೆ ಕಲಂ 114 ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಒಬ್ಬ ವ್ಯಕ್ತಿ 2 ಮರಣಶಾಸನ ಪತ್ರಗಳು ಇರುವಾಗ ಯಾವುದನ್ನು ಒಪ್ಪಿಕೊಳ್ಳಬಹುದು ಬಗ್ಗೆ ತಿಳಿದುಕೊಳ್ಳಲು ಕಾನೂನು ಮುಖ್ಯಸ್ಥರ ಪಡೆದಿರುವುದಿಲ್ಲ. ದೆನ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಟು ಪೇಜ್ 49, ಒಪಿನಿಯನ್, ಅಭಿಪ್ರಾಯ. ಈ ಮೇಲೆ ಪರಾಮರ್ಶದ ತಪ್ಪು ಒಪ್ಪುಗಳನ್ನು ಕ್ರೋಢೀಕರಿಸಿ ನೋಡಿದಾಗ ಪ್ರಮುಖವಾಗಿ ಖಾತಾ ವರ್ಗಾವಣೆ ಕಾಲಕ್ಕೆ ಸಹಾಯಕ ಕಂದಾಯ ಅಧಿಕಾರಿಯವರು KMC ಕಾಯ್ದೆ ಕಲಂ 114 ಖಾತಾ ವರ್ಗಾವಣೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ನಿಯಮಾನುಸಾರ ಜರುಗಿಸಲಿಲ್ಲವಾದ ಕಾರಣ ಮತ್ತು ಪ್ರಕರಣ ಅವಧಿ ಮಿತಿಯೊಳಗೆ ಬರುತ್ತಿರುವುದರಿಂದ ಮೂರನೇ ಎದುರಾದ ಹೆಸರಿನಲ್ಲಿ ಹಾಲಿ ಖಾತಾ ರದ್ದತಿ ಕ್ರಮ ಸೂಕ್ತ, ಸಮಂಜಸ ಹಾಗೂ ಅವಶ್ಯಕತೆ ಎಂಬುದಾಗಿ ಅಭಿಪ್ರಾಯಿಸಿ ಮೇಲಿನ ಎರಡೂ ಅಂಶಗಳನ್ನು ಸಕಾರಾತ್ಮಕವಾಗಿ ಉತ್ತರಿಸಲಾಗಿದೆ. ವ್ಯಾಜ್ಯಚ್ಯುತನ ಮೇಲಿನ ಮಾಲೀಕತ್ವದ ವ್ಯಾಜ್ಯದ ಬಗ್ಗೆ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇತ್ಯರ್ಥ ಮಾಡಿಕೊಳ್ಳಲಿಕ್ಕೆ ಎದುರುದಾರರಿಗೆ ತಿಳಿವಳಿಕೆ ನೀಡುತ್ತಾ ಪಾಲಿಕೆ ಆಸ್ತಿ ತೆರಿಗೆಯ ಮಸೂಲತೆ ಕ್ರಮಕ್ಕೆ
ಆಯ್ತು, ನೀವ್ ಯಾಕೆ ಖಾತಾ ಚೇಂಜ್ ಮಾಡಕ್ ಹೋದ್ರಿ?
ತಪ್ಪು ಮಾಹಿತಿ ಕೊಟ್ರು ನಮಗೆ, ರೆಸ್ಟೋರ್ ಮಾಡಿದೀವಿ.
You have given a finding saying that when there is a two will,
ಹೌದು,
it cannot be decided. You
ಹೌದು.
have to say that go for a civil court.
ಅದನ್ನೇ ಹೇಳಿದ್ದೀಗ ರೆಸ್ಟೋರ್
ಇಲ್ಲ, ನೀವು
ಒರಿಜಿನಲ್ ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ವಿ ಅಷ್ಟೇ. ಮೊದಲೇ
ರೆಸ್ಟೋರ್ ಮಾಡಕ್ ಹೋದ್ರಿ? ಯಾವ ಬೇಸಿಸ್
ಅಲ್ಲ,
ಮೇಲೆ?
ತಪ್ಪಾಗಿರೋದು ಎಲ್ಲಿ ಆಯ್ತು, ನಾವು ಯಾರು ಮೊದ್ಲು ಯಾರ ಹೆಸರಲ್ಲಿ ಇದೆಯೋ ಅದೇ ಹೆಸರಿಗೆ ಮಾಡಿ ಅಂತ ಹೇಳಿದೀವಿ.
See,
Even my lords, if this court set aside the entire issue, if the party direct to approach the civil court, I am bound to do it.
yes.
I am nothing to do with the Katha is concerned. There is internal dispute between
Yes,
the brothers. Petitioner as well respond.
Timing on that to this thing. Who is appearing for other side? Third unrepresented, huh?
Fourth respondent,
Yaar is
third
that?
and fourth respondent.
Served unrepresented, sir.
They are unrepresented.
See, we'll set aside any entry made in that kata is subject to the result. Parties are directed to approach the civil court.
Civil court, yes.
Yes, Mr. In this writ petition, petitioner challenging order dated 20th/4/2016 passed by respondent number 2, Alva,
House,
passed by respondent number 2, whereby kata in respect of that property in dispute has been entered in the name of respondent number 4. 3 and 4 ಇಬ್ಬರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಇಬ್ರು ಇಲ್ಲ ಸರ್, ಇಬ್ಬರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆ.
Yes. The case of the petitioner that he is the absolute owner of the property bearing PID number 60-40-54 situated at Bairasandra Main Road, First Block, Jayanagara, Ward number 60, Putta, Biramana Nagara, Bangalore. Originally, said properties belongs to one Sri Krishnamma. She has executed a will in favor of the petitioner on 23/7/2018. After the death of the Krishnamma, that is on 24/12/2018, the petitioner become the absolute owner. The respondent number 3 and 4 also claiming that the Krishnamma has bequeathed in their favor. ಅವ್ರದ್ದು ಯಾವತ್ತು ಡೇಟ್ ವಿಲ್ದು
28/5/80, 28/5/1980.
1980. On the basis of the will produced by that petitioner, petitioner name has been entered in that kata has been changed in the name of the petitioner in corporation records. Being agreed by the same, the respondent number 4 and 3 and 4 has filed an appeal before first respondent,
second respondent.
First ಖಾತಾ ಚೇಂಜ್ ಮಾಡಿದ ಯಾರು ಹಂಗಾರೆ? ಮತ್ತೆ
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಚೇಂಜ್ ಮಾಡುದು ಯಾರು?
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಚೇಂಜ್ ದ ಖಾತಾ ಅದರಲ್ಲಿ ಪ್ರಯರ್ ಅಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ ಅವ್ರು. Filed an appeal before the second respondent under section
114A.
14A of
KMC Act 1976. The respondent by impugn order has allowed that appeal directed to restore the kata in the name of respondent number 3 and 4. In the impugn order, there is a clear finding that petitioner as well as respondent number 3 and 4 both are claiming two different will executed by
Srimati
Krishnamma. When that will is been disputed by the parties, best option for the respondent number 2 is to ask the parties to approach civil court. Instead of that, respondent has, even though after giving such a finding, respondent number 2 has allowed that appeal, restore the kata in favor of respondent number 3 and 4. Hence, the impugn order is without jurisdiction, is liable to be set aside. Accordingly, Annexure E dated. What is the date?
10-4-2016.
Yes. Dated 20th-4-2016 is quashed. Parties are directed to be approach civil court. Yes, with that writ petition is allowed.
Serial number 50, K.R. Krishnamurthy for petitioner, K.V. Mohan, Murugesh with Charati.
First respondent.
Yes.
For the petitioner. It's a writ of mandamus, my lord. Lord, a writ of an mandamus. A civil dispute suit was been pending before the trial court, which has been dismissed. Thereafter, an appeal in RFA 299 of 2008 has been filed. And that has came to be dismissed on 22/4/2022. It is a writ of an mandamus to consider the representation made by.
Now that suit for what?
Suit for declaration.
Declaration
But that
filed
is
by-
nothing to do with this property. This is road margin, my lord, and the civic amenity area. The commissioner, BDA has issued a letter to the commissioner directing him to remove the encroachments made on the road and the civic amenity area. While
You are
letters-
appearing for whom?
For the first respondent corporation.
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 Who is appearing for the contesting respondent? BDA. Who is appearing for the contesting respondent?
Contesting respondents, my lord, actually the direction is sought against 1 to 4 only.
No, that is true.
Yes, my lord.
See, according to that BBMP,
Yes, my lord.
whether that suit is in respect of that property in dispute here or it is a different matter.
It is the encroached portion, my lord, as per the BBMP, my lord, the portion which have been encroached by the contesting respondents. It is a BDA layout, my lord. It has been handed over to the BBMP to maintenance. Thereafter, representation was been made by the residents to remove the encroachments. Meanwhile, we had issued a notice that has been challenged before this honorable court in WP number.
What has happened that?
That writ petition came to be disposed with to conduct in a spot measure and to take action.
What is?
Spot measure has been conducted. Meanwhile, a civil suit was been pending before the trial court in respect of the same property. That has came to be dismissed. That was the suit between the contesting petitioner and the contesting respondent. We are not the parties before the court.
No, is it related to that same property?
Same property.
Where is that?
That I'm sorry. That was between Income Tax House Building Cooperative Society and this respondent number 5. That is in respect of the remaining extent of land where layout is formed. This is a land where even according to the commissioner BDA, that there is an encroachment of the civic amenity area and road area.
Yes.
And they filed that writ petition challenging the notice issued by the BDA to the commissioner saying that remove the encroachment. That was disposed of. Kindly see the order at page 20, my lord, by this honorable court.
Yes.
However, for the present, right of petitioner number 1 and right of respondent number 1 shall be left dealt specifically before the appropriate forum. Respondent Bengaluru Development Authority and Bruhat Mahanagara Palike to identify the property available to the parties and thereafter to proceed. Identification to be conducted before the parties. Till such identification.
Have you completed this order?
Yes, my lord. Kindly go to 21, my lord. There is a survey conducted and they found that the encroachment.
Where is the degree, mister?
Degree copy I will.
Degree copy you have?
Degree I have, didn't bring it. I can bring it next week, your lordship.
Who is appearing for the respondent?
5, my lord.
Serial number ಎಷ್ಟು written?
Sir, serial number 50, Alesha RG.
Yes, respondent number 5. Petition dismissed against 6 and 7.
Yes, my lord.
Who is contesting? 5 or 6 and
5, my lord. Nagendra is.
Nagendra is contesting.
You take action in terms of that earlier order. Where is that? You give the degree copy.
I will, my lord, your lordship may have
It
it
is
next
not
week.
related to that, then you have no
My lord,
difference.
related to same survey number, not in relation to this
Encroach-
road and this one.
Therefore, in view of the dismissal of the suit declaration under the RFA, my lord, now we will consider the representation and we will take an action to take the position of the.
No, suit is dismissed.
Yes, suit
Suit
has
is
been
dismissed.
dismissed. RFA is
is
dismissed.
Then
But
what is
no,
the
no,
hurdles
my
for
lord,
you?
the Supreme Court
Right.
matter is pending. my lord.
Supreme Court
Matter is, I should, I will produce the decree.
Whether it is related to
Yes,
this properties or not.
Yes.
Yes.
But the request, leave this, none appear for the respondent number 5. Leave this matter next week.
Much.
Serial number 51, A Nagarajappa for petitioner, Amit Deshpande.
In this matter, I am appealing to petitioner, my lord. My lord, kindly grant week's accommodation, my lord. I have informed to other side, my lord. Morning itself.
Yes, madam, what is this you are challenging?
My lord, annexure G and L, my lord,
Proceedings culminated in passing an order.
regarding deviation.
Who is appearing for BBMP? We have informed him to take time.
Inform.
Yes, at the request of petitioner, leaves this matter next week.
Serial number 52, V Srinivas for petitioner, H.
52, my lord.
Shivaramu.
Pending taken up on Monday, my lord.
Petitioner,
There was a direction, my lord.
Direct-
Instruction.
delegation of powers ಬಗ್ಗೆ notification ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರಿ ಸುಮ್ಮನೆ
ಹಾ.
last time.
Monday, my lord.
Yes, at the request of government advocate, leaves this matter on Monday, please. Yes.
Serial number 53, G Balakrishna Shastri for petitioner, T P Vivekananda.
Yes, Mr. Bal. Yes, Mr.
Vivekananda is not here.
Vivekananda Idrala, what is this matter, Mr.
I am seeking a writ of mandamus.
Hmm.
That the petitioner, Lord, is mandamus, Lord, is for considering the legal notice, Lord, annexure F, and the two representations, annexure H and J. Lord, the
Verification in the site measurement,
measurements, Lord, some dispute about the measurements. That is, my grievance is actually this. They, Lord, my client's father was allotted 50 feet into 80 feet, a site with a square shape. In the original plan, layout plan of the BDA was allotted to me, allotted to my father. I have succeeded. Later in 1995, Lord, they have conducted auction of the adjacent site, odd sites, Lord, 1220. Mine is 1229 or 20. Mine is 1219, that is 1220 site number. My grievance is the measurements, Lord, which is given for that adjoining site 1219 is bigger than actually what is factually it is there. With the result, both of us have to quarrel. If we intrude, Lord, with the same measurements, he will come to my property. Lord, a couple of feet, 1 or 2 or 3 feet will go away,
Yes.
resulting in a square shaped this course ಆಗ್ಬಿಡ್ತದೆ ನನ್ನ site. That is not my client's grievance.
Yes.
So with that Lord grievance, he gave the legal notice annexure F, annexure H and J measurements to see that my property 50-80 with a square shape is retained. It is not disturbed.
if now, my lord, he has filed statement of objections. He has said, he has deputed, my lord, an engineer and has measured the properties. 5080, my area is intact and that area is also intact.
Then what is the dispute now?
Lord, if it is so, Lord, no difficulty, Lord, my only objection is, let the statement be recorded, not which he says. Lord, my area is as per the plan, my lord, of the MODA, which was given to me, 50 into 80, not with the square shape. If he says, my lord, it is there. He says in the other side also that measurement is there. So my area will not be disturbed. That is what, my lord, so you can have no grievance. The Lord may record that statement.
Where is that, in which para they said in that objection?
My lord, your lordship says, statement of objections. Para 3, my lord.
Yes.
There in the middle, my lord, the further grievance sought to be made by the petitioner in the present writ petition is in relation to the measurement of both site number 1219 and 1220, which is a disputed fact which cannot be adjudicated in the writ petition. Notwithstanding the above, as the petitioner has invoked the writ jurisdiction of this honorable court and sought for a direction to consider his representation, the engineering section of this respondent has conducted a spot inspection and measured the site number 1220 and 1219. And found that the measurement of site number 1219 is 15 into 24 meters is physically intact. And measurement of site number 1220 is as per the measurements stated in the public auction notification. Copy of the sale deed and possession certificate are produced at annexure R1 and R2. The photographs showing the erection of compound in respect of 1219 by the petitioner is produced here with as annexure R3. Similarly, photograph of site number 1220 is produced with marked as annexure R4.
ಅವ್ರು ಹೇಳೋದು ಇಬ್ರದ್ದು ಅವ್ರವ್ರದ್ದು ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ.
ಎರಡು ಕರೆಕ್ಟ್ ಇದೆ ಅಂತಾರೆ. ನಾನು ಹೇಳೋದು ಇಷ್ಟೇ ಸರ್, annexure D.
No, I will extract that para 3 and dispose of this case. In this writ petition, petitioner has sought for following relief. After service of notice, respondent appear through their counsel and filed statement of objection. The relevant para 3 is extracted below. In view of the above, the relief sought by the petitioner will not survive. Accordingly, writ petition is disposed.
Sale number 54, D. Kumar Raju for petitioner, Kempanna. Sale number 54.
Yes. Kumar Raj. Yes, ಯಾರು ಕೆಂಪಣ್ಣ ಯಾರು ಬರ್ತಾರಾ? ಇಲ್ಲ ಸರ್.
Kempanna, Kempanna is there in panel, mister? Ilva? ಮತ್ತೆ ರೀಸೆಂಟ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ 11/4/2023 ಕೆಂಪಣ್ಣ ಲರ್ನೆಟ್ ಕೌನ್ಸಿಲ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅನ್ ವಕಾಲತ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ರಿಜಿಸ್ಟ್ರಿ. ಕೆಂಪಣ್ಣವ್ರು ಇದಾರಾ? ಇಲ್ವಾ? ಯು ಟೇಕ್ ನೋಟಿಸ್, ಯು ಆರ್ ದೇರ್ ಇನ್ ದಟ್. Yes. See, he has been directed to vacate that premises in this thing. NES ಬಳಿ ನಿರ್ಮಿಸಿದ ಅಂಗಡಿ ಮಳಿಗೆಯನ್ನು ಮಾರುಕಟ್ಟೆ ಸುವ್ಯವಸ್ಥೆ ಪಾಲಿಕೆ ವಾಣಿಜ್ಯ ಸೆಕ್ರೆಟರಿ ಮಳಿಗೆಯನ್ನು ಆರ್ಥಿಕ ಯಲಾಂಕ MES ಬಳಿ ನಿರ್ಮಿಸಿದ ಅಂಗಡಿ ಮಳಿಗೆಯನ್ನ ವೆಕೆಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಹೊಸದಾಗಿ ಹರಾಜ್ ಮಾಡಬೇಕು ಅಂತ. ಓಕೆ, ಅವ್ರೇನ್ ಆಮೇಲೆ ಅಪಿಯರ್ ಆಗ್ತಿಲ್ಲ, ಸ್ಟೇ ಇಲ್ಲ, ಏನಿಲ್ಲ. ವೆದರ್ ಇಫ್ ಇಟ್ ಈಸ್ ಆಕ್ಷನ್ reaction ಆಗಿದ್ರೆ
I will take an instruction.
you take an instruction and submit. What's your name?
KV Mohan Kumar.
Office is directed to delete the name of Kempanna counsel appearing for the respondent. Show the name of KV Mohan.
KV Mohan Kumar.
Mohan Kumar. At the request, leads this matter next week. You see this into an order.
I will.
Is our reporter one sorry file.
Yes.
You take this photo in the mobile.
Yes.
Verify. Next week, lead this matter next Thursday.
Serial number 55, Jaikara Shetty H for petitioner, Ashok N Nayak.
Petition, madam. Kindly pass out.
Pass over.
Regarding tax assessment in the year. Annexure C notice they have challenged. Subsequent to filing of this writ petition, there is a government has framed the rules, Gram Panchayat tax rate fees rule 2021. So now they have challenged only Annexure C. So my submission is, my lord, let the Annexure C be questioned and may be given, remitted back to development officer to pass the order in terms of the new rules.
Now that power is with the development officer.
No, PDO only.
PDO only.
Earlier, there are no specific rules. They have issued a demand notice. Now, government has framed the rules with regard to.
No, they are saying that without jurisdiction.
Jurisdiction illa. Appellate authority has, even he has remitted the matter to the PDO. They have made a miss. Yes. Appellate authority has stated that it is matter has remitted to the PDO. The Annexure C now they have challenged. Annexure C is a notice. Now the PDO can consider it in terms of the new rules.
Yes.
ಅವರಿಗೆ ಬಿಲ್ಡಿಂಗ್ ನಮ್ಗೆ ಅಷ್ಟು ಬರಲ್ಲ, it was earlier ಬೇರೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಇತ್ತು ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. Now they have made it clear ಯಾವ ಬಿಲ್ಡಿಂಗ್ ಎಷ್ಟಾಗತ್ತೆ, rule 13 of the taxation rules.
Yes, where is that new rule?
ಅದಿದೆ 13 and 15 ಕೆಳಗಡೆ. And 15(4) ಇದ್ದಿ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾವ ಬಿಲ್ಡಿಂಗ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಅಂತ.
Yes, tax assessment
ಹೌದು,
procedure,
ಹೌದು.
formalities of cancellation, so on so. Residential, commercial, so on so. Yes,
Let
I will
them-
record that will redo in terms of this.
Yes, my lord. And let them furnish all the document. They are not getting the rent and everything because they are hostel is there.
ಇದ್ರಲ್ಲಿ ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಡಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
ಇದೆ. You can give it.
You give a notice and
Assessment
ask
and
them to
yes,
produce.
demand,
Yes.
fresh demand after,
Yes.
in terms of the.
In this writ petition,
Kindly pass.
petitioner sought, allow ಮಾಡ್ತಾ ಇದೀವ್ರಿ ಅಲ್ರಿ. Sought following relief. Learned counsel appearing for the respondent has submitted that. Which respondent you are appearing?
2 and 3, my lord.
Now, in respect of collection of the tax, government has framed a new rule called Gram Panchayat Tax Rate and Fee Rules 2021. The notice, impugn notice annexure C may be quashed, leaving liberty to the respondent to proceed the matter in terms of the rules 2021.
Yes.
Submission is taken on record. The above writ petition is allowed. Notice annexure C dated 17/3/2016 is quashed, reserving liberty to the respondent. Respondent number?
ಹೌದು. Respondent number. Video.
Respond number 3.
Respondent number 3. ಅದೇನ್ ಹೆಸರಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಪಂಚಾಯತ್. Respondent number 3. Liberty is reserved to the respondent number 3 to, if so advised, to initiate in new rule 2021. Liberty to, yes.
If any objection, my lord, to that, they can.
ಅಲ್ಲ ನೀವು ನೋಟಿಸ್ ಕೊಡಿ, ಅವ್ರು ಮಾಡ್ತಾರೆ. Yes.
In fact, tax is a long pending because 2013-14, actually they are required to pay 50% as per the new rules. before
Yes.
filing.
Now that you recollect it and do
Yeah,
it.
that is very good.
Serial number 56, Naik NR for petitioner, KV Mohan Kumar.
All the
I beg to
contentions
appear
of the
for
parties left
petition.
out.
In this case, my lord, I have continuously paid the tax as the property belongs to my mother.
56, sir.
Since till 2014 and 16, they have collected. Later, your lordship, when I have made an application to cancel the name of the party, that has been issued the endorsement annexure E, page number 31, your lordship. As if I have not made application within 3 years from the date of Khata. When his Khata was effected, no notice has been given to us. But when I have filed application, this is the endorsement issued again in favor of me, stating that within 3 years I have not made application.
Yes, that is what that rule says, section says.
Allah, my humble request, my lord, when his name is affected, why they have not issued any notice to us? Because they have collected tax
No.
later than that.
See, if you want to file an appeal under 114A, the limitation is 3 years.
Because the endorsement issued, my lord, this is the endorsement. Because my lord,
If you not taken care within 3 years,
yes.
you have lose that appeal.
No, but they have collected in my name only tax, my lord, every year.
What is that remedy? You have to challenge it filing in a writ petition. What is that remedy if they are not challenged within 3 months?
Civil suit.
Huh?
Civil suit, my lord. A
Civil, you have to
declaration.
go for a civil court. Nothing wrong in that, mister.
Please, my lord.
Yes. Tali. In this writ petition, petitioner sought quashing of endorsement dated 9/3/2017 issued by first respondent wide annexure E. Case of the petitioner that one Srimati Dodda Akkamma was absolute owner of site bearing Kanashpuri number 112, Panchayat assessment number 32/1. Now it is within the limits of BBMP, ward number 96. New number 21, situated at Harijana Colony, Chola Nayakanahalli, Kasba Hobli, Bangalore North Taluk, measuring east to west 66 feet, north to south 28 feet. Petitioner great grandfather Sri Chikkamuni Somappa has purchased the said property by registered sale deed dated 31/3/1945. Petitioners are paying the taxes regularly. Kata is stands in whose name now, Mr.
Earlier, Dodakama, my lord.
Third respondent.
Third respondent.
Third respondent.
Our ಹೆಸರಲ್ಲೇ who is third respondent?
Kodandapani.
Kodandapani. ಯಾವಾಗ ಖಾತಾ ಅವ್ರ ಹೆಸರು ಚೇಂಜ್?
It is in 2005.
Without giving any notice, the respondent on
1/4/2005. I changed the kata in the name of third respondent. Being agreed by the same, petitioner has put it at KMC Act. One hundred and 114. Has filed a review before Additional Commissioner BBMP
On 13/2/2017.
on 13/2/2017 under section 114A. The review can be maintainable only if it is filed within the period of 3 months from the date of such recording of the transfer of the kata. In this case, kata has been effected in favor of respondent number 3 on 1/4/2005. The review is filed on 13/2/2017 beyond the period of 3 years. Therefore, the respondent has issued impugn endorsement annexure E. Impugn endorsement, therefore, there is no error or illegalities in endorsement dated 9/3/2017 annexure E. Hence, writ petition is devoid of merit, accordingly dismissed.
Please.
Cell number 57, Shriyari AV for petitioner, CT Parameshwarappa.
Yes.
Your lordship appearing for the petitioner.
Hmm.
My lords, the case is covered by this matter.
Respond. My lord, the senior counsel is away due to personal inconvenience. We kindly request for 2 weeks adjournment.
What is the case? How did the learned council, prima facie,
It's a road
demolish
widening,
2 shops of petition
land
without
acquisition
there being
matter.
any due process of law. In such event, it is needless to observe that if the respondent wants to widen the road in the land belongs to the petitioner, it is always open for corporation to acquire the land and dispose of the petitioner only after following the due process of law. In such event, yes, it is only who is you are appearing for whom, mister?
I'm representing CT Parameshwarappa, Your Honor.
Huh?
BBMP, R2, R3, R4.
Yes, in the similar matter, if you want to form a road, you acquire it in accordance with law. That's what they said. In that terms, we'll dispose of.
We are seeking some clarification from officials, Your Honor.
What is that clarification? Are you disputing this?
Yes, Your Honor. Kindly give us 2 weeks time. I mean,
No 2 weeks, mister. Tomorrow, if it is covered or not, you have to say it, mister. Where is your colleague? Just a serial number?
Sir, 57.
57. Parameshwarappa. Monday, you get that instruction. It is covered.
ತಾಯಿ ಹೆಲ್ತ್ ಸರಿ ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಅದಕ್ಕೇನೆ 2 weeks ಟೈಮ್ ಕೇಳಿದ್ರು.
ಲಾರ್ಡ್ಶಿಪ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇವತ್ತು ಆಕ್ಚುಲಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ವಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಕವರ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವ್ ಯಾರು ಬಂದಿಲ್ಲ ಅಂತ ಮಾಡಿದ್ದು. ಆಯ್ತು, ಅವ್ರೇನೋ ಹುಷಾರಿಲ್ಲ ಅಂತ ಇದಾರೆ. We will have it on next Thursday.
Much obliged.
Yes. Please this matter on Thursday at the request of counsel for the respondent.
Serial number 58, Prithvi Vadiyar, Bimbadar M. Gaudar for petitioner,
I appear for
Vishwanath
petition-
Aregde.
I appear for petitioner in this matter. Lords, I pray for a week's accommodation.
Why, mister?
Lords, I have got some personal inconvenience, Lords. I could not go through the entire file. Kindly grant me a week's accommodation. Lords.
You don't have file?
I have file, my lords, but yesterday I could not go through the file, my lords, so.
Yesterday ಏನು ಓದ್ಬೇಕಾಗಿಲ್ಲ, ನೀವು 17ರಿಂದ ಇದೆ ನಿಮ್ಮ ಹತ್ರ ಫೈಲ್.
ಇಲ್ಲ, my lords, ಇದರಲ್ಲಿ I came on NOC.
Mandamus other appropriate directing the respondent
property bearing town in favor of the petitioner issue writ mandamus any other or directing and to hand over the possession of property bearing measuring switches. And to allot that property.
Please, my lords.
Who has to allot?
Government has to allow.
Why? Who are you, Mr.?
But I am the local board, my lords, city municipal council, Sagar.
Who is the petitioner? It's a club.
But it is a club, my lords.
And why you are seeking for an allotment? What is your right?
My lords, actually, my property, my own building, my lords, was acquired for the government for establishment of additional civil judge Sagar town. my lords.
For compensating that you want seek for an allotment?
By
Is
that
it-
time, my lords, we went to a rented building. So since then, my lords, we are requesting the government to grant us some alternate land.
How can, Mr.? What is your right, Mr.?
There is no inherent power as such, my lord.
Then everybody will be say that.
Lord,
ಇದೇನೋ-
what actually the fact was, in the city civil court, in the court complex in Sagar town,
Yes.
there was a old building. In a portion of that building, several people were using it for purpose of some evening time. They used to spend time there
Yes.
as a recreation club. Later on, for the purpose of expanding the court complex,
Yes.
at the request of the learned principal district judge at that point of time, they vacated and they shifted to some other place.
Yes.
Actually, they did not have any right over that property, no title, anything whatsoever. They virtually, they are claiming on the basis of compassionate allotment.
Yes.
But the fact remains not that we have also stated so in the objection statement. Some amount towards the value of the land was deposited, and that is with the sixth respondent, that is my client. And my lord, the name of the petitioner has been changed subsequently, which was not the same petitioner, city club. Because of that, we could not refund the amount also. In 2009 itself, it was indicated that the alternate land cannot be granted to them.
Which is that provision that you are entitled for granting a land?
My lords,
All that day you have enjoyed without any rent.
No,
That
my
is
lord.
the benefit.
No, my lords, it was our own property, my lords.
What is the document to show that it is your own property?
My lords, I'll kindly grant me a week's time, my lords, I'll come.
If it is your own property, you would have not allowed them to demolish. You yourself has been there unauthorized occupants. Now you have vacated.
No, my lords, I can take this code through all these documents, my lords.
Yes.
Kindly grant me a week's time.
Show me that under which law you are entitled for
Please.
giving an alternate. Otherwise, everybody will say that
Please, my lords.
ನಮ್ಮ ಮನೆ ಹಾಳಾಗಿದೆ ಬೇರೆ ಜಾಗ ಕೊಡಿ ಇನ್ನೊಂದು ಅಲ್ಲಿ
Yeah,
ತನಕ.
it is not that, my lords. Actually, it was our property which was acquired.
Where is that?
It is for the public purpose. I'll kindly grant me a week's time, my lords.
If that is the case, you seek for a compensation, not for that alternate land. If they are assured that, yes, you will take your property in compensating that you are giving in a land ಅಂತ then a letter correspondence ಇದ್ರೆ,
Absolutely. very much.
otherwise it's difficult. Yes, at the request of council for,
Name may be deleted.
you are not there.
No.
Office is directed to delete the name of Prithvi Vadayar for petitioner. Council for the petitioner, yes. Next week. Yes.
Serial number 59, P. N. Nanjareddy for petitioner, B. K. Manjunath.
Yes, Mr. Reddy, what is this?
Very unfortunate case here.
Yes.
Milad, the petitioner site, Milad, was taken for Milad for road widening
Not to cite amount.
and
They
and
have utilized your land for an road.
road widening.
Ah.
ಅದಕ್ಕೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಅವರು they have passed a resolution stating that we'll give alternative site ಅಂತ. That was forwarded and it was also Milad.
What is that earlier round of litigation?
Earlier annexure B, they have admitted, annexure B, page 15.
Round of representation, Mahesh Learned Council. Recording submission, Mahesh Learned Council for the responsibility, if reasonable time is granted, respondent will take action in terms of that resolution. They have stated that they will take an action in terms of the resolution.
ಹೌದು ಮಾಡಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
Contempt ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ ನೀವು?
ಅದೇ ಪಾಪ ಅವರು ಸೈಟ್ 30/20.
Now who is appearing?
ಅವಾಗ ಅಂಡರ್ಟೇಕ್ ಇವರು ಐ ಥಿಂಕ್ ಬಿ ಕೆ ಮಂಜುನಾಥ್ ಗವರ್ಮೆಂಟ್ ಆಕ್ಚುಲಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹ್ಯಾಸ್ ಟು ಟೇಕ್ ಡಿಸಿಷನ್.
No, that Mahesh Learned Council for the respondent means
Resolution is passed by that
Municipality ne,
municipality.
but other we will last next annexure C towns. Government also equally responsible. The Deputy Commissioner control ಬರುತ್ತದು.
Yes, what has happened with this recommendation, madam? 2016, they have sent it to that Mane Yojana Nirdeshakaru Jilla Abhiruddhi Kosha. Where is Manjunath?
ಆಮೇಲೆ next year deal ಅವರೇ ಬರ್ದವ್ರೆ.
Otherwise, let them pay that compensation.
But
Either give that land or give a.
last may see the age of the petitioner. And I thought I verified from morning whether still 82 years avaga.
Pass over, you get Manjunath, you get Manjunath.
Yes, pass over.
Pass.
Serial number 60 adjourned, serial number 61, Lord Mariappa A for petitioner, HS Suhas.
My lord, my lord,
Hmm.
my lord, I begged for petition, my lord.
Yes, yes, Mr. Mariappa.
My lord, I seek some short adjournment because of my teeth problem. That's why I'm seeking 1 week time.
At the request of counsel for the petitioner, leaves this matter next week.
Serial number 62, R.A. Devanand for petitioner, Pategowda KV.
Respond, my lordship.
None appear for the petitioner, leaves this matter of 2 weeks. Yes.
Serial number 63 adjourned, serial number 64, Prakash T. Abbar for petitioner, connected matter, Rakshita DJ.
Yes. What is this matter, Mr. Jagdish?
Maybe passed out to 230.
Appear for respondent number.
First case, second case, that is a
Second, 3908. He is the petitioner.
3908,
Hmm.
2021. This, in this matter, my lord,
Hmm.
I am the petitioner before this honorable court.
Hmm.
Lakshmi, we have questioned the legality and correctness of the order of the assistant commissioner. And the order at
That is connected with that BBMP matter.
BBM, how, because in connected case, the, one of the, I am made as a party. The present petitioner has made as a party.
challenging OC.
Oh, occupancy certificate issued by the BBMP. In this is the main petition and that is the, your Lakshmi kindly appreciate the second writ petition is important and if I am ready, if the other side is.
Maybe taken about 213.
On 10/4/2024, my lord,
No.
the court has ordered to call for the records of the tribunal, my lord.
Records has come, madam. Who is appearing? Land Tribunal order, records has come. 10/4, counsel for the paper appearing for respondent with annexure so and so. AGA is directed to secure original records from the Land Tribunal, Mr.
ಹೌದು, original records ಬೇಕು.
You secure that records, they have challenged that occupancy right granted next week, which is the tribunal?
Lakshmi kindly fix the date.
No,
Order
which-
dated 10/4/2024, my lord. of
The
this-
LRF, my lord, your Lakshmi
no,
kindly.
Which tribunal? It's Bangalore or?
Bangalore.
Then next week.
Bangalore East Taluk, my lord.
Bangalore East.
Yes, learned counsel, government advocate, praise. Weeks time to secure original records from the tribunal. Leave this matter on 20th.
Oblige.
Get
Extend
The interim order may be kindly be extended.
granted earlier is extended till next date of hearing. Oblige. Yes.
Oblige.
Serial number 65, Ajit Kalyan for petitioner, connected matter, Achappa PB.
This matter, writ of mandamus. The last week, my lords, I had submitted that short time opposite counsel.
Yes.
Similar to the writ petition order passed by the coordinate bench.
What is
So,
that, madam, was your soft?
My lords, it is a contention of the respondent that, my lords, the discretionary quota under which we have sought, my lords, that has been struck off by the division bench of this honorable court. So in that basis, my lords, the division, that they can't consider, that is the objections they have raised. The coordinate went on the same decision, my lords said, if the discretionary quota is not available, you consider under the general merit and for allotment.
My
of
lord,
the site.
to put it in a nutshell, the petitioners had applied for houses under the KHB rules. Regulation 4A and 9A
provided for discretion, one by the board, 4A provided for discretion quota by the board, 9A provided for discretion by the government. Now, this particular provisions under the KHB Act was challenged before this honorable court in a PIL. Gojappa's case, this honorable court in that particular petition, Justice Oka and Justice Nawaz, Honorable Mohammed was sitting in the division bench and quashed those particular provisions of law. Thereby, the virtue of quashing of a regulation takes effect to the retrospective effect right from the beginning of the statute itself, and it's as if that provision of law is not existing. The actual position, insofar as whoever has got the sale deed under that, this thing, it becomes regulated, but people like, unfortunately, people like the petitioners suffer the order and it becomes applicable to them. It cannot be gainsaid that at some point in time, this regulation was going to be.
No, now you're saying that.
1 minute, my lord, I'll just complete this. Now, those particular aspects are taken into consideration, my lords. And now the coordinate bench of this court said, kindly consider this particular application on a seniority insofar as their applications are concerned and give it under the general merit. Now, is there a provision like the BDA Act? In the BDA Act, if your honors would recollect, there is a provision of seniority, but under the regulations of the KHB Act, there is no seniority of applications. It is for that particular layout. The condition of regulation 8 says that they should be resident of that particular locality itself where the layout is formed, and within 10 years preceding this thing, application should be filed. That is one aspect. Second aspect, what it says is, now it is not by application. The seniority does not come. Regulation 7 says it is by way of draw of lotteries. Now, for a particular layout, there is a draw. And the draw, that whoever comes in that lottery, now it is by, before it was at least manual and people said that there could be various other aspects into it. Now it is by e-draws. The system draws the names of the particular person and it is drawn and finished. If at all, whoever is applied for the sites, the houses, they get it by draw, they get it by draw. And if they don't get it by draw, their other applications goes.
Yes.
Regulation 7 is the regulation, my lords.
Yes.
I've also stated that in my objections also. Now, so the question of treating their applications on the ground of saying it is matured as seniority and give them a preferential treatment as against the other applicants who have subsequently come before the board with an application for allotment of this thing does not arise. And it is not permissible under the regulations.
They have applied for which project?
They have, one is in Hassan. The Shilpasri, my lords, WP number 402 of 22 is pertaining to a site in Hassan, my lords.
Hassan,
Yes.
that allotment process is over.
That allotment process is gone long back. Now, what can happen is if there is a, if there is a layout form, at best, on the ground of equity, this court can say, under regulation 8, there is a exception made for state government employees that this and other, saying that they even if they're not residing in that particular locality, they can be considered in that particular locality.
That cannot be made use, Mr.
That is the only exemption that can be extended to these
now,
applications.
What is this judgment then?
This judgment says this judgment cannot hold the field as my.
Why you have not challenged, you have accepted
My
it?
lords, now I will submit this, my lords, for whatever reasons. The board does not choose to challenge a particular this thing. They are amenable under the contempt jurisdiction 1, or the KHB is likely to file a writ appeal. If they don't choose to file a writ appeal, does it give a right to the petitioners to say, under a law laid down wrongly, I am also to be entitled to be given this thing, and a negative equality is to be claimed? It cannot be done.
That is true, Mr.
It cannot be done.
But similarly situated, why you are not giving an opportunity when you are not challenging that? Are you allotting these persons?
My lords, I don't appear in that matter. I have no stay in that matter, my lords. I don't advise.
Have they allotted these persons?
No.
They have considered. They have considered. Considered and allotted. Allotted, I am not aware. They have considered it. They'll say they have allotted. I can get the information.
On the last occasion also in this.
There is a direct- If they are allotted, see, then we'll see that. If they are
Yes.
not allotted, then it's okay.
That's fine.
If they are allotted, then similar treatment can be allowed to you. If they are not allowed, because they can say that if that order is contrary to the provision of law, then it says that
Malats, the
will not
same,
implement.
Malats, the same judgment, what my learned friend has said, that was challenged before his lordship Dikshit is also in revision petition, where similar, it has also been rejected, saying that it comes from the date of that, not retrospective.
No. Nowadays,
ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಒಂದು ಪ್ಲಾಟ್ ಮಾಡ್ತಾರೆ, ಅಪ್ಲಿಕೇಶನ್ ಕರೀತಾರೆ, ಬೈ ಲಾಟ್ರಿ ಹಾಕ್ತಾರೆ. ಸೀನಿಯಾರಿಟಿ ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬಂತಲ್ಲಿ?
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಿದೆ,
ಹೌ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್, ಹೌ ದಿಸ್ ಕೇಸ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್, ಟೆಲ್ ಮಿ. ಯು ಹ್ಯಾವ್ ಅಪ್ಲೈಡ್ ಫಾರ್ ಹಾಸನ್.
Yes.
ಹಾಸನ್ ಅಲ್ಲಿ ಒಂದು ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ, ಅಪ್ಲಿಕೇಶನ್ ಕರೀತಾರೆ, ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟು ಯಾರ್ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ಲಾಟ್ರಿ ಅಲಾಟ್ ಮಾಡ್ತಾರೆ ಬಿಡ್ತಾರೆ. BBMP ಆದ್ರೆ ಅಟೆಂಪ್ಟ್ ಬರ್ತದೆ. ಇದ್ರಲ್ಲಿ ನಿಮಗೆ ಈಗ ಹಾಸನ್ ಹೋದ್ಮೇಲೆ ನಾಳೆ ಇವರೆಲ್ಲ ಬೆಂಗಳೂರಲ್ಲಿ ಮಾಡ್ತಾರೆ, ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಎನ್ ಫ್ರೆಶ್
ಸ್ವಾಮಿ
ಅಪ್ಲಿಕೇಶನ್.
ಈಗ ಏನಾಗತ್ತೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಮಾಡ್ತಾರೆ, ಅವ್ರಿಗೆ ಅಲಾಟೇ ಆಗಲ್ಲ. ಸೊ ದೇ ಮೇಕ್ ಎ ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್. ಸೊ ದೇ ವಿಲ್ ಸೇ ದಟ್ ದೇ ವಿಲ್ ಅಲಾಟ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ಕಮಿಂಗ್ ವಾಟ್ ಎವರ್ ದ ಲೇಔಟ್ ದೇ ಫಾರ್ಮ್, ದೇ ವಿಲ್ ಅಲಾಟ್.
ವೇರ್ ಇಸ್ ದಟ್ ಪ್ರಾವಿಷನ್?
I'll let you know. In
If
other
they
matters,
are not, secured in a site in that one this thing, they are entitled for an other project.
they can make it because they give a paper publication. Under so Suryanagar first, second, we can make an application for that. So if
No,
one
no, just
stage is
tell
not
me-
applicable.
See, if you are applied for that A project,
Yes.
you didn't get that, is it entitled for your case to consider in that B? BBMP ಇದೆ, ನಿಮ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. ಅದಕ್ಕೆ ನೀವು ಈ ಜಡ್ಜ್ಮೆಂಟ್
ಅದ್ರಲ್ಲಿ ನಾನು ಅದು ಆರ್ಡರ್ ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿದೆಯಾ, I'll just find out.
verify. Otherwise, no use in granting that relief also.
Because
Consider
this-
your case in that.
It will only
seniority.
give a hope to the petitioners and give them some, this thing, twinkling light at the end, but nothing will fall out of it, my lords. And
At least they could, my lords, what I would submit is, since they have been waiting for several years, ಈಗ ಅವ್ರಿಗೆ ಏನ್ ಹೇಳ್ತಾರ, any other upcoming layout what they suggest, on the draw basis, let them consider these applications. and
You
also
can
allow.
give an application there.
Let it be.
Where is the bar for you to apply there?
Because my
Not apply it and you are successful in the draw, you will get it. ಅಲ್ಲೇನ್ ಸಿ BBMP ಲಿ ನಿಮ್ದು ಎಷ್ಟು ಅಟೆಂಪ್ಟ್ ಆಗಿದೆ, ಫಸ್ಟ್ ಯಾರು ಹಾಕಿರ್ತಾರೆ ಅವ್ರ ಮೇಲೆ ಬರುತ್ತೆ. ಇಲ್ಲ ಹಂಗಲ್ಲ, ನೀವು 1ನೇ ತಾರೀಕು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ದನು 30ನೇ ತಾರೀಕು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ದನು ಸೇಮ್.
ಮಲಚ್ ಇದ್ರಲ್ಲಿ ಮಲಚ್ ಅನೆಕ್ಷರ್ಸ್ ಟಿ ಸೀರೀಸ್ ಮಾಡ್ಬಿಟ್ಟು ಅವರು ಡ್ರಾಲ್ ಅಲಾಟ್ ಮಾಡಿದೀವಿ ಅಂತ, ಡ್ರಾಲಿ ಅಂತ ಎಲ್ಲೂ ಇಲ್ವೇ ಇಲ್ಲ. Their objection is
ಇರೋದೇ ಡ್ರಾಲ್ ಅಂತ.
draws, regulation 7, my lords.
Regulation ಅಲ್ಲೇ ಇದೆ ಡ್ರಾಲ್ ಅಲಾಟ್.
regulation ಅಲ್ಲಿ ಇದೆ, but straight away they allot under the discretionary quota. That's why it has been struck down.
That is.
ಅವ್ರಿಗೆ ಹೆಂಗೆ ಬೇಕೋ ಅದು they allot it in that.
ರೈಟ್ ಡೌನ್ ಮಾಡಿರೋದು ಸ್ಪೆಷಲ್ ಕೋಟ್ ಅದು.
ಅದಕ್ಕೋಸ್ಕರ ಅದೇ
ಅದೇ
ಹೆಂಗ್ ಬೇಕು ಹಂಗ್ allot
discretionary
ಮಾಡ್ತಾ ಇದ್ರು.
Special
ಮಾಡಕ್
quota
ಬರಲ್ಲ
ದಲ್ಲಿ
ಅಂತಾನೆ
quota.
ಬ್ಯಾಕ್ ಡೋರ್ ಎಂಟ್ರಿ ಪರ್ಮಿಟ್ ಮಾಡಬಾರ್ದು ಅಂತ explain ಮಾಡಿ.
Peoples are waiting for that lottery, but they are allotting special quota for all. Therefore, they said that it is discrimination.
Correct.
ಅದು ಹೋಯ್ತು.
Discretionary quota.
ಈಗ ನೀವು ಜನರಲ್ ಅಲ್ಲಿ ಬರ್ಬೇಕು ಅಂದ್ರೆ each time you can apply. There is no bar.
ನಾ ಇವ್ರಿಗೆ
Another
allot
thing, my
ಆಗಿದೆ.
lords, these are beneficial legislation for people who are deprived. If they have got a site allotted by any other authority subsequently, and now they are holding possession of some other.
ಆಯ್ತು, why you have not explained that earlier bench saying that?
My lords, I only appear in matters which is allotted to me, my lords. Your honor is aware how the board side.
Next week you
this
verify.
thing functions. Yes.
Tuesday.
Yes, this matter next.
Final disposal matter, serial number
Highly
66,
obliged.
Manisha Kangovi for petitioner, Mallikarjun Reddy case.
And he pass.
Yes,
Good.
who is other side?
My lord, I am for the respondent
Good
BBMP. This is a case, my lord, where there is encroachment on a footpath by respondents number 4, 5 and 6, saying that they have constructed a temple on a public footpath, my lord. Now, the BBMP, my lord, by previous orders was directed to take action to evict them, my lord. But since this is a public temple, my lord, a lot of people come and they create a lot of nuisance there. They come with all flags and all
Yes,
sticks and things like this, my lord. Such being the situation, this honorable court, my lord, the coordinate bench had directed the police also to interfere and then to seek us and to give me assistance as and when required, my lord. Such being the situation, my lord, if the police extends help, my lord, I will definitely be taking
Remove
it.
that illegal construction and occupation of the Nagama temple. Who is occupying that?
My lord, 4, 5 and 6, though they are represented, my lord, these are the
I-
people who have put up.
I beg to appear for respondent, my lord, 4 to 5. My lord, I have constructed, that is the report they have submitted. Along with my objection statement, I have given the copy, order copy passed by the BBMP authority stating that I have not single inch encroached about the road is concerned. These are the properties
No, Mr.
allotted,
Naik,
Binny
your
Mill
name is
workers,
not
my
there.
lord,
Your name
workers'
is not
property.
there. Your name is not there, Mr. Naik. Which is that matter?
Serial number 66.
66. Oh, 69, my lord. 60.
Yes.
Sorry, my lord.
Next week.
ಪಾಸ್ ರೆಡಿ ಜಸ್ಟ್ ಲಿಮಿಟೆಡ್ ಕ್ವಶನ್
ಅಲ್ಲ,
4, 5, 6 ಬಂದು ಅವ್ರಿಗೆ ಏನಾದ್ರು ಇದು ಹೇಳ್ಬೇಕಾಗುತ್ತೆ as far as BBMP is concerned, my lord, I am willing to
No,
take
that's Mohan Rangam is coming.
how ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬಂದಿದ್ರು ಅವರು
Bandidra.
ಬಂದಿದ್ರು.
Yes. None appear for respondent number 4 to 6. Leave this matter next week. Let us see if they not come, we will pass an
Any
order.
date maybe, date,
Birth next Thursday.
please.
Yes.
Finally. Final hearing matter.
And their matter Matyan. Yes, Mr.
68, my lord.
68. Yes.
And for the respondent number 1,
What do you want?
next week, my lord.
For the request of counsel for the respondent.
69 kindly maybe have it next week, my lord.
69 Naik, you want time?
Yes, my lord.
69 next week at the request respondent.
We are petitioner. 69 petitioner.
Petitioner, he wants 1 week time. Yes.
ಸರ್ 64 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬರಲ್ಲ ಅದೇ ಸ್ಟೆನೋಗೆ ಕೇಳಬೇಕು ಸರ್. ಸ್ಟೆನೋ ಮೇಡಮ್ ಕೇಳಿ ಕಾಲ್ ಫಾರ್ LCR ಅಂತ ಲಾಸ್ಟ್ ಟೈಮು ಮಾಡಿದ್ವಿ, ಈ ಟೈಮು ಬಂದಿಲ್ಲ. ಒಂದ್ ಸ್ವಲ್ಪ ಅದು ಕೇಳಿದ್ದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ರೆ ಮಾತ್ರ ಕಳಿಸ್ತೀವಿ ಅಂತ ಹೇಳ್ತೀವಿ ಮೇಡಮ್. 64 ಆರ್ಡರ್ ಏನ್ ಹೇಳಿದ್ರೆ ಹೇಳಿ. ಸೆಕ್ಯೂರ್ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಸರಿ. ಹಾ ಅಲ್ಲಲ್ಲ, ಸೆಕ್ಯೂರ್ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಸಾಹೇಬ್ರ ಹತ್ರ. ಕೊಡು. 64 ಆರ್ಡರ್ ಶೀಟ್ ಅವ್ರು ಇವತ್ತು ತಗೊಂಡು ಸೈನ್ ಮಾಡ್ಸಕ್ಕೆ ಆ ಟೈಮೇ ಕಾಲ್ ಫಾರ್ LCR
ಮಾಡಿದ್ದಾರೆ ಸಾಹೇಬ್ರು, ನೋಡಿದ್ರು, ಅವರು ಬಂದಿಲ್ಲ ಅಂತ
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅನ್ಲೆಸ್ ನೀವು ಸಾಹೇಬ್ರಿಗೆ ಆರ್ಡರ್ ಮಾಡೋವರೆಗೂ ನಾವು ಬರೋದಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಾವು ಸುಮ್ಮನೆ ಅರ್ಜೆಂಟ್
ಶಿವಾರೆಡ್ಡಿ ಸರ್ ಇದ್ರಲ್ಲ, ಅವರೇ
ಶಿವಾರೆಡ್ಡಿ ಅದನ್ನೇ ಇನ್ನು ಆಗಿಲ್ಲ, ಮತ್ತೆ ಎಲ್ಲಾದ್ರೂ ಬರ್ಕೋತಿದ್ವಿ ನಾವು ಮೇಲೆ ಬರ್ಕೊಂಡು ತರ್ಸ್ತಿದ್ವಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿಲ್ಲ ಅಂತ
ಸರಿ, ಸೈನ್ ಆಗ್ಬಿಟ್ಟು 3:30 ಬರುತ್ತೆ, ಬಂದು ನೋಡಿ. ಇದೆ ಸಾಹೇಬ್ರು ನೋಡಿದ್ರು, ಇದೆ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದಾರೆ.
ಇವಾಗ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್
ಹೇಳಿ.
ಎಷ್ಟನೇದ್ರಿ ನೋಡೋಣ ಲಾಸ್ಟ್.
ಯಾರೋ ಬೇರೆಯವ್ರ ಜೊತೆ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ.
ಬ್ರದರ್ 25 ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ ಏನಿದು? ಅದು ನಮ್ಮ ಹತ್ರ ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗ್ಬಿಟ್ಟೈತೆ, ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. 25 ಆರ್ಡರ್ ಸ್ಟೇಟ್ ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ, ಅದು ನಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ, ಮಿಸ್ಪ್ಲೇಸ್ ಆಗ್ಬಿಟ್ಟೈತೆ. ಏನ್ ಮಾಡಿ ಸಾಯರ್ ಬೈತಾರೆ. ಇದು ಆತ ಕಲಿಗಿದ್ದ ಅವರು ಅದರ್ ಸೈಡ್, ಅವನು ಬಂದಿಲ್ಲ.
ಇಲ್ಲ, ಅವ್ರು
ಇದ್ರ ಅವ್ರ ಕಡೆ ಜೆರಾಕ್ಸ್ ಅಂತ ತಗೊಂಡಿದ್ದೆ ಅಷ್ಟೇ ಒಂದು. ದೇವೇಂದ್ರಪ್ಪ ಅವ್ರ ಕಲಿಗಿದಾನಲ್ಲ,
ಅವ್ರು ಪವನ್ ಕುಮಾರ್ ಯಾವಾಗ್ಲೂ ಇರ್ತಾರೆ.
ಅದೇ
63 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡಿದ್ದಾರೆ.
ಬೆಳಿಗ್ಗೆ
53 ಮತ್ತು 67 ಬರಕ್ಕಾಗ್ಲಿಲ್ಲ, ಪಕ್ಕದ ಕೋಟ ನಂದೇ ನಡೀತಾ ಇದೆ. Okay. 53. 54. Okay.
69 adjourn. 69 adjourn ಆಯ್ತು ಸರ್. ರೀಚ್ ಆಗಿತ್ತ ಅದು? ಹಾ. ಎಷ್ಟು ಈಗ ಅವಾಗ ಯಾವಾಗ ಹೋಗಿದೆ ಅದು? ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನಂದು 25 ಒಂದಿತ್ತು, ಅದೊಂದು ಪಾಸ್ವರ್ಡ್ ಆಯ್ತು, ಎರಡೇ ಮಾಡ್ತಿದ್ದು. 69 ಒಂದ್ಸಲ ಫೈಲ್ ತೋರಿಸ್ಬೋದಾ? ಮಾರ್ನಿಂಗ್ ಆಗೋಗಿದ್ಯಾ? ಮತ್ತೆ
ಸರ್ 70th ಸೀರಿಯಲ್ ನಂಬರ್ ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗುತ್ತೆ ಸರ್. 70th ಸೀರಿಯಲ್ ನಂಬರ್ ಮಧ್ಯಾಹ್ನ ಆಗುತ್ತೆ. ಹಾಂ ಸರ್. ಸರಿ ಸರ್. ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
Serial number 3.
Next week.
ನೋಡಿ ಇಲ್ಲಿದೆ.
Amendment carried out, right? Amendment carried out as per order. Good 116 there.
ಎಷ್ಟಿದೆ ಸರ್ ಪಾಸ್ ಓವರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪಾಸ್ ಓವರ್ ಎಷ್ಟಿದೆ? ಒಂದು 45 ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು? 2 ನಿಮಿಷನಾ?
ಸರ್ ಅದು 59 ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಫೋನ್ ನಂಬರ್ ಇದೆ ನೋಡಿ, 59 ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಸಿಗ್ತಾ ಇಲ್ಲ. ಮಂಡೆಗೆ ಹೇಳ್ತೀನಿ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇಗೆ ಹೇಳ್ತೀನಿ. ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಕೈಂಡ್ಲಿ ಸೀಲ್ ನಂಬರ್ 59 ಅವರು ಮಂಜುನಾಥ್ ಸಿಕ್ಕಿಲ್ಲ, ಒಕ್ಕಾಲತ್ತಲ್ಲೂ ಫೋನ್ ನಂಬರ್ ಇಲ್ಲ. ಐ ವಿಲ್ ವೆರಿಫೈ ಇನ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕೊಂಡ್ರೆ.
Yes.
In the meanwhile, government also let them verify deputy commissioner.
Yes, Mr. You secure that information, what has happened? Resolution passed by that municipality.
Municipality. ಯಾಕಂದ್ರೆ ಅವ್ರು ಕಳ್ಸಿರ್ತಾರೆ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕೋದು.
This matter next week.
Passed over matter, serial number 4, Chetan AC. Serial number 6, Mahesh Kiran Shetty as for petitioner, Omkara KB. Serial number 6, Mahesh Kiran Shetty.
Lordship, advocate for respondent, this is a transfer matter after, it's a divorce matter.
You are appearing for Omkar KAB.
No, Sujata and petition. Apologies, Your Lordship.
Mahesh Kiran Shetty. Serial number 25, Hanumantappa B for petitioner, H. Devendrappa.
Sorry, my lord, the petitioner, my lord. Regarding it. Deviation of the plan, my lord. The order passed by the second respondent were under challenge before the honorable.
Confirmation order.
My lord, the honorable KT has dismissed the appeal and upheld the order of the second respondent. And then that petition under challenge before this honorable court, my lord. But in reality, there is no any deviation at all. the petitioner's late father, A. Hanimegowda, had obtained the CITPSO the license from the, in the year 1965 for a first floor, the ground floor, my lord. And thereafter, of the expansion of the family, obtained additional license from the BBMP in the year 2009. But after constructing of the building, they come to know that there is a deviation. But to what extent the deviation is not mentioned by the second respondent.
Where is that permission which is taken for second and third floor?
Mail matters, condition. The page number, my lord, 28, the KT's order, my lord. The 10th line, my lord, is.
Yes.
ಈ ಬಗ್ಗೆ ಎದುರುದಾರರು ದಿನಾಂಕ 3/8/2009 LP ನಂಬರ್ 10/29 ಇನಕ್ಷೆ ಅನುಮೋದನೆಯನ್ನು ಮಂಜೂರು ಮಾಡುತ್ತಾರೆ. ಆ ಪ್ರಕಾರ ಮೊದಲನೇ ಅಂತಸ್ತು ಮತ್ತು ಎರಡನೇ ಅಂತಸ್ತಿನ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. ನೆಲ ಅಂತಸ್ತನ್ನೇ ದುರಸ್ತಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸಕಾಲದಲ್ಲಿ ಮೊದಲನೇ ಮತ್ತು ಎರಡನೇ ಅಂತಸ್ತಿನ ಕಟ್ಟಡವನ್ನು ಪೂರ್ಣಗೊಳಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಮೇಲ್ಮನಿದಾರರು ನೆಲ ಅಂತಸ್ತಿನಲ್ಲಿ 2 ಕಾರುಗಳ ನಿಲುಗಡೆಗಾಗಿ ಶೆಡ್ ಕಟ್ಟುವ ಅರ್ಹತೆ ಹೊಂದಿರುತ್ತಾರೆ. ಆ ಪ್ರಕಾರ ನೆಲ ಅಂತಸ್ತಿನಲ್ಲಿ ಮೇಲ್ಮನಿದಾರರು 2 ಕಾರ್ ಶೆಡ್ಗಳನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. ಅವುಗಳಿಗೆ ಗೋಡೆ ಕಟ್ಟಿ ಬಾಗಿಲನ್ನು ಇಡಲಾಗಿದೆ. ಅವುಗಳನ್ನು ಮೇಲ್ಮನಿದಾರರ ಕುಟುಂಬದ ಸದಸ್ಯರು ಉಪಯೋಗಿಸುತ್ತಿದ್ದಾರೆ. ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಶೆಡ್ಗಳನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಟ್ಟಿರುವುದಿಲ್ಲ. ಆದರೆ ಎರಡನೇ ಎದುರುದಾರರು 29/11/2010 KMC ಕಾಯ್ದೆ 321 ಅಡಿಯಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ಆದೇಶವನ್ನು ಮಾಡಿ ಕಾರ್ ಶೆಡ್ಗಳನ್ನು ಕಟ್ಟಿ ಅವನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಪಯೋಗಿಸುತ್ತಿದ್ದೀರಿ ಎಂದು ಏಕೆ ಒಡೆದು ಹಾಕಬಾರದು ಎನ್ನುವ ಬಗ್ಗೆ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿತ್ತು. ಸದರಿ ನೋಟಿಸ್ಗೆ ದಿನಾಂಕ 6/12/2010 ಮೇಲ್ಮನಿದಾರರು ಜವಾಬು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ಜವಾಬನ್ನು ಸರಿಯಾಗಿ ಪರಿಗಣಿಸದೆ ಎರಡನೇ ಎದುರುದಾರರು 17/10/2011 KMC ಕಾಯ್ದೆ 321(3) ಅಡಿಯಲ್ಲಿ ಸ್ಥಿರೀಕರಣದ ಆದೇಶವನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸದರಿ ಸ್ಥಿರೀಕರಣದ ಆದೇಶ ಈ ಕೆಳಕಂಡ ಕಾರಣಗಳಿಂದ ಉಚಿತವಾಗತಕ್ಕದ್ದಲ್ಲ. ಪಾಯಿಂಟ್ ನಂಬರ್ 2 ಮಿನಿಟ್ ಇಟ್ ಇಸ್ ವೆರಿ ಸ್ಥಿರೀಕರಣದ ಆದೇಶದಲ್ಲಿ ಎಷ್ಟು ಶೇಕಡಾವಾರು ವ್ಯತಿರಿಕ್ತವಾಗಿ ಕಟ್ಟಲಾಗಿದೆ ಎನ್ನುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟಪಡಿಸುವುದಿಲ್ಲ. These are the findings of the Honorable KT.
This is your argument. Finding will be come to that page 30.
Read madam.
You read that ಅಂಶ 1.
Read madam. ಮೇಲ್ಮನವಿದಾರರು ಬೆಂಗಳೂರು ಜಯನಗರ 5ನೇ ಬ್ಲಾಕ್ 11ನೇ A ಮೈನಲ್ಲಿರುವ ಸ್ವತ್ತಿನ ನಂಬರು 575ಕ್ಕೆ ಮಾಲೀಕರಾಗಿ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತಾರೆ. ಸದರಿ ಸ್ವತ್ತು ಮೇಲ್ಮನಿದಾರರಿಗೆ CITB ಇಂದ 1950 ಮಂಜೂರಾಗಿರುತ್ತದೆ. ನಂತರ ಅದು BDA ಆಗಿ ಪರಿವರ್ತನೆಗೊಂಡಿರುತ್ತದೆ. BDA ರವರು 29/3/1985 ಮೇಲ್ಮನಿದಾರರಿಗೆ ಸದರಿ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ಕ್ರಯ ಪತ್ರ ಬರೆದು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ನಂತರ ಮೇಲ್ಮನಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿರುತ್ತದೆ. ಮೇಲ್ಮನಿದಾರರೇ ಕಂದಾಯ ಪಾವತಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಈ ಬಗ್ಗೆ ದಾಖಲೆಯನ್ನು ಪಡಿಸಿದೆ. 1990 ಸದರಿ ಸ್ವತ್ತು ಮೇಲ್ಮನಿದಾರರಿಗೆ ಮಂಜೂರಾದ ನಂತರ ಅನುಮತಿ ಪಡೆದುಕೊಂಡು ನೆಲ ಅಂತಸ್ತಿನ ಮನೆಯನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ಮನೆಯಲ್ಲಿ ವಾಸವಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ 1995 ಮಂಜೂರಾಗಿರುವ ನಕ್ಷೆ ಅನುಮೋದನೆಯ ನಕಲನ್ನು ಹಾಜರುಪಡಿಸಿದೆ. ಮೇಲ್ಮನಿದಾರರ ಮತ್ತು ಆತನ ಮಕ್ಕಳು ಒಟ್ಟು ಕುಟುಂಬದ ಇದ್ದುದರಿಂದ ಕುಟುಂಬ ಸದಸ್ಯರ ವಾಸ ಮಾಡುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಹೆಚ್ಚುವರಿ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡು 1 ಮತ್ತು 2ನೇ ಅಂತಸ್ತಿನ ಮನೆಯನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಎದುರುದಾರರು ದಿನಾಂಕ 3/8/2009 LP ನಂಬರ್ 10/29/10 ನಕ್ಷೆ ಅನುಮೋದನೆ ಮಂಜೂರು ಮಾಡಿರುತ್ತಾರೆ. ಆ ಪ್ರಕಾರ ಮೊದಲನೇ ಅಂತಸ್ತು ಮತ್ತು ಎರಡನೇ ಅಂತಸ್ತಿನ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. ನೆಲ ಅಂತಸ್ತನ್ನೇ ದುರಸ್ತಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸಕಾಲದಲ್ಲಿ ಮೊದಲನೇ ಮತ್ತು ಎರಡನೇ ಅಂತಸ್ತಿನ ಕಟ್ಟಡವನ್ನು ಪೂರ್ಣಗೊಳಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಮೇಲ್ಮನಿದಾರರು ನೆಲ ಅಂತಸ್ತಿನಲ್ಲಿ 2 ಕಾರುಗಳ ನಿಲುಗಡೆಗಾಗಿ ಶೆಡ್ ಕಟ್ಟುವ ಅರ್ಹತೆ ಹೊಂದಿರುತ್ತಾರೆ. ಆ ಪ್ರಕಾರ ನೆಲ ಅಂತಸ್ತಿನಲ್ಲಿ ಮೇಲ್ಮನಿದಾರರು 2
para 9.
ಎದುರುದಾರರಿಂದ ಪಡೆದುಕೊಂಡಿರುವ ಕಟ್ಟಡವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಮೇಲ್ಮನಿದಾರರು ಪ್ರಸ್ತುತ ಸ್ವತ್ತಿಗೆ ಮಾಲೀಕರಾಗಿ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತಾರೆ. ಅವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಅವರೇ ಕಂದಾಯ ಪಾವತಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಹಾಜರುಪಡಿಸಿರುವ ಕಂದಾಯ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬರುತ್ತದೆ ಸದರಿ ಸ್ವತ್ತು BDA ರವರಿಂದ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ 1965 ಮೇಲ್ಮನಿದಾರರು CITB ಇಂದ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡು ನೆಲ ಅಂತಸ್ತನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. ದಿನಾಂಕ 3/8/2009 ಎದುರುದಾರರಿಂದ ಹೆಚ್ಚುವರಿ ನಕ್ಷೆ ಅನುಮೋದನೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಮೊದಲನೇ ಅಂತಸ್ತು ಮತ್ತು ಎರಡನೇ ಅಂತಸ್ತಿನ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಲು ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಆದರೆ ಹೆಚ್ಚುವರಿ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪ್ರಕಾರ ಕಟ್ಟಡ ಕಟ್ಟಿಲ್ಲ ಎಂದು ಮೇಲ್ಮನಿದಾರರು ಮೇಲ್ಮನವಿ ತಿಳಿಸಿರುತ್ತಾರೆ. 1995 ಪಡೆದುಕೊಂಡ ನಕ್ಷೆ ಅನುಮೋದನೆಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಾರ್ ಪಾರ್ಕಿಂಗ್ಗೆ ಅನುಮತಿ ನೀಡಿರುವುದಿಲ್ಲ. ಆದರೆ ಅಧಿಕೃತವಾಗಿ 2 ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಶೆಡ್ಗಳನ್ನು ಕಟ್ಟಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ಹಾಜರುಪಡಿಸಿರುವ ಫೋಟೋಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬರುತ್ತದೆ. ಕಾರ್ ಪಾರ್ಕಿಂಗಿಗೆ ಹಾಜರುಪಡಿಸಿರುವ 2 ನಕ್ಷೆ ಅನುಮತಿಗಳಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲ ಎಂದು ಅವುಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬರುತ್ತದೆ. ಆದರೆ 2 ಕಾರ್ ಶೆಡ್ಗಳನ್ನು ಕಟ್ಟಿಕೊಂಡಿರುತ್ತೇನೆ ಎಂದು ಮೇಲ್ಮನೆದಾರರು ಮೇಲ್ಮನೆಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮಂಜೂರಾದ ನಕ್ಷೆಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಕಾರ್ ಶೆಡ್ಗಳನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ ಎಂದು ಎದುರುದಾರರಿಂದ ಪಡೆದುಕೊಂಡಿರುವ ಕಡತವನ್ನು ಫೋಟೋಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಎದುರುದಾರರು ಮಾಡಿರುವ ಆದೇಶ ಕಾನೂನಿನ ಪ್ರಕಾರ ಸರಿ ಇದೆ. ಸದರಿ ಆದೇಶದಲ್ಲಿ ಮಾನ್ಯ
They have built up a car parking.
Car shed, 2 car
Other
park
1 and 2, they have taken a permission.
from BDA.
ಅದ್ರ ನೀವೇ ಹೇಳಿದಿರಲ್ಲ. ಈ 1900-3/8/2009 ಎದುರುದಾರರಿಂದ ಹೆಚ್ಚುವರಿ ನಕ್ಷೆ ಅನುಮೋದನೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಮೊದಲನೇ ಅಂತಸ್ತು ಮತ್ತು ಎರಡನೇ ಅಂತಸ್ತು ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. Only thing is they have put up in a car shed. Car parking ಅನುಮತಿ
2 car sheds.
ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ where is that permission for car shed, Mr.?
ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಓನ್ಲಿ ಕಾರ್ ಶೆಡ್ಡಿಂಗ್ ಅಷ್ಟೇ.
ನೀವು ಇಲ್ಲಿ ನಕ್ಷೆ ಹಾಕಿದಿರಲ್ಲ, where is that permission for car shed?
ಅದು ಇಟ್ ಈಸ್ 1965 ಲೈಸೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್ ಪರ್ಮಿಷನ್.
1965 ಇಲ್ವಾ ಲೈಸೆನ್ಸ್? ಕಾರ್ ಶೆಡ್ ಪರ್ಮಿಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ
Car parking, nowadays car parking is to be inside only.
ಯಾವ್ದು ಅನೆಕ್ಷ ಡಿ ಏನ್ ಮಿಸ್ಟರ್ ಅಮ್ಮ?
Next D, my lord, it is the
Is that
plan regarding that is.
it's a sketch showing details of deviation observed against sanction plan. What are the deviations?
Showing the details of the deviation observed against the sanction
Sanction
plan. ಎಷ್ಟಿದೆ? ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ ಇದ್ರಲ್ಲಿ?
No, that is being deviated. What? Sketch is showing the deviated portion.
ಈಗ ನೀವು ಮಾಡಿರೋ ಸ್ಕೆಚ್ ಆಯ್ತು.
Yes, well, it must be along with the confirmation order, I believe.
ಎಷ್ಟಿದೆ deviation? Is it
If
permitted?
my lordship sees page number 24. As per sanction, ground floor should have been 172.19. But they have constructed 185.57. So total deviated portion is 13.38, comes around 7%.
7.77%.
Other first floor, second floor, deviations are not shown, and there are some setback deviation.
Only that ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಮಾತ್ರ deviation ಇದೆ.
There are setbacks deviation, front and left side there is deviation in the setbacks. The second tabular form in that page.
Setback ಏನಿದೆ?
Setback 2.40 as per plan they have to left, but they have left only 0.90. So 1.50 is the deviation.
1.5. ಅದೇನು 62.50% ಏನದು?
It's up in percentage, it's showing 62. Front and left there is setback deviation.
Yes, Mr. You see that how much deviation is there?
ಅಲ್ಲ, as per their sketch, not 62.60% ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, 62.50%.
Deviation, see that, see, ground floor, it's okay, 7.77% ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಇದಾಯ್ತು. ನೀವು ಸೆಟ್ ಬ್ಯಾಕ್ ಅಲ್ಲೇ ಪೂರ್ತಿ ಎಲ್ಲ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಅದು ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಬಗ್ಗೆ.
That is that violation. You demolish it. Demolish that car parking.
No, it is not affecting other owner.
No, it is affecting others or not is not the question. Question is that they have sanctioned the plan, you cannot violate that.
Any fresh notice to the petitioner, then fresh regarding.
ನೀವು ನೋಟಿಸ್ ಕೊಟ್ಟೆ ಮಾಡಿರೋದು, ಇನ್ನೇನ್ question ಅದು?
Regarding, it is 1965 sketch regarding it. 1965 ಅಲ್ಲಿ, because
ಅವರು
please.
see, they have inspected the spot and find out. ನಿಮ್ ಸ್ಕೆಚ್ ಬೇಡ ಅವ್ರಿಗೆ, ಈಗ ಸೈಟ್ ಇಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಇದ್ರೆ ಇಷ್ಟು ಸೆಟ್ ಬ್ಯಾಕ್ ಅನ್ನೋದು ಬೈಲಾಸ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ, ಅದ್ರ ಮೇಲ್ಗಡೆ ಅವ್ರು ಮಾಡ್ತಾರೆ.
But it is not affecting other persons or neighbors of the property, my lord. It is within the parameters of safety measures, my lord.
You can't say that, Mr. Totally ನಾವು ಅದು ಬೇರೆಯವ್ರಿಗೆ ಎಫೆಕ್ಟ್ ಆಗೋದಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲ. Is law has to be implemented, Mr.
Left them so they conduct the fresh inquiry regarding the fresh notice to the petitioners.
Why the inquiry which is conducted, any defect, it is proper.
2011 ಆಗಿತ್ತು ಸ್ವಾಮಿ, that is ಸ್ವಾಮಿ, order of the honorable KT, it is sponsored in the year
Front to
2011.
back to right to left to deviation ಇದೆ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ನೀವು ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಏನೋ ಕಟ್ಟಿದ್ದೀರಾ ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. You ask
Left
your
to-
client to
please.
remove, huh?
Please, man, left to the court without recording it, not to any cause damage to the property of the cars parking of the petitioner.
No, I will confirm that they will do in terms of that, they will not damage that property. I will confirm that order passed by the KT. Right. This petition. Petitioner. Called in question. Order passed by Karnataka Appellate Tribunal in appeal number 59 of 2021, 2011, dated 23/1/2016, Annex G, thereby order passed by second respondent dated 17/1/2011 by the Annex G under section 321 of TMC Act has been confirmed. The facts of the case are that petitioner is the owner of the property bearing number 575 11th Main Road, 5th Block, Jayanagara, coming within the jurisdiction of BBMP. Petitioner, after obtaining the building plan, petitioner father,
Late father, my lord, Hanimegoda.
yes, petitioner father, after obtaining the building license for construction of the residential building in said property, first ground floor ಗೆ 1965 ಅಲ್ಲ?
Please, man.
Yes.
Please, man.
Huh?
Awesome. And the
And
65.
in the 1965
Please,
forest,
please.
ground floor. Thereafter, 2009 has obtained the plan sanction for construction of first and second floor. Pursuant to that plan approved by the authority, they have put up in a construction. The respondent authority without proper out according to the plan. Respondent, second respondent has initiated the proceedings under section 321 of Karnataka Municipalities Act. Passed an order on 17/11/2011. Directing the petitioner to remove that deviation made by the petitioner within 7 days. By the annexure C, being agreed by the same, petitioner has filed an appeal before Karnataka Appellate Tribunal under section 443A of KMC Act. Appellate Tribunal by order dated 23 January 2016 has dismissed that appeal by the annexure G. Being agreed by the same, the petitioner is before this court. So and so learned counsel appearing for the petitioner has contended that petitioner has constructed that residential building after obtaining that necessary plan from the competent authority. In the year 1965, petitioner father has obtained the plan for construction of the ground floor. Pursuant to the function plan, they have put up in a construction. He further contended that first and second floor has been constructed. So father in the 1965 for construction of the ground floor. And second floor has been constructed after obtaining that necessary, after obtaining the approval of the plan from the competent authority on 3/8/2009. There is no any violation of building plan. The authority, without conducting a proper inspection, has passed an impugn order. Hence, he sought for allowing the petition. So and so learned counsel appearing for respondent corporation has contended that the authority, after conducting an inspection, after conducting a survey, find that petitioner has deviated the building plan. After giving in a notice, the impugn order has been, after giving in a notice, order under section 321 of the Act has been issued. The appellate authority has rightly confirmed the same, hence he sought for dismissal of the petition. Heard the learned counsel for the parties. Feroz, red paper. Petitioner is the owner of the property, municipal number 575, new number 36/16, measuring 2,400 square feet, situated at 11th Main Road, 5th Block, Jayanagara. In the year 1965, petitioner father has constructed the ground floor after obtaining necessary plan from the competent authority. Thereafter, on 3/8/2009, petitioner has obtained the plan approval for construction of first and second floor. And they have constructed ground floor, first and second floor. Yen complaint ಮೇಲೆ enquiry ಮಾಡಿದ್ರಾ ಅಥವಾ ಏನು?
Normally, on the basis of complaint only, VVMP initiate action. On the basis of complaint, it must have been done. Neighbor's complaint must have been there.
On the basis of a complaint issued by the corporation, they have initiated a proceedings under section 321 of MC Act. After 321, 1 is the provisional order.
321, 1 and 2 is a provisional order. 320,
Conducting in a spot inspection. And after and conducting a spot inspection and survey. After giving in a notice to the petitioner. After conducting in a survey. Petitioner has passed the authority has passed an provisional order under 321
In-
class 1 and 2
1 and
stating that petitioner has deviated the building plan approved by the authority. The percentage of deviation is also deviation against the function plan is pointed out by conducting in a survey as per Annex E. It is very clear from Annexure E. Petitioner has violated that, deviated sanction plan while constructing ground floor. The authority, after giving in a notice, after conducting an inquiry as provided under section 321 of KMC Act, has passed a confirmation order by the Annexure C dated 17/1/2011. The appellate authority has rightly confirmed that order passed by second respondent under section 321(3) of the Act. There is no error or illegalities in order passed by the respondents.
My lord, one submission, my lord. As per so the new act, there is a fresh notice may be called to the petitioner, then after to conduct the inquiry, because as per the old act 1965, only 5.25, but as per the new act, so maybe fresh notice to the petitioner, sir.
Where is that? What is that new act?
BBMP Act, residential portion के 50% deviation they can levy the penalty and regularization. ಹಿಂದೆ KMC Act ಅಲ್ಲಿ only 5% ಮಾತ್ರ regularization provision ಇರ್ತಿತ್ತು. ಈ BBMP Act ಅಲ್ಲಿ ಏನಾಗಿದೆ ನಾನ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಗೆ 25%, ರೆಸಿಡೆನ್ಷಿಯಲ್ ಗೆ 50% ಅಂತ 241A ನಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಇದೆ.
let's relate to Akrama Sakrama regularization.
ಅಲ್ಲ
is
ಅಕ್ರಮ
subject to
ಸಕ್ರಮ
the-
act done and it is in pending before the Supreme Court. Leaving that apart, ಅಕ್ರಮ ಸಕ್ರಮ ಬಿಟ್ಬಿಟ್ರುವೆ the BBMP Act of 2020 provides for that. So any construction which has taken place prior to the Karnataka Town and Country Planning Act, Amended Act 2013, the building is constructed, that can be regularized up to 50% ಅಂತಾರೆ.
ಅದೆಲ್ಲ 1919 ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಇದೆಯಾ ಅದರಲ್ಲಿ?
In the old act, it was 2009, before 2009. In the new act, it's 2013. But both relates to parametria, same the Akrama Sakrama regularization. If the Supreme Court tomorrow says that you can do it, then it can be.
That is pending before the Supreme Court.
ಅಕ್ರಮ ಸಕ್ರಮ ಆಕ್ಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ನಾನ್ ಕೇಳ್ತೇವೆ ಅಕ್ರಮ ಸಕ್ರಮ ಆಕ್ಟ್ ಬೇಡ.
ಎಲ್ಲಿದೆ BBMP Act ಅಲ್ಲಿ ನಿಮಗೆ?
241.
It's 249, my lordship. It's same as 321A. Under the old act, it's 321 capital A. which is same as in the new act, it's 249.
50% ಇಲ್ಲ 5% ಇತ್ತು.
ಅದು 5% building bylaws ಅಲ್ಲಿ ಇತ್ತು.
ಇದು ಇದರಲ್ಲಿ residential ಗೆ 50%.
If my lordship sees the 321A, capital A of the old act, KMC Act, it is same as 249, it's my lord.
40.
Under the old act, it's 320.
Yes, my lord.
Under the new act, 249.
Regularization certain unlawful building.
Yes, my lord. Where the building is built according to the.
ಇದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Same.
ಇದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದ್ರಿ.
In the old act, it's same.
This has been challenged before the Supreme Court. Deviation, it has been challenged. Yes.
Subjudice ಇದ್ದಾಗ ಚಾನ್ಸ್ ತಗೊಳ್ಳೋದು. At decide ಆಗೋವರೆಗೂ let them not take legal decide.
No, that.
Because there is an option. If Supreme Court says, they can't restore back the property.
At this stage, dismissed. At this stage, Cabinet Council for petitioner has submitted that in view of new act, the permitted limit of the deviation is
50% in case of residential property,
50% in case of residential property.
25% in case of non-residential.
Cabinet Council for respondent has submitted that issue is pending before the Supreme Court. Liberty is reserved to the petitioner to submit a representation.
Yes.
ಅಲ್ಲ ಅದೇಂಗಾಗತ್ತೆ ಅಲ್ಲಿ ಇದಾಗತ್ತೆ.
Kept in abeyance till disposal of the.
This will be kept in abeyance till the decision of the.
Liberty is always there for them to give a representative. Liberty is always there for them to give a representative.
No, once demolish ಆದ್ಮೇಲೆ they can't restore back the property. ಅವ್ರು demolish ಮಾಡ್ಬಿಟ್ರೆ
ಇವ್ರದ್ದು 50% ಗಿಂತ ಜಾಸ್ತಿ ಆಗುತ್ತಾ deviation?
ಇವ್ರು 7.77 ಇದೆ.
Setback deviation is more. Flow deviation ಇಲ್ಲ. Setback deviations ಇದೆ.
Respondent, under these circumstances, the order passed by respondent under 321 is kept abeyance till the decision of the Supreme Court.
Great, man.
ಇಲ್ಲ ಅಂತಂದ್ರೆ what has happened to the Supreme Court judgment?
It's still, it has not come up again. ma'am.
In all cases, then you have to wait till the Supreme Court judgment.
If the construction is prior to 2013, if the construction is prior to 2013, then we have to wait. Because in the new acts, the year is 2013. Under the old act, it was 2009. So construction prior to that, we can wait.
2013, ಇವೆಲ್ಲ 2013.
For that, it may be applicable. For new after 2013, we need not to wait. There is no scheme for it.
Now that, what are you doing for all these things? There is a complaint for encroachment.
We are taking action, Malaship. There are two things, Malaship. Under the new act, there is a provision for applying a new plan. If you have not taken any plan and you have built up the portions and you have built up the entire building, then you can apply for a new plan. But if you have deviated, then you have to demolish it. Only up to 5% it
No,
can
if,
be realized.
in the Supreme Court that your amendment is upheld, then he is entitled for regularization.
If the construction is prior, then Supreme Court is prior only. Malaship.
then-
For that, they must have given a representation at that point of time.
No,
Many
Act
people have.
2020.
Under the old act, it was there, my lordship. Under the old act, it was there.
Because the new act, he has a benefit.
In the new act also, it's there. Under the old act also is there. In many of the cases, what has happened, even in their reply, or somewhere they have stated that we have deviated. We are seeking the benefit of akrama sakrama in many of the cases. In some cases, nobody has taken that stand, my lords. So, in this particular case also, no stand has been taken. But
Stand, he's taken the stand are not the criteria, but under the act, he has that benefit.
benefit is there up to, if the construction is prior to 2013, they can take.
About that, in the meantime, if you are demolish that, then
Yeah,
you cannot get that benefit.
You cannot.
Then how we are initiating every day, so many cases are coming. How you are balancing that?
Nowadays, all new constructions, my lordship, old constructions, very less number of cases are there.
ಎಲ್ಲ 2013 ಮೇಲೆ ಎಲ್ಲಿದ್ದಾವೆ?
13 ಮೇಲೆ.
2013 ಎಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದ್ದವಕ್ಕಿಂತ ಹಿಂದಿನ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋನ್ ಏನ್ ಮಾಡ್ತೀರಾ?
As if now there's a cases, a lot number of cases are pending, my lordship, on the same issues. Some buildings have been demolished, like not building, deviated portions have been demolished, my lords. But number are very less.
Let us even before 2013.
Yes, ma'am.
It can be implemented only after the decision. Yes.
Serial number 45, V. Srinivas for petitioner, N.R. Jagadishwara.
Petitioner, same Lord. This is also same. But the deviations is not as per my friend's case. It is a little more, Lord. It is annexure A. If your lordship can kindly come to
What is
annexure.
the percentage of deviation?
Lord, it is in the provisional order, it is stated, it is 342, Lord, 236.89%. 236.89%. 236.89%, Lord.
Who is your opponent?
Lord Jagdishwar, he is online, Lord. He is online.
I am for the responding, my lords.
It is permissible under the new this thing act.
Up to
More than that.
more than that, Lord.
Your lordship may kindly turn to the report. Along with
236
my report, I have produced the plan, my lords, at page number 13.
ಎಷ್ಟು percentage?
Along with the report, I have produced the plan, my lords, may kindly look into.
Wait. ಎಷ್ಟು percent ಇದೆ?
My Lord, as per the provisional order, it is 236.89%.
236.
Yes,
It is more than that.
more than
Yes.
that, more than the limit, my Lord. That's why I made a submission on the other day that let them consider my construction as an illegal construction and let them levy penalty, whatever, my Lord, because what had happened is 2011 we have put up the constructions. It is a, my Lord, the shop premises is in existence. The plan obtained was for residential purpose. Now there is a, my Lord, the entire road is a commercial road. Because we were unable to reside, my lord, we have converted it as a shop. Thereafter only this problem started, my lord, because the other neighbor who was competent, he has filed this and.
It started because of that and all. You have done it illegally.
Yes, my lord. So let them, my lord, since it's a shop premises, shop ge there is no plan, my lord. As such, I would, my lord, I will concede to that fact. But shop ge plan ilde irodrinda. Let them consider it as a illegal construction, levy penalty under 240 subclass 8 and
Not permissible. Otherwise, in all cases, everybody will say that impose the penalty and regularize.
Yes.
Government went to the extent of 50% deviation now. Indian 100% ಬಿಡಬೇಕಷ್ಟೇ.
Unauthorized regularize ಮಾಡ್ದಂಗ ಆಗತ್ತೆ.
Deviation. You demolish instead of that, corporation has to demolish because they may demolish and damage the building. You demolish and then we will ask them to verify whether it is in terms of the plan.
now I am 75-year-old, my lord. I don't have anybody's support, my lord. Now at this age, my lord, I cannot even disturb my tenant also because I don't have kids and my kids are residing separately. This is the only income what I am getting, earning out as on today, my lord.
That's the law. You see that without damaging, what extent it can be, this thing can remove.
Brought within the.
If it is brought less than 50%, then that can be said that in subject to the result of the Supreme Court.
Yes.
You do it that less than 50% without damaging the building. Another 50% will say that subject to that they can implement only after that.
My lord, the reason why I cannot bring it within 50% is, my lord, down below there is a shops, my lord. My lord, as per the sanctioned plan, it is a residential house. Now shops are in existence. The main allegation in the report what they have filed as of now, my lord, pursuant to filing of this writ petition, spot inspection was carried out and they have filed a report. And it says that I have constructed a shop and I have let out the same. Now, my lord, to make the shop as a house, I require investment, my lord, to bring it within that one. I don't have that capacity as on today, my lord. I am making a very fair submission to the court
that I am not. Thing is, you are doing that residential purpose converted into that commercial. But actually, my lord, when I obtained, my lord, actually, when I bought the property, as per the earlier 1962 sanctioned plan of the BBMP, it was a shop. I thought of making it as a house and taken the plan. My lord, thereafter I didn't went, my lord, this is, the truth is like this. Thereafter I constructed only the upper floors, left it like that only. But unfortunately, the plan sanctioned, what I've taken the plan is like this. There is no provision under the law that now you can seek for a modification and all. Modified plan togobodu. Modified plan togolake, there is an option, my lord. Before construction, not after construction. After construction, only the modified plan. You verify what extent you can be demolished and yes. See, even shop also, you remove that deviation, then you can later use it as in a shop, you can do it for a commercial. That is in a different dispute. If you are using that residential into the commercial, there they will take a separate action. But deviation is concerned, you have to see that. Yes, much. At the request of counsel for the petitioner, leave this matter of 2 weeks. Much.
A date may kindly fix, my lords. Date may kindly fix.
24. Much.
Oblige minutes.
Serial number 6, Mahesh Kiran Shetty for petitioner, Omkara KB.
Lordship, appearing on behalf of petitioner. Lordship, it is a transfer case. Both the parties have filed for a divorce in Bangalore. And my client, actually, she is residing in Jamkiran. And what happened is she already has a child of 1.
6. You are appearing for whom? You are colleague? Yes, yes, you are. I thought that last occasion also she has appeared in wrong, same matter she said it is not. Yes.
Apology,
Yes, yes.
Lordship. So, Lordship, my client has 1.5 years old child, and she is not able to travel from all the way from Jamkiran to Bangalore. It is difficult for her as she is not earning.
Yes.
So, kindly.
She is residing with whom?
With her family, Lordship.
Parents.
Yes, Lordship.
What is that boy or girl, baby?
It's a girl child, Lordship.
Girl child. What is that age?
She is 1.5 year, Lordship.
1.5 year. Yes.
So, as they are not able to travel, Lordship, we would like.
You have filed any case?
Sorry, Lordship?
You have filed any case for maintenance or this thing?
Lordship, if I'm not wrong, they have during the wedding, my client has given certain amount of gold and watch and money to the groom. So we are asking that back, Your Lordship.
No, see, husband has filed in a case for what? Divorce or restitution of conjugal right?
For divorce, Your Lordship.
Divorce. You have filed any case for maintenance?
Yes, Your Lordship.
Before which court?
Jamkiran, Your Lordship.
Where is that annexure? Have you produced that?
It's not produced.
What is that
Criminal miss number 220 bar
276.
276 bar 2020. 276 of 2020.
2020 in which
Pending before the JMFC Jamkandi. It's a 125 CRPC post.
In that he is appearing.
He has appeared, he has filed his objections.
So learned counsel appearing for petitioner wife has contended that after the matrimonial dispute, she started living with her parents and 1.5 year old, 1.5 year age daughter. She has filed an criminal miscellaneous 276 of 2020 for maintenance in Jamkandi. In that case, Respondent husband is appear through their counsel and prosecuting the case. Respondent husband has filed divorce petition in MC number 1546 of 2020 before First Additional Principal Judge, Bangalore. From Jamkhandi to Bangalore, what is the distance?
Lordship, not sure about it.
Jamkhandi, what is the distance? Jamkhandi ಎಲ್ಲಿ ಬರುತ್ತೆ? ಬಾಗಲಕೋಟೆ. ಬಾಗಲಕೋಟೆ ಅಂತ ಅಂದ್ರೆ Bangalore almost 500 kilometers ಇರುತ್ತೆ. From Jamkhandi to Bagalkot, from Jamkhandi to Bangalore, it is more than 500 kilometers. It is difficult for the petitioner to come to Bangalore for prosecuting the case. Hence, he sought for allowing that CP. When the matter is called in the morning session, none appear for the respondent. It was passed over even afternoon session, none appear for the respondent. Heard the learned counsel for the petitioner. Petitioner is a legally wedded wife of respondent. Their marriage was solemnized on 25/1/2019. After that matrimonial dispute, petitioner was started living with her parents and 1.5-year-old child in Jamkhandi. He has also filed a criminal miscellaneous 276 of 2020 before Civil Judge Jamkhandi for maintenance. Respondent husband has filed a divorce petition in the MC number 1546 of 2020 before First Additional Principal Judge, Family Court, Bangalore. It is about more than 500 kilometers from Jamkhandi to Bangalore. It is difficult for the petitioner to travel from Jamkhandi to Bangalore for prosecuting the case. Under these circumstances, the above civil appeal required to be allowed. Accordingly, CP is allowed. MC number 1546 2020 pending on the file of First Additional Principal Judge, Family Court at Bangalore is withdrawn and same is transferred to Senior Civil Judge at Jamkhandi. On 543.
Final hearing matter, cell number 67, V. Ravi Prakash for petitioner, TP Vivekananda.
Yes, Mr. What is this?
ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿತ್ತು, ತಾವೇ ರೀಕಾಲ್ ಮಾಡಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್.
ನಾನೇ ಮಾಡಿದ್ದೀನಿ.
ಹೌದು, ಈಗ ಪುನಃ
What is this, Mr.
ಇದರಲ್ಲಿ ದಿ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸೈಟ್ ವಾಸ್ ಆಕ್ಷನ್. The petitioner was the successful bidder. That sale deed and possession certificates were issued. That later he approached the authority with a contention that with a complaint that the land where the site in question was formed belongs to a private individual and he is obstructing his possession and therefore we have to allot an alternate site. But then we have conducted an inspection. We found that the land where the site is formed, which was denotified by the government, and this site is at the end of the layout formed by authority and the land which was denotified.
Yes.
At the time of putting the site for auction, this was not actually measured and report was submitted. There was a mistake on our part in putting the site into auction. And then the matter was placed before the board to consider his request. The board took a decision that insofar as auction sites are concerned, there are no rules for allotment of an alternate site. And therefore, to refund the amount along with interest. That decision of the board has been communicated to the petitioner to seek for refund of the amount.
So why can't you give it in that some other area? It is your fault.
But there is a fault, undoubtedly there is a fault on our part.
You are saying that if it is done it in that proper layout, then it is your fault to allot that in that private person's property.
No, my lord, the land was acquired, sites were farmed. And my lord, in the interregnum, the landowner approached the government has denotified. It is at the center of the denotified land and the layout of the authority. In fact, this honorable court in identical circumstances, insofar as BDA case is concerned, has held. Insofar as auction sites are concerned, there are no rules for allotment of alternate site. The allotment of alternate site could be made if it is a regular allotment to the general public pursuant to a notification. It is under that circumstances, my lord, we offered him the refund of the amount along with interest. But I do consider, my lord, there is a
Like if
there
this
is
there. The case where in the action. No, why that in the action site there is there is no provision for alternate this thing.
my lord, in the rules, my lord, insofar as allotment rules are concerned, there is a specific rule, Rule 16 of the allotments of sites rules. Karnataka Urban Development Authorities rules, site allotment rules 1991. Rule 16.
1991.
1991 rules minutes. ಕನ್ನಡದಲ್ಲಿದೆ. ಕರ್ನಾಟಕ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನಿವೇಶನಗಳ ಹಂಚಿಕೆ ನಿಯಮ 1991. ಈ ಬುಕ್ ಅಲ್ಲಿ ಪೇಜ್ 125 ಇದೆ ಸರ್.
Yes.
Rule 16 minutes. This rule applies to the regular allotments. ನ್ಯಾಯಾಲಯ ತಡೆಯಾಜ್ಞೆ ಅಥವಾ ಇತರ ಯಾವುದೇ ಕಾರಣದಿಂದಾಗಿ
ಹಂಚಬಹುದು.
Similar rule is not there in the Karnataka Urban Development Authorities Disposal of Corner and Sites Rules 1991. It is Karnataka Urban Development Authorities Disposal of Corner Sites and Commercial Sites Rules 1991.
ಎಷ್ಟು ಪೇಜ್ ನಂಬರ್ ಅದು?
ಅದು ಪೇಜ್ 107 ಅಲ್ಲಿ ಇದೆ ಇದ್ರಲ್ಲಿ ನನ್ನ ಬುಕ್ ಅಲ್ಲಿ. 107 minutes.
Yes. Now that in any sites, in the new layout, you have to be allotted as per the rules only.
Insofar as the allotment rules are.
Allotment has to be done in according to the rules only. You cannot deviate that. In one of the site can be allotted to that this petitioner.
But that's what this honorable court has said. Insofar as auction sites are concerned, our rule apply ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿ.
Otherwise, what has happened? Why that action has been cancelled? Is it the fault of the?
ಅದರಲ್ಲೂ fault of the authority ನೇ.
Fault of the authority.
ಹೌದೌದು. ಇಲ್ಲಿ para 14 ಅಲ್ಲಿ lordship may kindly come to about 10 to 12 lines. Para 14 minutes, about 12 lines from the top. The next question, lordship's got the next question. Therefore, we see no ground to interfere with the order of the learned single judge in this regard. The next question required to be considered is whether the appellant was entitled for an alternative site. No doubt the BDA initially allotted an alternative site to the appellant. However, the appellant seems to have not accepted the allotment of that alternative site on the ground that it was a smaller in size than the auction site, and it was adjacent to slum and sought for allotment of another alternative site. It is at that stage the BDA issued impugned endorsement to the appellant to the effect that she is not entitled for an alternate site. Admittedly, the appellant was a successful bidder in respect of site number 83 in public auction. The said public auction was conducted as per the provisions of BDA so and so rules 1984. There is no dispute that the site in question is a corner site. As per the provisions of the aforesaid rules, the corner site in any layout formed by the BDA are required to be disposed of in public auction. The said rules do not provide for allotment of an alternative site in lieu of auction site for any reason. There is no provision in that regard in the said rules. The only provision providing for alternative site is contained in Rule 11A of VDA Allotment of Sites Rules 1984. The said rule is applicable only when possession of the site allotted as per that rules could not be handed over to the allottee for any reason stated therein. In the instant case, the site number 83 was not allotted to the appellant as per the Bangalore Development Authority Allotment of Sites rules as held earlier.
Now that there is no other option, she has to seek for no, you can go for damages also.
Adal
You can
madbodu.
Sue for damages.
My suggestion would be, he has been put to hardship undoubtedly. But in addition to the interest, your lordship may grant him some compensation because of the fault committed by our officers. Lordship may grant them some cost or damage.
Further, cost can be imposed.
Cause your lordship may impose cost recoverable from the officers.
Yes, unless he has to prove what is the damages cost, we cannot.
Your lordship may
We can
impose some cost and direct the authority to recover it from the officer who has put up the file for auction
Yes.
without ascertaining the availability or.
Of that property. Where is he then?
ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಇದೇ ರೀತಿ ಆಗಿದೆ ಲಾಸ್ಟ್ ಮೇ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್ ಮಿಲಟ್ಸ್ ಒಂದು 5-6 ಸಲ ಇದೇ ರೀತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ, ಬರೋದಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು, ರೀಕಾಲ್ ಆಗಿದೆ, ಇವತ್ತು ಇಲ್ಲ.
ಮತ್ತೆ ಅದನ್ನೇ ಮಾಡ್ತಾರ ಅವ್ರಿಗೆ. Who is that Ravi Kumar? There is no representation on behalf of so and so. There is no representation behalf of petitioner. The matter is called out, noticing that court has assured that there is no evidence in the prosecution proceedings. When the matter is called twice, none appear for the petitioner. Read this matter tomorrow at the top of the list under the caption for dismissal. All verbal.
Serial number 68, 69 adjourned. Serial number 70, Onkara Murthy Ji for petitioner, Yogesh D. Nayak.
Yes, respond number 26 time. Government advocate ಆಗಿದ್ದಾರೆ ಯೋಗೀಶ್
The Nayak R2.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Government advocate ಅವರು.
ಹೌದು ನೆಕ್ಸ್ಟ್ ವೀಕ್
The planning authority.
ಇದ್ದಾರೆ ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
What is that?
I have applied for plan, Your Honor. The respondent number 2 has issued endorsement stating that he has to execute relinquishment deed in respect of the property which is margin land. The property is abutting to the national highway. ಇದನ್ನ ಪರಿತ್ಯಾಜನ ಪುಕ್ಕಟ್ಟೆಯಾಗಿ ಪರಿತ್ಯಾಜನ ಪತ್ರ ಬರ್ಕೊಟ್ಟು ಕೊಟ್ಟಲ್ಲಿ ನಾವು ಮಾಡ್ತೀವಿ ಅಂತ. ಅದು we have filed this petition at the time of admission, Your Honor. It was stayed and permitted to go on with issue plan with remaining ಏನಿದೆ ಮಾರ್ಜಿನ್ ಬಿಟ್ಟು ಮಾಡಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ರಿಟ್ ಅಪೀಲ್ ವಾಸ್ ಪೆಂಡಿಂಗ್ ಅಂತ ಕಾರಣಕ್ಕೆ that writ appeal was disposed of by the division. ಅದು similar matter was before.
ಅಲ್ಲ ಅದರಲ್ಲಿ ರೆಗ್ಯುಲೇಷನ್ ಇರ್ಲಿಲ್ಲ, ಇದರಲ್ಲಿ ರೆಗ್ಯುಲೇಷನ್ ಇದೆ ಅಂತೆ.
Was passed. Some similar order passed by the single bench was preferred the writ appeal. Before the division bench, it was dismissed, upholding the order of the single bench. Similar cases were by holding that Article 13A of the Constitution, the private person cannot be deprived. Without acquisition, he cannot demand for relinquishment deed ಅಂತ ಹೇಳಿ it was dismissed. On that ground, in order sheet, it is very specifically list this matter after disposal of.
Planning authority report. No, that now they have issued an order on the basis of the circular. A circular pass ಆಗಿದೆಯಲ್ಲ ಇನ್ನೇನ್ ಬಂತು? ಯಾರು? ಮೊದ್ಲು ಇರ್ಲಿಲ್ವಾ? Point that circular issued by the appellant and the endorsement issued based upon the circular on the ground that without authority of law. Really the regulation.
Single judge reported judgment ಇದೆ ಸ್ವಾಮಿ. Similar cases were passed. ಅದು pass.
Zoning regulation ಅಲ್ಲಿ ಇದೆಯಾ ಅಥವಾ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ ಇದೆಯಾ? ರೆಗ್ಯುಲೇಷನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು. ಎಲ್ಲಿದೆ ರೆಗ್ಯುಲೇಷನ್ ಅಲ್ಲಿ? ಅಪ್ರೂವಲ್ ಆಫ್ ನಾಟ್ 15 ಪಾಯಿಂಟ್. If a road, if any road proposed in the master plan shall be incorporated in the plan, it shall be handed over to the authority free of cost.
No, man.
How can this be?
It is not law, sir.
ಅದು ಅಲ್ಲಿದೆ ಆ ಪಾಯಿಂಟ್ ಪರ್ ಸಿಂಗಲ್ ಪ್ಲಾಟ್ಗೂ ಬರುತ್ತೆ.
ಅಲ್ಲ ಆಯ್ತು. In terms of this has to be go. How can that you say that free of cost in public private property?
ಅಲ್ಲ ಅದು ರೆಗ್ಯುಲೇಷನ್ ಇನ್ನೂ ಇದಾಗಿಲ್ಲ, ಪ್ಯಾಸ್ ಆಗಿಲ್ಲ.
ರೆಗ್ಯುಲೇಷನ್ ಯಾವ್ದು ಮಾಡಿದ್ರಿ?
ಅದು ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಅಲ್ಲೇ ಇದೆ, 2031 ವರೆಗೂ ಇದೆ.
What is this circular challenged in this petition?
We have not challenged any circular. We have
ಈ ಕೇಸಲ್ಲಿ ಯಾವ್ದು?
ಆ ಕೇಸಲ್ಲಿ
ಎಲ್ ಇದೆ ನೋಟಿಸ್.
ಇಲ್ಲಿ
ಅದು ಮಹದೇವಪುರ BBMP ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ. BBMP ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿ. BBMP as Town and Country Planning Act.
include that circular wide annex dated issued by the respondent and constable and the derogative of the. Which is that circular annexure E dated 29/2/2016. ಈ ಪಿಟಿಷನ್ ಅನ್ನು ಸರ್ಕ್ಯುಲರ್ ಪಾಸ್ ಮಾಡಿದ್ರಲ್ಲ ಅದೆಲ್ಲಿದೆ ರೀ?
ಅದು ಇಲ್ಲ ಸರ್.
ಆ ಸರ್ಕ್ಯುಲರ್ ತಗೊಳ್ಳಿ. ಈ ಸರ್ಕ್ಯುಲರ್ is in terms of this thing.
Yes.
On the basis of the circular, if you are issuing a town planning this thing, then it has to go. If circular goes, it will not survive, Mr. Maybe that is the circular.
Another reported judgment I have passed, Your Honor. Justice Hemant Chandangaud judgment. There are similar 4-5 cases were clubbed together and disposed of.
Already circular challenge ಮಾಡಿದಾರೆ. ಅದು ಯಾವ ಸರ್ಕ್ಯುಲರ್ ತಗೊಳ್ಳಿ?
29/2/16 issued by second respondent by annexure A. And so annexure B.
ಆ ಸರ್ಕ್ಯುಲರ್ ಯಾವ್ದು ತೆಗೀರಿ?
Urban Development Department. So ಇವ್ರದೇ ಅದು ಆ ಕಾಪಿನ.
If that is the government circular, on that basis this planning authority has issued this, then
they have not stated on what basis they are issuing this endorsement annexure L Your Honor.
Zonal regulation issue ಮಾಡಿದಾರಲ್ರಿ? ಆ ಸರ್ಕ್ಯುಲರ್ ತಗೊಳ್ರಿ. ವಾಟ್ ಇಸ್ ದ ಸರ್ಕ್ಯುಲರ್?
ತಗೋತ
next week.
Next week.
What is the circular which is passed by this court?
Please.
If similar, then is this matter next Friday? Yes.
7.
Friday. 4.